Good morning. Happy Wednesday, everyone. I am alternate juror, and thank you for joining us on my channel this morning. It's about freaking time you show up, Gabby. We waited all night for you. Good morning. Not from New England. Good morning, Mum. I'm working on that. Good to see you here. And Stormy, good morning. I think I might be competing with your weather today, Stormy. It's supposed to be 63 here. Don't rain on my parade, please. So, good news. When I was getting the court feed up to see what was going on today, we are doing closing arguments. Bad news. Lollipop's doing closing that I saw, so yay. Yippee. I saw that. Yes, I saw you in the comments. I don't do a lot of night times, but yesterday was a short day for court, and I thought, let's get this out of the way so we're caught up for today. I was hoping today was going to go just like it is, and I'm hoping that we get verdict today because that works out perfectly for me, not that they care. Yes, no more tooth Capone. I'm so sorry. But good news, when I was trying to figure out where to start to see where the audio started, I paused it in a special spot for you, Gabby. Oh, well, I hope everything is okay. I understand. I don't know if you're like me. I get claustrophobic in those things, so I gotta take stuff so I don't freak out. That is a horrible, horrible case. Sad. Another parenting fail. So I just I haven't watched anything on it because Carmen's pretty much kept me up to date on what is happening down there, especially since it was so close to her house. Like, okay. So, well, Mom, I'm gonna get it. I hope there's nothing seriously wrong and the MRI shows nothing or answers your questions because I've been on I've been on that side where something's wrong, they can't find it. And then, people are like, "Oh, I hope all your tests come out okay." And you're like, "Nope, I don't. I need them. I need to know. I need to know there's something wrong with me and I need to know." So, if you're on that side of it, I understand that too. You just need an answer. I can do D. I can do it. And you're welcome. I told Carmen you were going to be very upset that she was here. And you were not. All right, guys. Let's get the show on the road. And then I'm thinking if obviously they're going to go, well, I assume the jury will get it. And since they did not play his police interrogation, I think I may do that maybe while we're waiting. Gabby, I know you've watched it. The ones that I have found are like 20 minutes long, like around a half hour, maybe a little less. Is that the one you have seen, or do I need to look for something else? Because be honest, I have not had a whole lot of spare time this week to start looking at stuff. Alrighty. Hey, we got closed captionings today. All right, Gabby, this is paused just for you because for some reason it takes the jury forever to get in here. So, as usual, let me know if the sound is okay or not. And here we go. A half an hour long, 30 minutes. Okay. I think I then the ones that Court TV has up is his the one I need. I share with you. Dang it, I forget that all the time. Hope you can hear it. There we go. Let me back it up. I had all this set, and then I went to hit my sound at the for the beginning, and it would not show up. It wouldn't play. So I had to exit out of everything, come back, and then I just missed Gabby's spot. Try this again. There you go, Gabby. Because we are children. Oh, and no, he's not there in case anybody was thinking he might be.
Please be seated. Good morning, ladies and gentlemen. I just have a preliminary matter I want to address with you. The court is aware that posters and other items related to this case have been placed in areas around the courthouse. I remind you that your verdict in this case must be based exclusively on the evidence that is presented in this case. That includes evidence presented during the trial and what you saw on The View. Just as you were instructed that you could not consider any
Good.
television, newspaper, online, or other coverage of this case, you may not use or consider any information that may be posted or found outside the courthouse, other than on The View, in coming to your verdict.
Apparently nothing.
Attorney Smith, does the defense wish to present any evidence?
No, Your Honor, defense rests.
All right.
Yeah, I
Ladies and
wonder what they
gentlemen,
are.
the defense has now rested, so it is time for closing arguments. Counsel, whenever you're ready.
Thank you.
All right. We all know she speaks slowly, so I'm going to speed her up. If it's too fast, let me know. But I know we all want to get past her as fast as possible.
Wake up, baby girl. Baby girl, wake up. Those were the words that Kayla used to describe how Adam approached his child when he discovered that she was dead. Kayla used words that were the truth sometimes to fill in her lies. Baby girl, wake up. Those words were from a real memory of how Adam was speaking when he discovered his daughter, looking peacefully asleep, would never wake up again. Wake up, baby girl. But she didn't. Those words were the truth surrounded by Kayla's lie. Adam is no innocent. Shortly after he discovered that his baby girl would not wake up again, he began a series of decisions, terrible and
Good
criminal
morning, Roseanne.
decisions. He made them with a very misguided belief that he had to make them to keep his family from being ripped apart. And he made those decisions with the input and influence of his wife, Kayla. He did make those choices, and you will hold him accountable for those choices. He and Kayla hid, moved, lied, and manipulated Harmony's body after her death. It's unforgivable. They lied about her whereabouts after her death, and it's unforgivable. But he did not do this to hide that he killed Harmony, because he did not kill Harmony. He did this because he believed it would keep his family together. He did not witness tamper with Kayla. She was an instigator and equal partner. He did not influence her. She influenced him. And most importantly, he did not kill his daughter. He did not kill his baby girl. When Kayla was facing charges not related to Harmony's death, theft, and 2 charges of receiving stolen property, charges that could send her to prison for over a decade. And then, by her own actions, she was facing 2 more charges for perjury, for lying about Harmony's death. And she was subject to 2 more felonies. These felonies, 3.5 to 7 each, potential, stacked in prison. 3.5 to 7 plus 3.5 to 7 plus
Is this too fast?
receiving stolen property times 2 plus theft. So Kayla decided to lie about Harmony's death, to accuse Adam of something that he did not do, to get herself out of her own problems. And what better way than to pick an accusation that had already been made? Adam was already arrested and in jail for an allegation of striking Harmony, a tale that he had struck her and given her black eyes. That became the groundwork for Kayla's own lies. She had to lie because the truth would point to her. And her lies were accepted because Adam had already been accused of causing Kayla black eyes. Her lie was easily accepted until you look past the horror of what she has said and past the emotion that would be the reaction when you heard her say it. When you look with a critical eye at those lies, you're going to see that they're lies intertwined with truth. Wake up, baby girl. The allegation that Adam beat his child for days and then on December 7th for hours is crazy. And I'm going to briefly go over that and the craziness of it as it got worse and worse with the telling. She told you a horrific story of Adam screaming and yelling and beating Harmony because when they woke up to go to the clinic, she had peed in the car, screaming and yelling at the Colonial Village at an hour that people might be going to work for rush hour, at a time that they should not have been there, and they were essentially squatting and not wanting to be noticed. Screaming and yelling and punching her in the head. And then they got to the methadone clinic, which was about 10 minutes away, at around 7 o'clock in the morning. Kayla got her dose at 7:04 when the clinic was open for people to get their doses. Her horrific story continued with Adam beating Harmony, she says, when he got out of the clinic. He at 7:09. She said he smelled urine and said, "Again, Harmony? Why don't you tell us?" And he began yelling and hitting her right in the head, right there in front of the clinic. And you know that one time that they had done something wrong outside the clinic, they got told on. One time, she told you, they had left the kids in the car and gone into the clinic together with no one watching the kids, and they got told on. And they had to change their habit and go in one at a time so that somebody would always be out with the children. That would have been noticed outside the clinic at 7 a.m. when people are going in for their doses. She continued that horrific tale because she said, after witnessing these beatings, she said, "I'm hungry. Let's go to Burger King." And Adam drove to Burger King. And on the way, she said Harmony was crying a lot and making a weird noise. And Adam got really angry and kept punching her and said, "Shut the fuck up." And then he hit her at the traffic lights, 2, maybe 3 traffic lights, she said, coming over the seat and pummeling her in the back. Not in secret, not hidden, broad daylight on a busy street with busy traffic stopped at a stoplight. And then she said she put up an arm to stop him. She doesn't mention any effort to try and stop those horrific acts beforehand. No effort on her part. But somehow or other at this point, she thinks this is enough and puts her arm up. And what does she say he does? He gives her a look, a crazy look, like evil. It's the first time she had seen that. And she felt like he might hit her. So she didn't do anything. He scared her, she said. And then as he's punching her, she says, driving into the Burger King parking lot, and you were there, wide open parking lot, says that he's punching her and says, I felt something different. I think I really hurt her this time. She said he was scared. So what does he do when he's scared? He drives up, he orders the food that Kayla wanted. She was hungry. So he ordered a croissant, 3. She said, 1 for Adam, 1 for Kayla, and 1 for Harmony, she said, and some hash browns. He drove up, paid the cashier, either got his card or the cash back, whatever. Reached in as the cashier is handing him the food, takes the money, hands it to her, and drives away. He was scared, she said. And this is what he does, she says. Her story is crazy. And what were the boys doing when this is happening to her sister over and over again? They might have been sleeping. No, they were not screaming as they drove up to the cashier to get the food. They might have been sleeping. She doesn't remember. They didn't react much. They were quiet. They didn't cry much. She continues on at the Colonial Village. She thinks at first maybe they ate at the Burger King.
Me
But
too.
with more questioning, nope, yep, she was refreshed. They went back to the Colonial Village and she decided to feed the kids. And she said that she took a little bit out of a little piece off of the food and she fed Declan. She said Declan was the middle. She would have to put the food in his mouth, but no, she didn't look back. She just sort of reached back and put it in his mouth. And she took another piece and she would give Seamus also. She didn't have to look. She didn't look back. She didn't see anything back there. And then Harmony's croissant, she just sort of put it back there for Harmony, she said. Didn't look back. She was scared to look back. And then also with that, because she remembered clearly, she didn't have to look back for Declan because he was in the middle and she could just reach right there and put it into his mouth without looking. But then she was reminded that Seamus's car seat was in the middle. Seamus had been in the middle of that accident that was on the 29th. And she had previously said that Seamus was in the middle when she talked to the police and that Harmony was leaning against her brother and that Harmony had a blanket on her lap and that she put a piece of croissant for Harmony on that blanket. She didn't remember this. She made this up. She made it up from feeding the kids when they did go to Burger King. She made it up with some sense of reality. We would go to Burger King and we'd go back and I'd feed them and I'd give them pieces in the back. But she had to intersperse her lies to show that she would not have known the condition that Harmony was in. She then goes to Mr. Bordero, to get some drugs. She didn't remember that she was the one that went up, but she was refreshed.
Oh, sorry. Just trying to move
She was
those,
shown her previous transcript.
which I
She not
didn't.
only told the police she went up to buy drugs, but the reason that she went up was that Tony might front her the money because he'd never said no to her. She remembered it at one point, but tried to deny it here.
His name's Tooth.
And she claimed
Oh,
that they didn't stay long and they went, she didn't know where, somewhere. We had to do something. I don't remember what. And when they left, they got to an intersection and the car broke down. And that's when they discovered Harmony was dead in the middle of that broken down in that intersection. Wake up, baby girl. Baby girl, wake up. This horrific story, and they didn't know until that intersection. That story is crazy. But then her story even got worse. When I started questioning her about some of those little facts, and you remembered how she would respond to me, think about Kayla. As you think about what she said, think about watching her testify. I brought out that she had originally said that Adam had struck Harmony 10 to 15 times at 2 to 3 a.m. in the morning. She said, yeah, that was true. That's when it started. Okay. And then he woke up to go to the clinic and Harmony peed again. No. He made her sit. Oh, she didn't remember if it was peeing or pooping. Sorry to use that word, but I'm just not going to use a different one. She couldn't remember
But you'll
which it
F-bomb?
was, but he made her sit in it all night, she said. And then, did she pee again when you woke up to go to the clinic? Yes, she said. Then when I asked her about that, had somebody cleaned up the offensive poop or pee from 2 or 3 o'clock in the morning? No, it just smelled of urine when we woke up, she said. She also said that when they were going to the clinic, Harmony didn't have any injuries that she knew of. But beating 10 to 15 times, 2 to 3 in the morning, and no sign? No. That was a lie. It cannot happen. It could not be. And it makes no sense. It doesn't because it's a lie. All that horror, all that chaos at the intersection. Oh my God. What could be worse? It's an absolute nightmare. You have done something to a child over and over again for hours, and you get stuck in the intersection, and somehow or other, you've got to make sure that nobody sees that child. Wake up, baby girl. Baby girl, wake up. The description, well, I'll get to the description of the intersection later. No, I won't. What she described at that intersection was that Adam said, wake up, Kayla, wake up, baby girl. Baby girl, wake up. Put his hand on her heart, and she came over, checked the neck, checked her pulse. And then at some point, somebody is waving cars around, sometimes her, sometimes Adam. She says she's not seeking help. She's not seeking assistance. She's not doing anything but grabbing the children and grabbing the clothes, while Adam grabs a duffel bag from the trunk filled with clothes and puts her in the bag filled with clothes from the trunk. When I asked about that, she said the trunk was actually locked already, but it didn't open. So we had to go through that little hole when you take that center down in the back of a car, and you can reach through, you can put your skis through. She said we went through that and pulled out the duffel bag. That's how we got it. That would be over Harmony's body in a busy intersection, taking off a car seat and taking a child or two out of the car and reaching in and getting a duffel bag full of clothes and pulling it through that little area. There's a reason why she made up that story, and I'll get to it in a little bit. But let me talk to you about waving cars around and not asking for help. Kayla was admittedly part of the cover-up, but she wasn't covering up to save a man who beat a child in a cold, continuous, torturous, escalating over days beating. If that had been going on, Kayla would have instinctually protected that child. By all accounts, Harmony was a loving, lovely child. Instinct would have caused you to protect that child, even if you were given an evil look. And even if you were afraid at some point when you had the opportunity, it's not only a child in the car. It's not only your stepchild. There are 2 of your children in the car, exposed to an absolute horror that no one would allow their children to be held for. She didn't go to, when she went to Videro, she didn't ask for help. She didn't ask for call 911. When they were at that intersection, she didn't collapse with, oh my God, it's up, finally. She's waving cars around. She's cool. She's calm. She's getting the kids out. Why? Because that wasn't when Harmony died. In that intersection, Harmony was already dead, and a plan had already been set for what to do. They had talked for hours before that intersection. They knew what they were going to do. And that car breaking down at that intersection certainly put ruin those plans. But Harmony was already in the trunk. She was already wrapped and in the trunk. and they were going somewhere to take care of what to do with her body. And that is why Adam was able to go into the trunk and grab the duffel bag and walk away without anybody at that intersection seeing Harmony's body, seeing Harmony sitting, lying, being maneuvered around in the car, because she wasn't. She was in the trunk. Kayla was able to keep her cool because they had been discussing this for hours, what they were going to do. And this problem at the intersection, we can get over it. Keep your cool. She said, Adam said, what do we do? And she said, let's go to Badero's. And they grabbed what they could and they went to Badero's. Not only, if that had occurred, would she have instinctually protected Harmony and her children when she could. Any love that she had for Adam would have died. No one can maintain love for a man who would do something like that over and over again in front of your kids, in front of you, and give you that evil look that made you feel threatened. There are reasons that women stand by their men, but not for that. No one would stand by for that. Why did Kayla stand by Adam? Because that never happened. Adam was not a threat to her.
Please speaking.
Because of
Oh my
Harmony's death.
gosh.
Adam was her protector. Wake up, baby girl. True memory that Adam spoke when he unexpectedly discovered that Harmony was unnaturally appearing to be asleep. He didn't even know she was dead. Wake up, baby girl. And she never woke again.
You get a drink of water because you're pissing everybody off.
I'm going to review with you more of Kayla's lies and some of her reluctant truths that I was able to pull out of her and other of the real evidence. But before I do that, I want you to keep something common sense in the forefront as you evaluate it. I don't think anyone but they can understand the decisions that they made to hide and lie about Harmony's death. But I want you to consider which is more likely, that a mother of her own children and a caretaker by all accounts, a loving and joyful girl she is taking care of, would stand by and protect a man who brutally beat time and time again in front of her and her own children, that beautiful child. Or would a father who failed in his responsibility to care for that beautiful child, would he stand by his wife because he did not know how Harmony died? Kayla and Adam's relationship struggled on after Harmony's death. But till the end, Kayla appeared to put Harmony's death behind her. She just wanted her man. Adam, however, lost his grip several times after he and Kayla prepared Harmony's body to finally dispose of it, to wash off decomposition and debris in the shower and put her in another bag. He tried to commit suicide. Kayla held him together. You've got to be here for me and the kids. She held him together, but he lost it several more times. He would have bouts of paranoia, think Kayla was trying to poison him, think that there were cameras. He was losing it several times after that. Thought she was cheating, lashed out on her, punched her a couple of times. And then in March of 2021, St. Patrick's Day, she recalled, he had another bout of paranoia.
He clearly hit her. We saw the pictures.
Why do we have this picture of Kayla with black eyes? Because Kayla took this picture, this selfie, and she sent it to her family. This was something she would not tolerate. You did this to me. Adam was arrested. Adam went to jail. She got a restraining order. She moved. No. She was not an isolated, independent woman. She wasn't trapped. She had friends. She had family. She was connected to services. Tara, her friend, helped her out of the apartment to a safe place. Adam was arrested. She filed a restraining order. It showed in her actions when Adam, in one of those fits of paranoia, lashed out at her. She was not going to tolerate this. She told you, was her own woman. Adam's behavior did not control her. And by the way, Tara Hilbert, the one that told you that Adam gave her the lie about Harmony that Kayla and Adam had developed, said Harmony was with her mother. She also told you that that came up in the context of a conversation where he was missing Harmony. Rebecca Maines didn't say he hated Harmony because she reminded him of her mother, Crystal. He was missing Harmony. He was feeling bad.
No,
And he moved on quickly when she said, well,
said.
where is Harmony? And he said, oh, she's with her mother. And the conversation moved on. He had worked 4 years visiting Harmony, 4 years to get her. He knew who Harmony was. He wanted Harmony in his home where he lived, in his grandmother's home, where he lived with his grandmother and other uncles and other family members. He wanted her a part of his home. For Kayla, there was no indication she even thought about Harmony until this investigation became public. She wanted Adam and she didn't want anyone else. She was not relieved when Adam was out of her life. She was not haunted by memories of a brutal assault to an innocent child. She was not haunted by those memories because those memories didn't exist. Her story was a lie. There are no haunting images, except for the ones that might be in your head based on what she has said. But those images do not exist in reality. He had not done that. She told you that after he was in rehab in the summer of 2021, they communicated about getting back together. But then Adam was cheating on her then, and she wasn't happy. Thing, she called Kelsey. She wanted Adam back. She was not haunted. But Adam, in the fall, was out of her life. He was in Maine with Kelsey and her relatives. When the investigation opened up and the police tried to come and talk to her, did she say, I'm so sorry? Let me tell you what happened to Harmony. It was terrible. I've held it inside, but it's time you know the truth. Adam is a brute. No, she said, Adam. She calls Adam. She knows where he is. Get back here. I'm not dealing with this alone because they were partners in this conspiracy. Get back here. And he came. But he came with his girlfriend, much to Kayla's chagrin. You know, one thing that was odd now, she didn't rely on the police to protect her. She said Adam threatened her that if she ever told on him, he would have Kevin kill her. Kevin, you met Kevin, the uncle. The uncle that Adam and he were not particularly getting along with because he had failed to pay some bills he had promised to pay and put them in pretty dire straits. The uncle that after a visit and that argument, about a week later, calls DCYF, the authorities on him. That uncle that you met was no threat to Kayla. That was another lie that she told to try and figure out why, give a reason why she would not have come forward before. She was free. I want to talk about another lie that you watched developed.
What are you doing down there?
The fuel grinder. What's that all about? Why was that such a big deal here? The fuel grinder. Well, I'm going to remind you how that developed to be an issue in this case. And it did develop over time. You heard that when Kayla first started giving her story to the police, she was talking about the shower, what happened at Union Avenue, and she was asked, well, were tools used? And she said, no, only the scissors. She had cut off the hoodie. Adam had taken the leggings, and they put Harmony in the shower. She didn't see or know of any tools. And then on questioning, she sort of saw where it was going, and she said, well, when he came out of the bathroom, he wanted to put her in pieces, but couldn't do it. About 8 months later, when she was asked about Adam using tools again, now this 8 months from the couple of June conversations in 2021, she gets her deal. She has obligations under that deal. She has to keep cooperating or it could all fall apart. 8 months later, they want to talk to her some more. She's in prison. She's brought out to them. And they have pictures of tools. I assumed that their picture was the same size as these, but they had this picture of the fuel grinder. they had a picture of a circular saw, and they had, did I do it backwards? Yes. A picture of a circular saw and a picture of the miter saw. And they asked her about it. And they said, any tools used? And she said, not that I know of. And then they said, they showed her this picture of the grinder. And she said, I had never seen that. I never seen it. They showed her this and she did not recognize it as anything that she had ever seen before. They showed her the circular saw and she said, that looks the most like an old tool that Adam had under the counter in a big box. Looks most like it. Miter saw, no, that wasn't it. This looked most like it. And then you learned that she went in March to talk to them. Now, after that March thing, she's going to talk to the state to prepare for her testimony here in front of you. She had 3 of those sessions. They were very long sessions. And they brought a picture, this picture. They brought this picture to that meeting, this picture of a tool that she had never seen before. They brought it to that meeting. And we don't have recordings of that meeting, but she came out of that meeting having given a story of, well, when we were at her mother's house in December, he was interested in his mother's fuel grinder. She just bought one. It was still in the box. And he saw that and she recognized this tool as the tool on the box. And she said Adam was holding it and said, this would be a good tool to use to help get rid of the body. This is December, 2 months ago that she said this. After almost a year before, she said, I've never seen anything like that. I've never seen that. Question first, why would you bring that? Oh, and you don't have to rely on Kayla's word that that was the photo, because eventually from Detective Rahill, we did get out that the third photograph at that March interview where she said, I didn't see that. It wasn't actually identified in the interview, but they had taken this photograph for the purpose of seeing about that Home Depot purchase. Do you remember the Home Depot purchase? The police were following up on Lime and looking at Lime purchases from Home Depot, and they discovered a purchase of Lime, the fuel grinder, an extra battery, an extra blade. They wanted to connect that to Adam because it was right around the time that there was a call for service at the shower. That would be evidence that you put together that could prove something. So they want to make that connection. And Detective Rahill said, we specifically brought this photograph to see if you could identify it to make that connection for us, because they had found that out maybe 6 months before. Shouldn't make that connection for them, but they didn't give up. So they brought that photograph, not the police. This was during her prep session. That photograph was brought to the prep session, and she understood this was important. And there was no truth about this other than she had never seen it before, but she made up a story about Adam wanting to take it from her mother. That story has so many levels for you to understand Kayla. Oh, and one more thing about that. I asked her, why didn't you tell anybody before 2 months ago about Adam wanting to steal or take your mother's fuel grinder? Why did you wait 2 years to say this, or a year, or whatever? And she said, nobody asked me. She also said, I think in that story that fuel grinder would, NutriBlender would have been good too. I asked Detective Rahill about whether she was asked about that, and sure enough, as the transcript showed, do you remember him buying anything or stealing anything or any other types of tools like power tools or anything? And she said, no, she was asked about other tools. Then you heard from her mother, the supposed owner of that fuel grinder. Nope, never had a fuel grinder. I have plenty of tools. I do some working stuff. I know fuel grinder. I never bought this. Certainly didn't have a new box with a fuel grinder in it at all. Independent verification that her story was a lie. But it also illustrates something really important. One, she can gauge what seems to be important to the police or to the state, and she can create a lie to try and give them something that they seem to be looking for. She doesn't understand its importance, but if they're going to show her this thing again after she said she never saw it, it must be important. And especially with, and I don't know if it was all blown up for her when she signed it. The other thing it shows you is that she would make up a lie to put the man she says is her best friend most of the time, to put him in that bad of a light, that in December, he's contemplating stealing her mother's power tool, her mother's fuel grinder, contemplating what he can do with it to Harmony's body. Evil, deranged. That is what it says about the story that she can make up to put him in that bad of a light. Was she capable of making up the lie that Adam brutally beat his daughter to death? Yes. Watching that lie unfold tells you, yes, she is capable and she did do it. Talk about the lime. You put lime on your lawn, you learned, to raise the pH. A lawn where rain happens, dogs play, children play, people play. That is not something that you use to dissolve a body, to make a body decompose. Where she got the lime from, I don't know. Maybe she mistook something that she heard on a crime show. I have no idea. But lime, to decompose a body, nobody has told you that it would do that. And in fact, you learned that it was used to bring pH up on your lawn. And you learned that it wasn't an unusual purchase in the wintertime because Home Depot had sold lime. 33 purchases, I think, within that 2-month period. And we're not even going to other stores to look and see how many things of lime stole. I don't know where this lime thing came from. What they did was take Harmony's decomposing body that had been decomposing for 2 months, take her clothes off, put her in the tub, ran the water, and those fluids from decomposition flowed out. Other debris from decomposition flowed out. And it did stop up the drain. But it wasn't lime, and it wasn't dismemberment. And even Kayla says she didn't see any sign of dismemberment. She saw Adam take Harmony's body and put it in these great big trash bags filled with lime. And we heard how big the bathroom was. That was a lie. Now, let's look about the lie she told about Harmony being hidden from view the whole time in the car, because she said the beating happened almost right away. From the time, and I confirmed it, you're saying from the time of eviction to the time that Harmony died, you're saying that she was beaten all the time. Yep. Hidden the whole time. Yep. And you pretty much stayed at Colonial Village the whole time without moving. Yep. And then you learn. And she said we did this so that we could hide Harmony's black eyes and bruises. Whenever anybody would come around, we would put a blanket over her. Nobody saw her. So then you learn that Harmony was not hidden. Harmony was not hidden from the Garcias. You heard Courtney Garcia. They had met up with the Montgomerys. They had given the Montgomerys food. They knew the Montgomerys were living in the car. And Courtney told you, we offered to let them stay overnight at our place. And Adam was interested. Kayla was not. Do you remember that? Kayla was not. Adam was interested. Adam was not hiding Harmony from view. Harmony wasn't hidden from Christina Lubin. Kayla's mom testified. Kayla had admitted that she went to her mom's the day after Thanksgiving. And she went there to see if her mom could put them up. And her mom couldn't because of the landlord. And eventually I was able to pull out that she was there. While she was there, she got cleaned up. She cleaned up the kids. They ate. They caught up with each other. Christina told you that she was catching up with her grandchildren, even her step-grandchildren. that she remembered sitting on the couch interacting with Harmony. She was a lovely child, kind of quiet, polite, but she looked healthy. And she noticed Harmony. She noticed her hair in pigtails. She noticed what she was wearing and the glasses, and she interacted with Harmony. There were no black eyes. There were no bruises. Harmony looked good. Harmony wasn't hidden from Tabitha Scott on December 29. Tabitha Scott, you remember, the police officer said was in the car during the accident on December 29. She was in the front passenger seat while Kayla was in the back with 3 kids, 2 car seats. And so that when the police officer came, they threw a blanket over Harmony to hide Harmony. Why? Because of black and blue and bruises? No, because they went to Christina Lubin's after that. There were no black and blue. There were no black eyes. They hid Harmony because they had too many kids in the car and Harmony was not restrained and they had just gotten in an accident. Maybe people overlook it, but not when you just had an accident and your child is unrestrained. She wasn't hidden from Tabitha Scott that day. So that's 2 to 3 days after they've been living in the car now. And then another 3 days later, December 2nd, she wasn't hidden then. They were in an accident around the clinic. I think it was around the clinic. Anyway, that same officer responded to that accident and also noted again who was in the car. This time it was only Kayla and Adam in the car. Harmony was not hidden from whoever babysat her. Kayla couldn't remember, couldn't tell you. But it could have been Tabitha, it could have been her mother. She didn't remember, but whoever that babysitter was, Harmony was not hidden from that babysitter. And Harmony wasn't hidden from Anthony Badero. Anthony Badero didn't particularly want them there. And but she said that Anthony walked out every day and Harmony would wave to him. Where did she say this? She said this to the grand jury. She was in the midst of a lie to the grand jury, telling them Harmony on the 30th had gone to her mother's. Adam took her to her mother's. She's lying to the grand jury. She doesn't want to admit anything that is the truth about Harmony once they were evicted. And she sort of slipped. And she said, yeah, well, Anthony Badero, Harmony would wave to him every morning for those 2 weeks into December. And then nobody seemed to catch that that was actually different from the lie that she was telling. Just moved on and she continued on her lie. And she admitted to you when I asked, yep, that was a slip. And yes, that was the truth. No need to lie about that to the grand jury because you didn't want to bring that out in the first place. Then I talked about one of the issues that did come up a lot in the car. 10 days from the time that they were evicted to the time that Harmony was discovered dead. 10 days. And she tried to make it seem like 24/7 they were in that car. 24/7 Harmony was hidden. 24/7 they ate. She would change diapers and they would stay at the Colonial Village. They didn't do anything. Then I started asking more questions. Do you remember that? Well, you change the baby and your toddler. They were both still in diapers. You'd change them and you'd wipe them. But to get them really clean, you would take them to a public restroom or something to wipe them down and clean them up with soap and water. Nope. Didn't happen. Well, they were in diapers. You needed diapers. You're in there for 10 days. You had to have bought diapers. Went to Walmart, the mall? Nope. Well, where did you get your diapers? Gas station, convenience store. Think about the prices at a gas station's convenience store. That's not where they were getting their diapers, your wipes, your extra food. They wouldn't go far, she kept saying. Well, did you clean up the kids at all? Nope. Clean them in the car with wipes. Okay, so you didn't go to the bathroom in the car. Where did you go to the bathroom? Okay, that was a problem for her. And you went to the bathroom when you went to Burger King. Yep. And you go to Burger King a few times. Yep. And you'd go to the bathroom when you went to gas stations or something to pick up your food and stuff. Yep. And you'd go to the bathroom at Badero's because you were right there at the Colonial, right? Yeah. And you said that Harmony didn't always go with you. That means that Harmony went with you sometimes, right? Yeah. And you'd ask her when you went to the bathroom, do you want to go with me, right? Right. So she went to Badero's with you too, right? Yeah. Sometimes. Not all the time. She went in the car a lot. Okay. With work, with prodding, you learn a different story. Harmony is out there. She is not hidden from public. Why does she want to make her? Why does she want to make the story look like that they were 24/7 in a car? Well, you learned why she was working so hard to make that appear. You learned from the state's question that she was aware of opening statement and talked about it with her lawyer. And she said she used the information to prepare her answers to you because the truth pointed to her. That is why she did it. And she knew that these answers were coming and what they would mean. I mean, these questions were coming and what they would mean. So she decided to present a tale of never alone with the kids 24/7 at Colonial. But that tale fell apart as well. Mr. Badero was another person who was caught lying to the grand jury. And he told you he didn't want anything to do with this investigation. He did not want to admit that he had been selling drugs, and he did not want to be part of this investigation at all. He said that no, Harmony never waved to him. He never went down to the car. And then he would get turned around and stuff, and he would tell a different tale. And he said, well, I went down to the car, but not to sell drugs. And maybe I'd wave at the boys, but I didn't see no girl. I didn't see no girl. Okay, what was going on there? Badero, in November 22nd, had just been convicted of another offense involving a drug. One of his prior offenses was distribution. And he also got driving without a license. Without a license. Shortly before, another conviction. He had used Adam as a driver, and Adam had used his car back in September, I think. And he did that because he was going to court, and he certainly didn't want to be driving a car without a license going to court. So he needed a ride. Adam drove in the Sebring, and he brought all the kids with him. And he and Badero and the kids were in the car, and I think somebody else. And we go to after the conviction, he's no less afraid of being caught driving his car without a license, what it might lead to. So he's still in need of a driver. Adam just can't use his Sebring. The family is living in the Sebring. And he said, yeah, Adam drove me in my car sometimes. I don't know how many times. It could have been just once. Reducing him out. But Adam was a driver. Why would he not be driving? He's right there. He's got nothing else to do. He's in need of money. They want drugs. Of course, Adam was driving Badero during that time. Kayla even admits that, yep, Adam drove Badero in Badero's car, but not while we were living in the Sebring.
Sorry, I need a break from her rambling. Did she just say he lied about seeing Harmony because he had just had a conviction in the November prior to when they think that they passed her away? That hasn't, your conviction makes you blind. You can't see if a person's there or not. Oh, and he was your driver, so you can't see if a person's there or not? Or am I just totally spacing out and lost her? Because blame Kayla all you want, but you didn't bring us any, and you don't have to. It's not your place to put on. You don't have to prove your innocence. I got it. I respect it. But if it's so good, and Kayla's so guilty, which I don't think her hands are clean, bring us something. Then you got to have something. And you brought us nothing. Because really, I'm tired of kind of hearing about Kayla. Kayla's got her own issues going on. I think Kayla was involved in some point. I think Kayla also had the crap beat out of her. And so I don't know, but I don't think this blaming Kayla is gonna work. And also, was she insinuating Kayla hit herself in the face with that picture? Because that takes a lot. I can't imagine, because I would hurt. Ugh, I just wish she'd hurry up.
But not while we were living in the Sebring. Why? Because you understand that he was driving Vadero during that time. It is why Vadero is going out in the morning to see Adam, or out daily to see Adam to get his driver. And it is why Kayla is alone with the children in the car. And it is why Adam did not know until he came back that Harmony was dead. Why does Kayla make up these truths or hide and work so hard to make you think a different story? Because the truth leads to her.
Hamilton.
Sorry.
I need some more vodka. I'm gonna need some vodka.
What else supports that Adam was not aware of Harmony's death until he came and shook her? Wake up, baby girl. Let's talk about blood in the car. That was a lie from the beginning. She had told the police, she learned, that while she's claiming that they're all frantically pulling everything together to leave the car that has just broken down at the intersection, she said Adam grabbed a Kleenex, I think, and wiped something down in the car. And they asked about that, and she said he had had blood on his hands from striking Harmony and giving Harmony a bloody nose. She assumed that that's what he was wiping up. And the police officer said, wait a minute, I haven't heard about blood before. What's this? She gets discovery. She knows that they found the car. She knows that there's no blood in the car. So she walks it back. And she says, no, not that day. He was cleaned up. And it was from a bloody nose from an earlier beating a few days before. So no, there was no blood in the car that day. And I started questioning her a little bit more. And so are you saying you saw no blood that day? And she said, well, there was dried blood on Harmony's face. And I said, so there was blood that day? And she said, no, that was from the days before that we talked about. Okay, well, one of the things that you learned about Blue Star is it wouldn't have mattered whether it was a few days before December 7th or December 7th. It wouldn't have mattered if Adam had tried to wipe up blood. Blue Star would have found it. And if you're talking about a beating where somebody is leaning over the seat and getting blood on their hands from a bloody nose, then that also would have left a trail somewhere in the car to be found. There was no blood found by Blue Star. And that stuff you learned can find blood years later, trace minute amounts of blood. And it did in other places, not necessarily anything related to this. Being out in the elements, being out in swinging temperatures may or may not affect the test, but it can. And it did find DNA on the toothbrush. Those trace things last. There was no blood in the car, around Harmony, around the center console, around the steering wheel, anything to be found by Blue Star, because that never happened. Harmony never had a bloody nose on December 7th or on a few days before. And let me talk about this bloody nose. Think about the amount of beating that Kayla tried to describe. 10 to 15 times at 2 to 3 a.m. Waking up in the morning and again, and all of it, face and head. Going to the clinic, coming out and again. Beatings, driving up the road, stoplights, and again and again and again. And then saying something was different this time. I think I heard her. That child would have been as bloody as you can possibly imagine. Why did Kayla slip about the blood and then back it off? There was no blood. Restored was alive. I lose my place often. I'm very sorry. I know that you're being very patient with me. The police took this investigation very, very seriously. You heard it was one of the biggest ones that they've ever conducted. Hours and dedication of the officers can't be denied. And it's something that we all hope for in our police officers when we need them to help us. And the emotions that come with danger to a child, a missing child. Now, at the time when the investigation started, she would have been 7. Pictures. Of that adorable child in the media, pulling in the community. Help us find this girl. The media is all over it. It's the biggest thing, the biggest investigation Manchester police did, and they dedicated time, resources over and over and over again. The emotions had to be running high. And they kept going down wrong paths because people would give them information, whether it was that they wanted to help and they were wrong, whether it was, as Adam horribly put it in his recording, they wanted their 2 minutes of fame, or they wanted something like Kayla, maybe Rebecca Mays, or they just, who knows? They went down those black holes and they were willing to do it because to not go there might mean that they missed something real. They would not regret going down those black holes and doing all those searches. But they can, and they should, and it is right to feel anger. That never should have happened. And Adam and Kayla both could have prevented that from happening. But they lied about her death, and they covered her death up. And you can feel that emotion as well. It is okay. And you can hold Adam accountable for what he did. But emotion equally shows you that Kayla is lying. She continues to lie, and she made a few things up in front of you. Remember how you felt watching her and evaluate that, because that will also show you she's lying because she has something to hide still, because the truth points to her. Adam did some very, very bad things, but he did not kill his daughter. His choices got him where he is today. He has no one but himself to blame. He did what he did, and he got blamed for something he did not do. He put himself in that position. But the evidence that you can rely on remains the evidence in this courtroom and the view, not the emotion, not the horror of what she described, the slow, methodical evaluation of what she described compared to the other evidence. And can you put your trust for one of the most important decisions of your life in Kayla? Because that is what you'd have to do. There's no doubt that the police know that she's a liar. The state knows that she's a liar. She's charged with perjury, lying to the grand jury. She's charged twice, but you watched her as I asked her over and over again, all those questions to the grand jury. This is a lie? Yeah. This is a lie? Yeah. This is a lie. And some of those details that she wove around that lie that she has to admit today.
I was slip up.
Those details were made to make her story seem real. But sometimes she slipped, and the truth came out, like it did when she said Harmony would wave to Tony Badero every day.
Well, who's lying, Badera or
Those emotions,
Kayla? Oh my
recognize
God.
those emotions, and put them aside, like you said that you were able to do. I haven't talked about the second-degree assault case almost at all, I don't think. Kevin made the accusation. You watched. He was in a fight with Adam between Kayla and Kevin. You've heard the fight was about money as well as Kayla's black eye. And what did he say? A week later, maybe 10 days later, he called DCYF. Well, that was investigated. Mr. Atzeros came out. Took a couple of times, but he came out and he talked to Harmony, and he talked to Adam, and he talked to the family, and he checked things out. And he has a series of things that he is checking out to determine if a child is okay, if she's safe, the things to do for his investigation. And as a result of all that, nothing. Until 2 years later, when they're investigating Adam and they want to get him, he's arrested for that second-degree assault charge for what Saros was content with the situation to hold him. So that he was in jail from January 4. Kayla went to jail a couple of days later. You also learned that it was not because, as Rebecca Maines put it, Adam hated Harmony because she reminded him of her mother. Because you heard people like Katie Moran who said the memory bothered him. It bothered him that he had struck her and given her a black eye, struck her glasses and given her a black eye. It bothered him, even after he knew that she was dead, striking Harmony when he found her with her hand over Declan's mouth. It bothered him. And Terry Hebert, he missed Harmony. I do appreciate your patience, and I'm coming to the worst part of the case for me. It's the part where I have to stop, and I can't talk. I've got a little bit more, but I can't wring out more information from you. All the information is in, and I don't get to get up and say, but wait a minute, don't forget this. The state is going to give their closing after me, and I imagine it's going to be very different from what you just heard from me. And I can't get up and say, wait a minute, yes, this person said this, but look at the context of what they said. Look at somebody like Nicole Giles, who said, I saw bruises on Kayla's torso and on her body, and this was at the Fit Shelter before they ever went to Union, and it bothered me. Kayla's friend, Nicole, when she was first talked to at the beginning of the investigation in January of 2022, the month that Kayla and Adam were arrested, she was asked about those sorts of things, and she said, no, I never saw any sign of domestic violence. No, I didn't see anything. No. And then I think it was a year later that she comes out with this story. Everybody was affected by that picture of Harmony. Everybody was affected by the media and all the police efforts that went in to find this child. And some people wanted to contact police, talk to police, and be a part of it. But Nicole Giles, when she was first spoken to, said no. So if the state talks about what Nicole says, I won't be able to get up and say, wait a minute, she didn't say that at first. That was with all the exposure over the year. She made up that story to help her friend Kayla when she was talking neutrally without knowing anything. No DV. Let's talk about Rebecca Maines. She sounded like a pretty decent person, standing up for her wrongs in her past, taking responsibility, understanding it. But boy, did she get her hair up when Jamie, Attorney Brooks, started asking about these things. I've admitted I'm a criminal. Don't go down that road. No, she is still denying her status as a criminal because she
I don't think so.
Anymore. She got her hair up and she said, no. When I talked to them in January of 2023, I wasn't looking to get anything. When I talked to them, I wasn't facing any charges. I was already convicted and in jail. Then you learned, no, she was facing charges. She was facing the charges that are still pending now. And I think she said that she wasn't getting any additional time. There are a lot of reasons that say what they say. With Rebecca, I can't go through the changes. You heard that she had several interviews and not what came out when. But you do know that she did have a reason to want to give something to the police, and what she gave to the police actually didn't fit anything else. Adam worked 4 years to get Harmony. He didn't hate her because she reminded him of Crystal. He loved her and wanted her in the house in his grandmother's house with his family, his immediate family and his bigger family. And he wanted to raise her. Things absolutely fell apart after. But he didn't hate Harmony. And her story about, I don't remember if it was urinating, peeing or pooping, putting in the corner, there's nothing about a car. She's taking bits and pieces of information that is out there in the media and trying to make her own story that's bad about Adam, but maybe it help her in her troubled situation. No, nobody can help me. I'm already doing my parole violation. I was done. Nope. There were 3 sets of charges pending, and she even corrected it. No, there's 4.
And they're
And
still
she's not
pending.
expecting to do any time, I think she said, for those that were out there. Any more time. So, back to the end. You don't get to rely on your emotions.
Or your
I've
notes.
seen a few times, if you've looked at your face, and it's pretty clear that there have been emotional reactions to some of the testimony. There may have been some reactions of anger when you heard Adam's recording, knowing all the time and effort and services and resources and money that was put into this case because of choices that he
Exactly.
made. And he's saying they're wasting taxpayers' money. Yeah, you can get mad at that. But then you stop and you say, okay, that's bad. Let's look at the facts. What is proof beyond a reasonable doubt? Well, remember the recording. I think you all got a video before you came out into the big room to be determined if you're going to be chosen or not. And in that recording, they talked about different tests about what is reasonable doubt. Or what are the different burdens. And one burden was preponderance of the evidence. If the evidence favors one side over the other, that is a test, and that side is the side that gets your verdict. Then there's something very much higher than that, clear and convincing. And it happens in certain types of cases where you have to be clearly convinced that your verdict is correct before you can make it. And then there's something even higher, beyond a reasonable doubt, that you look at all the evidence without the emotion, and you determine, has the state proven to you beyond a reasonable doubt? Do you know, in your heart of hearts, do you know, not that this decision seems to make you feel good, do you know that it is right? Do you know if they have met their burden? If there's any doubt, we're not talking aliens, we're not talking crazy stuff, we are talking about trusting Kayla. If there is a doubt, a reasonable doubt, and there is a reasonable doubt to not trust Kayla with any important decision. If you have that doubt, you must find Adam not guilty. That is your test. And this verdict could be easy, and it could be quick if you rely on emotion, if you rely on anger, if you rely on horror. Because what Adam did, what he did do to Harmony's body after she died is horrific. What he did do by allowing that entire investigation to go for so long can make you very, very angry. And if you decide this case based on your emotions, it can be a quick verdict because none of those emotions will be positive. But if you take the time, you take a breath, and you go through the evidence piece by piece, evaluate, talk to each other. What do you think about her testimony? Some of you will remember things different from others. Talk it out. What was correct? Some of you might remember things different from what I said. I'm human. But talk it out. What is right here? What is there? What is missing? What is crazy? And what is fact? If you do that, this is a very, very difficult case because those emotions are there. If you do that, if you put it aside, you will find that Adam is not guilty of murdering his daughter. He did not do that. And he's not guilty of witness tampering. He didn't influence her testimony at all. It was in her best interest. To lie, to hide, and to make up more lies as time went along because the truth hurts.
All right, ladies and gentlemen, what we're going to do now is we'll take a 15-minute break so that you can use the restroom, have a drink of water. Then we'll come back. It'll be the state's opportunity to make closing arguments to you. Then I anticipate that we'll probably go directly into final instructions. And at that point, once you have the final instructions, we'll select the alternates, the jury foreperson, and it will be time to deliberate. So for now, just take a stretch, have a drink of water, use the restroom, and then we'll bring you back in for the rest of closing arguments and instructions. All rise for the jurors, please.
Also, if you didn't do it, why not say where she's at? be so sad. Tell her where she is. We said the same thing. Oh, Elaine Bredaha. Yeah, her last thing about he just didn't like he didn't do this because of this, this, and this. I'm like, then say where she's at. I'm sorry, I should have done this. You got mad at Kayla. Said Kayla was guilty because Kayla didn't run after the police, and well, neither did he. What's her mom's there? So her mom, you probably have seen. Uh, she's filed. I think it's going to go to court on March 11th. That she's filed to have Harmony declared deceased, and she wants to be made head of her estate because right now both of them are the head of her estate, of Harmony's estate, which I don't know what that is. I don't know what's there that she wants. Let me fast forward here. Nope, it's not. Sorry, Hamilton, it's not Green Giant. And that's the other thing. She's not on trial here. It's a lesser of two evils, and sometimes you got to just take. I don't know who had the information here and who didn't. I don't believe either one of them 100%. Well, I don't know his side because he didn't talk. He didn't have to, but we don't know anything. I haven't seen that, Hamilton, because that lady
Please be seated.
can't with either one of them, but I've seen that it's going around.
Good morning again, everyone. I want to thank you very much for the time that you have spent in this case, for a journey that we told you back before we took the view was going to be a journey that you weren't going to forget. It has been a long couple of weeks. You have been incredibly attentive, and we are very, very appreciative of that. One of the things you heard just a moment ago from Attorney Smith was that she doesn't get the opportunity to come back up here and talk again. That's true. It's called taking turns. It's something that parents teach children. At the beginning, state has to go first, defendant has to go second. At the closings, defendant has to go first, state has to go second. Something very simple that parents teach children. One of the other things that they should teach is if you're going to quote the defendant, if you're going to quote a witness, you have to make sure that you're accurate. So I'll apologize in advance, but let's quote people accurately. I fucked up. Again and again and again. I fucked up. I fucked up. That's what the defendant, his language that he used when he told Travis Beach at the night he got the U-Haul, the night that he disappeared Harmony's body, to whatever place it is now, where he knows it is right now to this day, his words, I fucked up. Not she, not we, not Kayla, I fucked up. Singular, personal, solo. That's the defendant's words. Defense counsel got up here in openings and said that you'd hear evidence that Adam Montgomery was out in the middle of the night doing his business when something happened and Harmony died. If that were so, the defendant never would have told Travis Beach, I fucked up. Adam Montgomery was no loving, caring parent, but an enraged tyrant who had no business being around young Harmony. So together, let's look at the actual evidence, the actual quotes of what you saw and heard as we look at all of the charges that you're going to deliberate on that encapsulate what the defendant did do, and talk about the evidence that you've seen tells you what he committed. And we'll start first with what the defendant's telling you in opening arguments. And now that you can and should find him guilty of abuse of a corpse and falsifying physical evidence. Let's set that as the baseline. Let's start there. Let's see what that actually means before we look at how he committed each one of the crimes charged, not just the ones that he feels are going to distract you from the rest of the nightmare that he's responsible for. Who carried Harmony's body away from the broken down car in the duffel bag, hid her outside of Colonial Village while they stayed in Anthony Badero's blue Audi for 2 nights, put Harmony under a ramp and then in a van and then in this cooler for weeks at Christina Lupin's house, into the CMC bag, into the walk-in cooler at Portland Pie Company, in the fridge, in the freezer, defrosted her in the shower, consolidated her body yet again, brought her to the Econo Lodge, tricked his friend into renting him the U-Haul, and then dumped her body somewhere. All to make sure that the evidence that could have been brought before you that shows that he's responsible for having murdered her would never be found. And he says you can and should find him guilty of those 2 crimes, of abuse of a corpse and falsifying physical evidence for this. He doesn't dispute this. The defense said all of that in their openings, that the defendant did both of these 2 bolded things. Since day 2 of this trial, opening arguments, you should then consider not only all of the testimony, but also all of the corroborating testimony about all of those charges, those 2, falsifying physical and abuse of a corpse, to be true. So let's make it very, very painfully clear from the indictments that you're going to be considering for falsifying physical evidence and abuse of a corpse, making this Harmony fit into this and disappearing her body in the condition that it could not be found for a trial like this one. The evidence was there, and the defendant's counsel professed to you that he's not disputing that, not saying he didn't commit these crimes. So you can check these 2 off the list. And with that, you got to remember the defendant gets no credit for this. He says that you can and should find him guilty of these, but he's not taking responsibility for them. He hasn't admitted anything. He's not taking responsibility for anything that he did. His argument to you is not because he's taking responsibility. It's tactical. He admits what he can't deny. And he denies what he can't afford to admit. He cannot deny each and every single one of these facts that were presented to you. That she died on the 7th, that he brought her in a duffel bag to Colonial Village, stored her under a deck, into a red cooler, in the closet it fit, in the ceiling it built. It's her blood in the ceiling at the Fit Shelter at 177 Lake Ave. And his fingerprints in the ceiling, remember? Left-handed prints in the ceiling. The only other person being poor Mr. Mondrag, the drywall installer. Into the CMC bag to the Portland Pie Company, over to Union Street, consolidating her body even more, bringing her to the Econo Lodge, tricking Travis Beach, and dumping her body so it wouldn't be found. The argument that the defendant is making, he had to make. His concessions don't mean he's taken responsibility for these crimes. It doesn't mean that he's a man of principle or restraint, nor does it give his argument any credibility that because I concede all of this, well, the rest of it must not be true. The whole thing's true. And he's taken responsibility for none of this. So again, baseline, first things first, before we move on, these two charges and the charges that his counsel argued can and should find him guilty of, they're there. That's done. And that's the tip of the iceberg. It's all of the charges, every single one of them has been proven by evidence, not emotion, beyond a reasonable doubt that the defendant is the man who did all of these things. And that's because you saw the evidence. You went on The View. You saw witnesses take this stand and put themselves before you, and you looked them in the eye. And the same common sense that you use every day to tell whether somebody is feeding you a lion, a bull, or not, you used with those witnesses. And because of that, you know that this is true. Because you heard from people like Kevin Montgomery, Nick Ahern, Katie Moran, all talking about the defendant telling them in July about the worst thing he had ever done up until that point. You heard from Kayla, 2 days from Kayla, and all of the other witnesses that corroborate her, how he beat Harmony, this 35-pound child. Remember, Nurse Travers told you that she was measured just back in June before the July incident occurred. 35 pounds, 5 years old, 35 pounds. And you heard from all those witnesses, especially Kayla, about why he beat Harmony to death, when he beat Harmony, and how he beat Harmony. And you vetted what she had to say. And you saw the rest of the injuries that he incurred and all the other evidence presented, corroborated in ways that we'll explore that the witness never could have possibly known there was other evidence out there that supported them. Not when the defendant started telling investigators what happened and how the defendant beat the life out of Harmony. And then beat and manipulated and controlled Kayla afterwards to make sure that she stuck to the story so he would not be held accountable and the evidence of his crimes would not be found. So when he says that you can find him guilty of these, understand that these two are but a part of the whole of his criminality, of how he murdered Harmony as well. When he said this to Travis Beach, it
Got me off
wasn't for
guard.
part of that. It was for the whole of taking Harmony's life and beyond. Don't forget what he's saying that you ought to convict him on as well. That the falsifying physical evidence and that the abuse of corpse are unto themselves evidence of the crime of murder. He's a murderer. That's getting rid of evidence. That's what murderers do. They get rid of evidence that would show others what they've done. They think, no body, no evidence, no conviction. They silence witnesses into staying silent or even perjuring themselves so that the witnesses don't tell others what the murderer did. Because murderers don't want to be held accountable for their actions. Murderers want to get rid of the evidence. They don't mind abusing the body so that the evidence of how their victim was murdered can never be found or used against them. They clean bathrooms with ammonia after they get rid of the evidence, like this defendant did. They clean out the plumbing lines, like this defendant wanted to do. They desecrate and hide the dead so that the body cannot tell the story of how they died to the living. That's what murderers do. That's what the defendant did, because he's a murderer too. Now, let's really start now. Let's start and talk about what he did first to Harmony. Excuse me. Let's talk about what happened in June. Let's talk about the second-degree assault. You will likely never forget Kevin Montgomery's testimony as he was sitting up here, taking his time to thoroughly make sure he answered truthfully and recalled to the best of his recollection. And you are never going to forget how he described Harmony's face when he flew home from Florida, having been there in July, come back on the 22nd to see Harmony in the house in the kitchen. And we saw him relive that moment for us, admitting that he asked her, quote, "Oh my God, Harmony," or "Oh my fucking God, Harmony, what did you do to your face?" End quote. And how he told us Adam answered the question, not Harmony. Adam did. She didn't do anything. I bashed her around the fucking house. That's not disciplining a child. That's not pulling her away or jerking her and not protecting someone else. If it had been, the defendant never would have said this when Kevin asked Harmony what happened, would he? Kevin Montgomery told you he was subpoenaed to be here. He did not want to testify against his nephew. And you saw it on his face that he remembered what the defendant said he did. Not Harmony answering the question. The defendant answered it for her. And remember how Kevin said the defendant said this. Another moment, probably not going to forget. When I asked Kevin about how the defendant said he bashed her around the house, Kevin, you'll recall, said, quote, "like a cocky son of a bitch." Nick Ahern told us he saw that black eye and how bad it was. And what did the defendant do? Lied to him. Nick told us how the defendant told him that it was from an injury from playing soccer. Nick told you he only saw it for what? How many seconds? 4 seconds. Only saw it for 4 seconds. Saw how bad it was. He described it as being pretty intense, that it was concerning to him, and that the defendant let her be outside for all of 4 seconds before the defendant told her to get back inside. And what did Harmony do? She obeyed. Nick saw him walk Harmony right back through the front door and then shut it. And so why did Nick hide Harmony away that day? Because he couldn't let a 5-year-old outside on a summer day, could he? Not when her face showed the mark of the assault that he had delivered on her. Shows everyone in the neighborhood, along with Nick, evidence of what the defendant did to her. Katie Morin told us that the defendant used other words to describe that day and what he did, besides bashing her around the house. Did she say a jerk? Did she say a grab? Did she say a yank? She did not. The defendant told her it was, quote, "the worst thing I'd ever done," end quote. And that he had supposedly backhanded her. That tells you that the defendant knew how badly he beat Harmony that day in July, that the defendant called it to Katie Morin the worst thing that he had ever done. And the evidence from the multiple people who saw how bad this was and who heard the defendant describe either inflicting it upon her or hiding her. Don't forget, we also have Demetrios Saros. When he first went to the house, was he able to see Harmony? He told you. Only from feet away, as the defendant was hurrying up and getting Harmony in the car and driving her out of there. And even a week later, when he finally does get to see Harmony, she still has a mark on her face. Finally, you've also got Kayla Montgomery, who told you she overheard the defendant's conversation with Kevin Montgomery and then confronted him because he told her it was from a lightsaber that one of the boys had been swinging around and Harmony got hit in the face. And she confronted him about it and said, "You said it was from a lightsaber." He said, "Yeah, no. What I said to Kevin was correct." He admits that he lied to her before when he told Kayla that Harmony got hit by a lightsaber. More evidence that corroborates that what Kevin said happened. His conversation with Adam, where Adam admitted to hitting Harmony in July, did happen. Simply put, from multiple witnesses, from the defendant's multiple confessions, he committed the crime of second-degree assault on a 5-year-old in July of 2019. And of that, there is simply no doubt. That being said, now we can move on. Who and where and why Harmony was killed? Let's go through what the evidence showed us, one thing at a time. We saw that it was not alone with Kayla, not in the Colonial Village parking lot in the middle of the night where Adam had gone to go do his business. Not that it was something that you heard that had happened. It was the defendant in the car on the morning of the 7th with his fists. And it was cold. We know it was cold. So cold that Badero's car died that night when they moved over into the Audi. Adam wrote to Matt Gendron, remember, that they were freezing. Cold enough so that Kim Frayne went and gave them the battery pack to help give them the jump start. So we know it must have been cold enough that day that blankets in the back of a car did not appear out of place. Kayla told us how the accidents were happening, and yes, something had happened the night before, but she told you the night before was when the defendant first hit her. Why? For another accident that Harmony had had in the car. An accident that Kayla did nothing about. An accident that the defendant did nothing about and told Kayla to let Harmony lie in it. Kayla told you what it smelled like, and she told you to your face that she still did nothing about it. And in the morning, things were still the same. Kayla described for you how it started up again. It was still dark outside. She told you the first blow in the morning, it was still dark outside. We know that. Why? Because it's December 7th. Because it's before they get to the methadone clinic, and we know that the check-in times there are 7:05 and 7:09. And you know how dark it is in December, just a couple of days away from the darkest day of the year, December 22nd. When the defendant gets out of the car, goes in and gets his methadone, and then comes back, he finds Harmony has done it again. The smell of her inability to control her bladder and her bowels, something that she used to be able to do just fine for years. It's back again in his car again. The last place that he has, the only place that he has. And what does the man whom Kayla saw be so rageful do? And remember, that rageful wasn't just seen by Kayla, wasn't it? We heard from Rose Smith, the driver, years later, 2021. She told you that after giving Kayla a ride to the methadone clinic with Adam and coming back, that Kayla had had bruises that day, terrible black eyes, and that she tried to give her phone to Kayla. And her words were that when he wrenched that phone out of her hands, he told her, "You are not giving that phone to my wife." And she described his face how? A look of pure rage. What does that person do when they get back to the car after their methadone and Harmony has soiled herself again? All he has is his car and his rage and his fists. And Kayla described for you how that went on. For the length of time that the same length of time that you took driving from the clinic here on Market Street up to the Burger King on Hooksett Road, you drove that drive. You know how long that is. And as the smell continued, she described that the hitting continued. And Harmony took blow after blow until she was moaning. And the defendant points to the fact and says, well, other people, they should have been able to see in the car. It's cold. It's dark. We know there's snow on the ground. Snow in New Hampshire means salt, which means the windows probably look the exact same that yours and mine did this morning. It's not easy visibility. Plus, think about it. Doesn't take a lot to be able to punch down on a 5-year-old, 35-pound child and make sure that it's below the windows. Not for him. Not for Adam Montgomery. Not against Harmony. Not in that car. And you saw from the Walmart video and the video from Officer Stanzel, when they first approached the defendant, when he was trying to find where Harmony was, you saw from that how the defendant looked at Walmart. He's not a small or a weak man. He wouldn't need to use much power to inflict deadly force upon Harmony's skull. And you heard it wasn't from one blow of his arm, but several. Take a moment. Let's just take a break and talk about something that defense brought up. The fact that there were other children in the car, and why wouldn't they have been screaming and yelling? I remember that fun catchphrase she tried to get Kayla to say, a cascade of chaos would have ensued. We know young children adapt to their environment like nobody's business. They're frightened by new faces. They're frightened by new experiences or the unexpected, but they're not frightened by something that's familiar. Why would the other children cry if Harmony had been getting hit and punished in the car? After all, this was the second time in less than 12 hours that they would have seen this if they were awake. They would not have been unfamiliar with his rage towards Harmony in that car. The defendant's theory that punishing Harmony for soiling herself would make the other children cry implies that this is unfamiliar to them. And the evidence shows that it is not. Kayla rejected that cascade of chaos every single time it was proposed to her. And both Kayla and common sense tell you that that makes sense, that that's true. Now, when they got to Burger King, the damage at that point had already been done. As Kayla told you, Harmony laid under the blanket. No one went to get help for her. Not the defendant who beat her, not for Kayla either. And what did the defendant say in that moment? Words matter. I think I hurt her this time. This time, I think I hurt her. I think I did something. Why say this? Because he didn't do nothing. He did something. He took her life in rage over a bathroom accident. And he admitted in his opening that you can and should find him guilty of abusing her corpse and falsifying physical evidence for what he did afterwards to get rid of the evidence, get rid of her, get rid of the evidence that would have shown he murdered her. But it was the evidence of his crime of beating her. I fucked up. I think I did something. I think I hurt her this time. That's what he believed. You saw Kayla testify. You heard for 2 full days practically while she was on the stand, having to tell you what she saw having happened. And Kayla did nothing. She did nothing. She did not parent Harmony. She did not clean Harmony. She did not change Harmony when she soiled herself and the defendant told her to leave her in it. She didn't stop the defendant. She didn't try to get Harmony help. She didn't call 911. She didn't yell out. She didn't run out of the car. She didn't disobey the defendant. She's not seeking help. She's not seeking attention. He went through the trunk to get her, not her, because she did nothing. Later, she didn't betray him until after she even lied in grand jury and committed perjury for him. She didn't lift a finger. She did nothing. Nothing at all. The defendant wants to have their cake and eat it too when they come to describing her. She's an abuser, but she did something in the middle of the night. She didn't see anything here, but she saw it all. She wants the defendant. Oh, she doesn't want the defendant. Believe her grand jury testimony, but don't believe her grand jury testimony, the part where she said she lied. That part you should actually believe, even though she's telling you it's a lie. Want to have their cake and eat it too when it comes to her testimony. Well, you know, she would have been really conscientious when she was shopping for diapers. Because that's, if you're homeless, yeah, that would make sense. You want to go where you can get the cheapest price. She's a drug user. She's homeless. And for Harmony, she does nothing. They want to argue, well, she would have had this instinct to protect that child. Oh, but she did something to her in the middle of the night. She did nothing. We are tested, all of us, just a few moments in our lives to do the right thing, where our character as human beings is tested to do the right thing. And on this test, December 7th, with where Kayla Montgomery was back in that life, she failed. At grand jury, she failed. She still obeyed him. Even though he had run off to Maine with his second girlfriend since then, she still obeyed him. Katie Morin told you that back then, Kayla would have done anything for the defendant. That's what her protector did to her. He had her conditioned so well, physically and mentally, that she kept his secret, and she did nothing. You saw that in her testimony when she told you about doing nothing. And she told you about not stopping him from hitting Harmony. And she admitted unashamedly, without reservation, she didn't try to take Harmony to the bathrooms to clean her up. She didn't try to get her help. She did obey. She took Harmony's body to Portland Pie when he told her to later, sitting her between her two children in the stroller for that 15-minute walk down the street. But she did nothing. You don't have to like her to believe her. You don't have to like what she did. You may have very good reasons for hating her, but that doesn't change the fact that she saw the defendant beat Harmony to death. That doesn't change her credibility on telling us what the defendant did. Just because you believe that her failure to do the right thing is despicable, it doesn't mean that on this, she's not credible. She actually tried to humanize this guy. Remember her testimony? She cried. And she said to you and admitted she still cares about him. Her in prison, Harmony somewhere, only he knows. And she still cares about him. And she admits how she did nothing for Harmony. If she was singing for her supper, like the defendant suggested in their opening, she wouldn't have done that, would she? She'd have an answer for every question, an excuse for every moment that she did nothing. She didn't have that on the stand. She would never have admitted that she didn't take the kids to the bathroom or that she let Harmony sit in it that night. And yet she did. That's someone who's not making up a story to make herself look better, is it? She never would have admitted that when Harmony is covered by the blanket as they get their food from Burger King, that she unceremoniously dumped a breakfast sandwich on top of the blanket. Harmony can open that herself. After the defendant had covered her and smashed her face. And yet, that is what she told you happened. Kayla admitted to you that she did nothing. It's not the face of a person who's trying to make themselves out to be the saint and the defendant to be the devil. That's certainly not a master criminal schemer trying to exonerate her own behavior, as you just heard in closing arguments. She is not like the defendant. She's not admitting that what she can't deny and denying what she can't afford to admit, because if she did, she would have never admitted to her failure to act to protect Harmony. She would have never denied doing the small things. She would have claimed, oh, I did do those. I tried to redeem myself. And how she comes across, how she testifies. What she is a battered woman admitting an inconvenient and terrible truth that she failed in a moment of life when her character was put to the test. She did nothing to help Harmony, nothing to stop her. She didn't kill her. Only the defendant did that. So when defense counsel says that it was Kayla who put Harmony in a duffel bag in the trunk and told Adam about it later, you heard and saw Kayla testify. She did nothing for Harmony, not a thing. And you can't get something from nothing. And the defendant's promise at openings that you'd see she did something remains exactly now as it was then. And it's a false promise. You've seen that theory with evidence presented to test it, and it is still without support. It is still without corroboration, and it is still unreasonable to believe because it was the defendant who did something. When you consider Kayla's testimony, don't consider it alone. Consider it with all of the facts that go along with that testimony. Facts such as that she does have an agreement to tell the truth. Defense counsel questioned her and argued that, well, she had to give the police a lot more to get out of the additional lies that she said in grand jury. But remember, if she doesn't tell the truth, all of this comes back on her. It's back to square one for her. Her agreement is null and void. But the evidence that you saw, how thoroughly the police investigated this case, where Harmony is, location after location after location in New Hampshire, Massachusetts, 900 plus pieces of evidence to help find out what happened has only corroborated Kayla about who killed Harmony, about when she died, who hit her, who mangled her body, and who dumped her where she is now, somewhere between here and the Tobin Bridge in Massachusetts. Corroboration, big, fancy, 5-syllable word that stands for evidence that supports that a statement is true. If you just had Kayla's testimony alone, with her truthful testimony on the elements of the crime charged, that would be enough for you to go ahead and find the defendant guilty of all the charges. But you don't just have her testimony. You have so much more, because every witness, 50 witnesses that came in and testified to you about and provided evidence, provide some corroboration for Kayla's account of what happened in ways that she never could have known. And that includes testimony and evidence that corroborates her on how Kayla died, how Harmony died, and why the defendant killed Harmony, why her body was desecrated, how Kayla was silenced for so long, and how the defendant discarded Harmony like trash so she wouldn't be found. Let's look at just one example. How do we know that Kayla's telling the truth when she told us how the defendant tried to induce or cause her to stick to his story, to not testify, to not tell people how he murdered and disposed of Harmony? How do we know that Kayla's telling the truth on that, tampering with her as a witness? It's because the evidence corroborates it. Nicole Giles told us that Kayla was still at the fit on Lake Avenue, the families in transition shelter, when she saw bruises on Kayla's body. This is back in January of 2020, before Harmony was ever known to be missing. And Kayla is admitting to Miss Giles that the defendant is beating her. And she, what? She asked Miss Giles not to tell anyone. Having just been homeless, now living in a transition shelter with 2 younger children, and having been tested before and failed to get help for a child, she stays silent. She obeys and sticks with the defendant's story. Despite her abuse later, we see that as well from the testimony of Rose Smith, who was giving her that ride for methadone that morning, saw the beating that Kayla had taken the night before. And as she again saw pure rage in the defendant's face as he came and wrenched the phone out of Rose's hands, saying, "You're not going to give my wife that phone." So much so that when you heard and saw Rose testify, you heard her say, ever since then, she refused to drive them around anymore. that she carries pepper spray now. And she said, quote, something I will never forget. Kayla is under control and doesn't say what happens to Harmony throughout that time period. And he believes that she's helping police. You heard testimony about how he believed the police were listening in on him and tracking him, and that he was ripping light fixtures down, that he was breaking thermostats and electronics. Kayla told you that he was paranoid that she was working with police and was being listened to. It's not a sign of mental illness. It's not a sign of being a sign that you want to continue to exert control. And you should think of it as such. That's corroborated by Dennis Cloutier. Remember the handyman at 644 Union Street? He saw the ripped down electronics, the broken thermostats, and he made the repairs. We also see more of that witness tampering from the testimony of Tara Hilbert next door on Orange Street, when Kayla finally does escape physically the clutches of the defendant, to the cycle of abuse that he had perpetrated for so long. The defendant didn't want to be found out. And since he silenced Kayla because he didn't want to be found out what he had done. And you know that from the very beginning. Don't forget the Facebook messages to Travis Beach. The U-Haul was still out there. What did he tell Travis? The day after, the next morning, when he's trying to find out, Travis is trying to find out where the van, because it's supposed to be back. What does he tell Travis right then? Please don't message me stuff like this on Facebook again. Just like getting rid of the body and destroying physical evidence, convincing witnesses to what you've done to stay silent. That's what murderers do. That's what this defendant did. They silenced them into staying silent. And the defendant did that for so very long. He made sure that it was his story that was being told. He continued to tell his story and different variations of it to everybody. His lie that he created. To Christina Lubin, remember, this would have been the first day after they got booted out of Anthony Badero's Audi. At Christina's place, tells her, I dropped her off in Massachusetts with her mother. Jessica Guerin tells her over a year later, while she's delivering a gift for her boyfriend, tells her at that time, oh, my other daughter, she's down in Massachusetts, and quickly changes the subject. Demetrios Saros, the former DCYF employee, tells her, no, send her down to her mother in Massachusetts. Did that right around Thanksgiving. Courtney Garcia, who sees Harmony in the car on Thanksgiving Day and not there just a couple of weeks later. What's the defendant's story? What does the defendant, not Kayla, what does the defendant tell all of these people and tell Courtney Garcia? Dropped her off at my mother's. She was having bathroom problems. I'm sorry, dropped her off at her mother. She was having bathroom problems. Tells Rebecca Maines, dropped her off with her biological mother. Biological mother doesn't even let me see her. A clever lie that works if Kayla sticks to the story that he's told everyone. And he did for a long time. That's why Kayla's in prison today. And corroborating evidence comes not only from the witnesses, but again, from evidence of receipts and from photographs, because a picture does speak 1,000 words. That is not the face of the person who's in control. It's the face of the person who was kept under control. She needed to be kept under control so that what the defendant did to his daughter would not be found out. And it worked for a long time. But all the witnesses who corroborate all testified to a different aspect of seeing the control that he exerted on Kayla and the stories that he told others to stop her from actually working for the police and to stop her from telling police what really happened. That's about what he does to her. But what else corroborates Kayla about why Harmony was killed? The defendant, again, not only about why, but telling Courtney Garcia and Rebecca Maines that why she is no longer with him, or one of the reasons at the time he gets rid of her, is because she's having bathroom accidents. So you know that that's the reason why he did what he did to her on the morning of December 7th. He's still mad about why this happened. He's still talking about it months with Rebecca Maines, years later. It's why he killed her, having accidents in the car. When Kayla said that the defendant hit her overnight and says words of, "You have to stop doing this," that's corroborated by what he told Courtney Garcia and Rebecca Maines, that he got rid of Harmony because she was having accidents. Rebecca Maines told us just yesterday, a friend of his, a close friend of his, that these accidents are what made him take Harmony away to, what did Rebecca testify? The defendant told her, a better place for Harmony, a better place. He told her that he thought Harmony was having these accidents on purpose. And Courtney Garcia especially recalled that the defendant said the accidents were happening while they were living in the car. So when the defendant says there's no evidence to support Kayla about what happened in the car, you know that's not true. Rebecca Maines could not have been clearer yesterday when she told you and clarified for both sets of counsel that the defendant told her he hated Harmony because Harmony reminded him of Harmony's mother. She could not have been clearer about that. Remember, if the defendant himself agrees with his displeasure and anger at Harmony when he got rid of her, and that was because of having accidents in the car, and when he says it to other people, that's not a coincidence. That's corroboration. Corroboration that he was angry at Harmony for the bathroom accidents. Evidence that even though this little 5-year-old girl that he thought was doing it on purpose, evidence of why he was so angry that morning. What else corroborates Kayla's account of when Harmony was killed and what the defendant did to her? Matt Gendron and Kim Frayne. Both of them corroborate the time of when this occurred. Both of them corroborated because Kayla told you it happened when they were back, when the last night that they had their car going into the morning, the drive from the methadone clinic to Burger King in the morning on December 7th. And after that, they moved into Anthony Badero's Audi. And what do we have on that cold, dark winter night, December 8th, 2019? Just after midnight, we've got the defendant Facebook messaging away to Matt Gendron as he told you, "Hey, need help ASAP, please. Need a jump and jumper cables ASAP. I need a jump. My car died. We've been sleeping in our car and the battery, we've been sleeping in our car and the battery just died. My car died. My car, me." And we know what car he's staying in. It's Anthony Badero's blue Audi. We know that from the tow receipt because the car went and got towed by Aaron Sweeney earlier on the 7th. Matt didn't want to go out. Kim agreed to go out, got there with the jumper pack, and when she was there, no Harmony. The two boys get in the car. Harmony doesn't get in the car. More corroboration of when this happened. Separate from Kayla's testimony, separate from the corroboration that what she says is in fact the truth. What is unreasonable to be believed? What is not corroborated? What's not corroborated is the defendant's theory that something happened in the middle of the night while he wasn't there. There has been no evidence of that. I'm going to talk about Mr. Badero for a few more minutes. The defendant proclaimed in opening that the defendant wasn't around, that he wasn't around that night because he was doing his business to get them out of that car. He's unemployed. He got no business. What business have we seen or heard any testimony about? He wasn't out working for Anthony Badero, making money and doing his business, because Anthony Badero showed us he's not the type of guy who's going to go ahead and hire the defendant to go out and work for him in the middle of the night. Tony Badero is not the type of guy who lets a homeless family stay in his car for more than 2 days. He was the type of guy who wanted that the family wanted to make sure didn't find out that they were living in Tony Badero's parking lot before their car broke down. And Tony Badero was definitely not the type of guy who was going to trust a homeless drug user who buys drugs from him to drive his car around at the middle of the night to help deliver drugs. Mr. Badero testified that he drove his car back then despite not having a license. It's not reasonable for you to believe that he is going to have Adam Montgomery drive him around that night, either to deliver drugs or in exchange for drugs. In fact, remember, Mr. Badero admitted to you that when he met the defendant, it was in the late summer of 2019. When? The one time he told you that he had the defendant drive him. And what was he driving to? The courthouse on charges for Mr. Badero getting caught for driving without a license. When you go to the courthouse for charges of driving without a license, probably a good idea if you don't drive your own car. Probably a good idea to have somebody else drive you, which is what Mr. Badero testified to. That was the one time he had the defendant drive his car. And that's back in the summer, long before the family's homeless, long before December of 2019. If the defendant gets pulled over making drug deliveries in the middle of the night, as defense is suggesting you, Mr. Badero's got a lot bigger problems to worry about than driving around without a license. Employing the defendant as his driver is something that Mr. Badero denied, and as you can see from reason, is not something that Mr. Badero would have done. It's not rational. It's also not rational to believe that Mr. Badero would have entrusted the defendant to go out and deliver his drugs for him. From all of the testimony you've heard at that time, you can easily imagine that if Mr. Badero trusted the defendant to go deliver drugs for him, the drugs that got delivered were probably going to be a lot less than what Mr. Badero had promised his customers. Common sense tells you that is not true. Common sense tells you that the defendant has no place to be the night of the 6th and the 7th, except in his car with his family, with Harmony. He has no business. He has nowhere else to be. And why did Mr. Badero tell us all this? He also said that the defendant and Kayla, when he saw them, were always together. Always together. And that when he did go outside and see the kids, it was during the course of the relationship. Mr. Badero said when those days, on the out days when they were in the Audi and he went outside, he did not see Harmony. Harmony was not there on the 8th. Harmony was not there on the 9th. And Kayla, as much as got jumbled a few minutes ago in closing arguments, Kayla was clear as well. It's one of the lies that she told you was a lie that the defendant doesn't want you to believe is a lie. She told you in grand jury that she lied and said that, in grand jury, I told Anthony Badero, I know that Anthony Badero saw the kids in Harmony and waved to him every day. I said that in grand jury, and I lied in grand jury. But you just heard in closing arguments that the defendant doesn't want you to believe that that's a lie, even though she admitted that that's a lie. You want to have your cake, and you want to eat it too. That's what the defendant wants. What else is unreasonable to believe? Arguments that, no one would have seen him stuffing her into the duffel bag when the car was pulled over on the intersection of Webster and Elm. Nobody, that could have happened, and for nobody to have seen it, that's impossible. It's easy to manipulate 35 pounds in a rear seat of a passenger when your back is to the sidewalk and the shrubs that you saw there on that section of the road, with a building with very few windows in that section of the road, when it's freezing cold and everyone around you is distracted by the woman who's waving other cars to go around. The physical evidence in the car and the physicality of manipulating Harmony's body show that this is yet another way in which the defendant's theory is unsupported. That his arguments that Harmony died from something other than his hands the morning of December 7th, that is unreasonable. It was he who punished her with his fists that day, and it was he who decided to destroy, alter, conceal, and remove her body from the Sebring to be sure it couldn't be used against him, when somebody came asking, where is Harmony? You may, when you're back in deliberations, be looking at the evidence in this case, different pieces of evidence that are there, photographs, diagrams, having a good understanding of where everything was, where it was found. And you may be asking yourself, why don't we have more forensic evidence here? First of all, the defendant is telling you that he falsified physical evidence. The other thing is that, as experts have told you time and time again, each one of the experts that got up here, time and elements can wear down DNA and fingerprints and blood. They were able to find DNA 106 trillion times more likely from a female child of the defendant and Crystal Sorey on this toothbrush in the very back of the trunk. The trunk of the Audi that the defendant abandoned, of the Sebring that the defendant had abandoned. But by being so good in hiding his crimes and in intimidating the one witness, the eyewitness to him beating Harmony to death, by wiping down and hiding and destroying evidence, he was sure that there was going to be less and less of it around. And yet still, from that toothbrush, from the ceiling, the truth prevailed. Sometimes evidence is not always where you expect to find it. We heard testimony about this cooler, Christina Lubin's cooler, this cooler, that the defendant kept Harmony's body. We know that Harmony was in there in a bag. We also know from Christina Lubin that she used to put money in there. She had put money in there recently for the defendant to be able to take to help provide for the family. So we know there should be fingerprints on the inside of that, because their fingers definitely would have gone in to take the money. And yet the fingerprints are not there. We know that latent prints sometimes go away. And yet when Kayla Montgomery comes forward and tells you, here is what I know. She finally comes forward in June. She leads everybody. She leads police to the evidence that actually corroborates, and in ways that she never could have known. She never would have known what was in the fit seal. She never would have known that police would have been able to find a sample, an example from CMC of the bag that the defendant had stuffed Harmony into. She told you she initially thought with police this was the bag. She never would have known afterwards that Emily Thompson and Cameron Gibney both saw bag in the Portland Pie cooler. She never would have known about what had happened and was found and was discussed in testimony about the Union Street bathroom, the ATM records, the Home Depot receipt, the Economistay Lodge, the rental records. She never would have known that when she came forward with this. In the ceiling, not even my height, Kayla Montgomery is not climbing up there to be able to look and see that there's something still in that ceiling. Part of all of those different things and what happened, you should also go ahead and consider what Kayla said afterwards about the forensic evidence that she could not have known would have corroborated. You heard about the bag of lime. It's not the fanciest looking bag of lime up there, is it? But that's the one that she identified. So let's talk about that for a moment. It's the bag of lime that has the same SKU that had been purchased the day of February 26th. That an 11:20 ATM withdrawal happened at the Citizens Bank, South Willow Street, and 20 minutes later, 20 minutes later, across the street at the Home Depot, that's when there's a purchase of that bag of lime. That SKU number specifically was found, as was testified to by the gentleman from Home Depot. A purchase of lime by a person who doesn't own a lawn and has nothing to fertilize in the middle of the winter. The common sense tells us maybe the defendant really wanted to get some lye, L-Y-E, like you would find in Drano, breaks down organic material, rather than lime to make your soil doesn't lower the pH, it raises it, makes it less acidic. But the lime purchased at Home Depot 20 minutes after the ATM transaction. And what was it purchased with? A grinder, a blade, that purchase, and a battery, excuse me. That's not a coincidence. Again, that's corroboration. Corroboration that when the defendant talked about how he wanted to get rid of Harmony's body, when they got their tax refunds in their account, that's what he did. So when she told you, we heard about this a moment ago in cross-examination, when she told you that she had seen this grinder new in a box at some point, believing that she had seen it at her mother's house earlier on, when the defendant said that was the kind of saw he wanted to use to get rid of Harmony's body. And then when you heard that Christina Lubin doesn't own this kind of saw, it's a grinder. She does woodworking. This is not a woodworking tool. It's for grinding metal. You have to ask yourself, where is it that Kayla saw this grinder in a box? Where was it? Again, not the lie of a master schemer, is it? Why would she concoct that out of thin air, as the defendant's arguing? Why say that that's the grinder or saw that he discussed when she knows and testified to you already that there's a corded saw in a box underneath the sink? If this was untrue, if she had not seen this grinder at some point new and in a box, if she was singing for her supper, she would have instantly just said, oh, yeah, it's the saw that we have down there. Saw the whole thing. That's what happened. Yeah, detectives, that's the saw. But she didn't do that. She identified the grinder. She said she saw it new. She remembers it because that's what the defendant talked about wanting to use on Harmony. If she didn't see it at Christina Lubin's house, and the only other place you can reasonably conclude is that she saw it at Union Street, along with the bag of lime, and she doesn't remember it clearly. That's the only other reasonable, logical conclusion to make. It's not a coincidence that from their account, the money gets taken out and 20 minutes later this happens. It's corroboration. And the next day, Dennis Cloutier is over at the house. The next day, trying to snake the drain, as asked by the defendant. And who did he say pacing behind him while he is trying to snake the drain? The drain and the drain cover that's already been off. Is it? Oh, no, it's not Kayla. It's the defendant, he said. Just the defendant who is pacing behind him. More evidence that Kayla would never have known corroborates what happened. More and more and more. She could never have known that there would be easy pass toll records of the same rental vehicle going back and forth, as Trooper Hernandez told us, through the Tobin Bridge on the night that he left to get rid of the body with the U-Haul. She could never have known when she told police what happened that those records were there, and that lo and behold, the odometer perfectly matches up for the distance to take that drive. Common sense tells you that. She didn't know that. She didn't know that that corroboration existed, because it's not reasonable to think that Kayla would tell and enable police to find other evidence that she did something. If she was the one who had killed Harmony, like the defendant wants you to believe, she would never have done any of this. The theory does not fit. And I want to jump to another reason why this theory does not fit. He's shown us that he's not the type of person that would have allowed this to happen under his theory. He's argued to you that he's a caring parent, despite what we've seen from the rest of the evidence. But his theory is, in fact, this, that they had planned for hours what to do with the body, and that the plan was to carry her around for months and store her in different places and then finally do something eventually whenever we get enough money for a grinder. It doesn't make sense. His theory is also that he was such a caring parent that he came home in the middle of the night from taking care of business to discover that his 5-year-old that he fought to get custody of is dead while left in Kayla's care. And he just takes it. He doesn't react. He doesn't rage. His theory is that he doesn't hit Kayla or yell or scream so others can hear, is that he just sits in the car for the rest of the day and night and takes it. Goes to the methadone clinic at 7:04 like it's nothing in the morning and takes it. That's his theory. That's not him. That's not who we've seen. That he would show indifference towards Harmony's death. That he bags, carts, stores, stuffs, frees, thaws, squishes, consolidates his child. He does all of that, then leaves Kayla for another woman, leaves her with this woman that he's arguing to now killed one of his children, leaves the other kids with her, and then takes off to Maine, goes on to live his life. That's not him. That's not him. That's not what we've heard. He doesn't do nothing. He would not have been the passenger in this situation. He's the driver. What the defendant suggests his reaction was would not have been his reaction if Harmony just died in the middle of the night from something, and he came back to find her in a duffel bag in the trunk. So we know that theory that depends on you believing that he's that type of person does not work. It is a fantasy. It is beyond belief. It is a bizarro world that the defendant would have you believe in the light of discovering that his offspring is dead, that he does nothing, and that it's Kayla who's always doing the something. That's not reasonable because it's not supported by the evidence, not with the defendant's lies to others, not with the actions that we've seen him take towards Kayla, not with the evidence that he left on Kayla's face and arms and back. And he lied to others too. He lied to others too. Who's the one that's getting rid of the phone? He's got his new girlfriend, Kelsey Small, to get rid of the phone. You saw from the other video there, he doesn't put himself in front of the camera. In fact, you probably saw when he first walked in, he had half a hand over his face. The video's there. You can look at it if you'd like when we go back into deliberations. He lied to the tow truck driver about his address. He had to abandon the car. It was the crime scene. He told the tow truck driver, I live at 77 Guilford Street. You know he doesn't live at 77 Guilford Street. Told the tow truck driver, I got no phone. We know he has a phone. He used it that night to Facebook message Matt Gendron to try to get a jump for the dead car. He lies to get rid of things. He tries to continue to hide. He tells Travis Beach, don't send me this stuff on Facebook. He certainly does have a cell phone during that time. He wants to get his car away from him as fast as possible. What better way to abandon it? Just tell the tow truck driver you don't have the phone and don't worry about it. Let him get rid of the evidence because he's telling you now that he's guilty of getting rid of evidence. The defendant admitted only to what he had to, which to you or I would be unspeakable acts to do to any human being, let alone a small child, let alone your own flesh and blood. He says in his arguments you should find him guilty of altering, destroying, concealing, and removing Harmony's body. And he admits this. Why? Because he thinks you're going to be fooled. His counsel questioned Kayla with the legal principle, and I'm sure you remember it. He was asking Kayla about her petty theft from Dunkin' Donuts. Well, you took some responsibility of it. You took the lesser way out of the problem so you wouldn't get a more serious charge. That's what he thinks that you're going to let him do. He thinks if you'll let him slide on the murder, if he admits to what happened afterwards, because he knows the evidence of that is overwhelming, that you'll let it go on the other two. He admits what he can't deny. He denies what he can't afford to admit. And the only part of Harmony that we have left will be sitting in that deliberation room with you on that pink toothbrush and outside here in this part of the ceiling wall that's there. And the other parts of her body, her rest of her torso, her face, her eyes, that smile, only the defendant, as we all sit and stand here today, knows where they are. And he can't afford to admit to you that he knows where they are, because the evidence contained on them will show that he caused her death. So she won't get the burial that everyone deserves. She doesn't get a headstone in the ground above the head that he battered. She doesn't get to be at peace in death because of what he did, because he can't afford to tell anyone where she is. She doesn't get dignity. She doesn't get peace because this man did nothing. He didn't do nothing. He did something called murder. And because he says trying to find her is a waste of time, that trying to find her is a waste of taxpayer money, that's what he thinks of her. That's what he thinks of what he did. That's what he thinks of you now. Efforts to find where he put her and what he did to her and why he killed her, they're a waste of time to him. His words, you heard them. To find the child that he murdered and the evidence that he hid. He believes Harmony's life and death are a waste of time and that they weren't anything to him and that he dumped her like trash. This is what you've seen in the evidence. This is what you've heard the defendant say when you consider whether he has an extreme indifference to the value of Harmony's life when he killed her. He had no value for her life when he killed her. He took an innocent life, a child, for no reason other than his rage and his indifference and his ignorance and his lack of humanity. Because this trial is about Harmony Montgomery. And you sat here and you were so attentive to every moment, every terrible fact. You watched the eyes and the voices of every witness, and you know it's not about quantity, it's about quality. How they testified, how they looked at you when they answered questions on cross and direct. That was not a waste of time. Only Harmony's killer would say that finding her is a waste of time. That's bearing witness is what you have done to the truth. And that's a front row seat on what this man perpetrated on Harmony and her body and the truth from being shown to you, who cowardly runs off to Maine to distance himself from the scene of his crimes, who runs with Demetrios, comes to the house and could see that bruise on her face. And even then, a week later, Demetrios still saw marks of her after the defender had bashed her all around the house. The man who complains about tracking down leads in Arizona as a waste of effort to prove something. Yes, that's what people do. That's what this community, this state, this nation, this society do. We go to find and protect life. Every one of us, whether you wear a badge or you don't, you seek to protect children, to put the next generation above your own. That's what a father does. That's not what the defendant wanted, because he is not Harmony's father. He has forfeited that right to even claim that title or call himself her father. She was never a daughter to him. Not in July, not in December, not in that phone call, not from the moment of her death continuing up through this very day when he knows where she is. He killed somebody he didn't see as a daughter. He never saw her as a blessing. He beat down something he saw as a nuisance, that he saw as an inconvenience. His behavior to the bathroom accidents shows you that in that moment when he killed her, she wasn't a person. She was an object, thing. And he was mad at this thing that ruined his car. And he hit and he hit and he hit this thing to make it stop doing what he didn't want it to do, to teach it a lesson, until he said to Kayla, I think I hurt her this time. I think I did something. And he might as well have said, I think I broke it. And that's what he did to her. Afterwards, only proves that his actions don't believe that he murdered his daughter. He broke one of his things. And like any broken thing that somebody never really loved, they throw it away. And that's what he did. He may have genetically donated half of his DNA to her, but he was not her father. She was an object that he beat, stuffed, threw, and shelved in a walk-in cooler. Cameron Gibney told you she was down next to the mustard. She was an object made even tinier from her 35 pounds when she was alive by defrosting and consolidating her down, that he took to a hotel and he drove through some tolls and he threw it away. And he knows where she is right now, but he believes it's a waste of time and taxpayer money to try to find her. So don't you ever think that this man murdered his own daughter. Rebecca Maines told you he hated Harmony because she reminded him of her mother. Defense counsel told you to go ahead and put a motion aside and look at the facts. Look at the facts. Look at the facts and call him a killer. Put a motion aside, look at the facts, and then you can call him a tyrant. And you can call him call him rageful. Those descriptions suggested to you, maybe, evil. But don't call him a father. It's time now for you to hear the court's final instructions, to then go back into that room and deliberate all the evidence that you've seen, and to hold the defendant responsible for everything he did in July of 2019, in December of 2019, and afterwards. You promised both parties in the court during jury selection that when proof had been shown beyond a reasonable doubt of all of the elements of the crimes, that you could and would hold the defendant responsible. And now, not all doubt, but all reasonable doubt. And that proof has been shown. You promised us during jury selection that you did that, and you would do that, and you saw Kayla testify. From that alone, you've got sufficient evidence to convict him of every charge, but you don't have to take our word for it, because we just talked about and you've seen for 2 weeks all of the evidence that corroborates and gives you what you need to find him guilty on each and every single one of these charges. We saw in this courtroom that Kayla is not lying about who hit Harmony. And there is no doubt about how Harmony was hurt in July, who killed her in December, what was done to her body and who did it, who falsified physical evidence, and how the defendant kept Kayla quiet. He's guilty of second-degree murder for recklessly causing Harmony's death with extreme indifference to the value of life, because you've seen beyond even that standard, he had complete indifference to the value of your life. Kayla did nothing. He did a lot of things. He did something, he said. It's called murder. It's called assault. And he's guilty of every single one of those charges in front of you. And so I ask you to hold him responsible for that truth in what you've seen in the facts, what you've seen, what you've tested, and what you've heard has been proven. Find him accountable and find him guilty on every single one of these charges. And I thank you so much for your time today.
All right, ladies and gentlemen, I'm now going to give you my final instructions. As I said to you earlier, you will have, I'll send 12 sets of all the instructions, both the ones that I gave to you prior to opening statements and the ones I give to you now as a whole. You will have written copies of these instructions with you in the jury deliberation room. So please listen carefully.
You ready for me to go live, or you want to hear instructions? Yeah, that guy nailed it. Definitely better than her. Like I said, even if she had evidence on her side, if she had all the facts on her side, he would have mopped the floor with her just because he's so well spoken and he laid it out. Just flawless. It is a very sad reason, but he did it. I mean, I've been sitting here thinking the whole time he was speaking, what if they have a verdict already? I doubt it, but
Word is knowingly. I've already read you the definition. In the instructions, I just refer you back to the definition that I gave you of knowingly. So it's the same definition that applies here. Charge ID 2027115C, tampering with witnesses and informants. The defendant is charged with the crime of tampering with witnesses and informants. The definition of this crime
yes,
has
he
3
did.
parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that the defendant believed that an official investigation was pending or was about to be instituted. And 2, the defendant attempted to induce or otherwise cause Kayla Montgomery to testify or inform falsely. And 3, the defendant acted purposely. The definition of purposely for purposes of this charge is the same as the definition of purposely that I have already read to you. I won't read it again, but you'll note that that definition is above. It is the same definition that applies to this charge. Those are the crimes that are pending against the defendant and are before you. The defendant's absence at trial. The defendant has been absent from trial. His absence from trial is not evidence in the case. You are not to guess or speculate as to the reason for his absence, and you may not draw any negative or adverse inference as a result of his not being present. You are not to consider for any purpose or in any manner in arriving at your verdict the fact that the defendant was not present at trial. That fact should not enter into your deliberations or discussions in any manner at any time. In conclusion, ladies and gentlemen, let me say that this case is important to both of the parties, the state and the defendant. The principles of law that I have given to you are intended to guide you in reaching a fair result. You are to exercise your judgment and common sense with honesty, understanding, and due deliberation. As I said before, you should decide this case without passion, without prejudice, and without sympathy. It is your highest duty as officers of this court to conscientiously determine a fair and just result in this case. Now, again, as you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout the trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which he has been charged. And the defendant has no obligation whatsoever to prove his innocence in this matter, and that includes the right not to testify if he so chooses. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to the charges before you. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the offense charged, you must find the defendant not guilty. On the other hand, if you find that the state has proved all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. And I remind you that a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. As I mentioned, we will select a foreperson at random at the end of these instructions. The foreperson acts much like the chair of a committee. He or she should make sure that you take up the issues that I have described and should make sure that each juror has a full opportunity to present his or her opinions and arguments. I suggest that deliberations involve several components. You should each think for yourself about the evidence and the law. You should speak up and let your fellow jurors know your opinions, views, and position as to what your fellow jurors have to say. And you should make every reasonable effort to reach a unanimous agreement. The verdict that you reach must be a unanimous verdict and represent the considered judgment of each juror. In order to return a verdict, all 12 of you must agree on your verdict. As you deliberate, try your best to work out your differences. Do not hesitate to change your mind if you are convinced that the other jurors are right and that your original position was wrong. But do not change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. If any questions concerning the law should arise during your deliberations, the foreperson should write the question out and sign and hand it to the court officer. The court officer will bring that to me and I will respond. You should take as much time as you like. You will be given a verdict form to complete. When you have arrived at a verdict, let the court officer know and you will be returned to the courtroom where the foreperson will render the verdict orally in response to questions that the clerk of court will ask. The jury foreperson may use the jury verdict form in answering the clerk's questions as to each charge. So, ladies and gentlemen, I am going to send back one jury verdict form that has each of the charges and a place where you can record what your verdict is. And that document can stay with the jury foreperson when you are brought back into the courtroom, and the jury foreperson will use that to respond to the clerk's questions. Please bear in mind, in your deliberations, there can be no communications with anyone other than the other deliberating jurors in the case or the bailiff. You are not to use your cell phones or smartphones to communicate with anyone, check email, or use the internet. Your verdict in this case must be based solely on the evidence presented at trial and the law as I have explained it to you. We will now select the alternates and the jury foreperson.
Is it better? It's not choppy on my end, but I got an email that they are working on doing maintenance on the internet. Okay, thanks, Gabby. For like ever. It wasn't just a weekend. I mean, they're not doing it now. They're doing it during the like midnight to 5:59 a.m. or something. But the last time they did maintenance, which was just not very long ago, I think I was having issues after their maintenance as well. But it's been kind of choppy on my end at times, but it's not choppy now. So hopefully it got better. Rumble's been the worst. Those poor people. It does look like they're playing bingo. Yep. Does New Hampshire have that? Whoops. Is New Hampshire one of those states that has that, or did they get rid of theirs? I I I don't look for it to be around really for that much longer, and most states are taking it out, getting rid of it, repealing it, whatever. All right, go fill out your form and come back.
It's critically important that you're not discussing the case with each other or with anybody else. You're not to do any independent research. Don't look anybody up. You are under sort of the same obligations as you were before. In that we need to use you for purposes of deliberations. We need to make sure that you haven't discussed the case with anybody or done any independent research. Let me say for the deliberating jurors, we're going to send you back into the deliberation room. You may begin your deliberations whenever you are ready. The exhibits, I explained to you before that the exhibits will go back into the deliberation room. So all of the exhibits, with the exception of just a few, we are not going to send back. We are not going
Kind
to
of
send
how my
back.
state
There
is
was
too. It's very
one
rare.
body worn camera video. If you wish to see that body worn camera video, what we would do is let the court officer know. We would bring you back in and we could show it to you at that time. We're also not going to send back some of the larger, the sheetrock, the rails, and the cooler. Okay. But if you are interested in seeing any of those exhibits, please just let the court officer know and we'll bring you back into the courtroom and you'll be able to view those exhibits if you wish to do so. So the sheetrock, the rails, the cooler are not going to go back into the deliberation room. The body worn camera that you viewed while you were here, that's also not going to go back. But if you wish to view any of those things, please just let the court officer know. We'll bring you back in and we'll do it at that time. All right, ladies and gentlemen, I think we have accomplished everything out here that we need to accomplish. You've been very, very attentive. I very much appreciate that. I'm now going to let the court officers take the alternates to their location and the jury to the deliberating jurors to the deliberation room. All rise for the jurors.
I agree, Roseanne. If I can get that going. The state used it the best way that they could, though, to get that point across of he knows where she's at and will not tell us. He hammered that home. I thought he did. I hate that it's a fact, but he used it to his advantage, and I hate to say that too. No, bench that she must have missed the lawyers. I haven't seen you all morning. I'm with you as long as they know for 100% the person is guilty, because there's been too many people that have been exonerated that were on that row, for lack of a better word, and that bothers me, but I'm with you on it, if that makes sense. Yeah, we're full today. They started out full, and then all of a sudden there wasn't hardly anybody there. Surely she's not still talking. I would think that the mom wouldn't have any issues getting Harmony declared deceased. I know that adults, it's 7 years, or it used to be, I don't know. But where's she at? Nobody has her. That's pretty clear. All right. So I need one of you guys to do me a favor. I will get the interrogation video up that we didn't get to see. If somebody will watch for, I think we'll have time to watch the interrogation video. But with it being kind of wonky, if I get too many tabs open, it's going to really make it wonky. So somebody can watch. That would be great. All right, let me go find this video. Okay, thanks, Gabby. I can open it on my computer, but I would prefer for it to not just be choppy. Oops. Hang on. Boost the sound. I cannot believe that they did not show this in court. I mean, I guess they didn't really need to, but it's generally like standard.
We might be able to work on that if you, we just turn this on, this is already being recorded, you all right with that? Nope. Okay. We'll do our best to try to get you a cigarette.
Yeah, we got cigarettes somewhere, so try to work on that, okay? Before we have any conversations, I'm just gonna have you read something, okay? And then we'll
Sounds
just go
still
from there.
okay? I hope. Okay.
All right,
Thank
just so
you.
you know, because you're under arrest right now, I have to read you this stuff, or you have to read it to me. Again, Detective Riley, Detective Dunleavy. It's January 4th, 2022. It's 8:55 p.m. You can read and write English, correct? Okay. So, Adam, I'm gonna have you start from there where it says I, and then I'm just gonna have you read down.
I, Adam Montgomery, and the right to remain silent.
So start from here. I, Adam Montgomery,
Give the following voluntary statement. Detective Dunleavy, Detective Riley, who has identified himself as a member of the Manchester, New Hampshire Police Department. He has advised me the following of the right to remain silent. Everything he's saying can be used against me in the court of law. I have the right to a lawyer for advice before any questioning, and to have one with me during questioning. If I can afford a lawyer, one will be appointed to me by the court. If I decide to answer questions now without my lawyer present, I still have the right to stop answering anytime. Do you understand? Yes.
do you understand all of these 1 through 5?
Yep.
Okay. What I'm gonna have you do, just initial 1 through 5. That just indicates that you understand what I'm saying, all right?
Yep.
All right. Can you just read that line aloud
Do
for
you
me?
understand each of these rights? Yep.
And you're gonna check either yes or no. All right. And then read the next line for me.
I admit to have each of these rights, and are you willing to waive each of these rights and answer questions? Sure.
Okay. Now, Adam, you're just gonna sign that line. All right. Appreciate it.
Before we go forward, can we get a cigarette in here?
So there's a sensor in there. So I'll work on getting you a cigarette at some point. I can't promise you one right now, just because the room we're in, and if this starts going off, I don't want to flood the building. You know what I mean?
Smoke detector ain't gonna go off.
That thing will, the sprinkler. So, but at some point we'll work on getting you. I know we have cigarettes in there. I know where they are. Okay, you hear what I'm saying? Do you need water?
I don't need nothing.
Okay. Are you?
No, I'm not okay.
Okay. What's not okay?
Nothing, what's up?
So I'm just gonna ask you some basic questions. You said you can read and write English, correct?
Sure.
All right. Can you just state your full name for me?
Adam Montgomery.
And Adam, what's your birthday?
2290.
And what address are you using to
I'm
call?
not using any.
Okay. What phone number are you using?
I don't have one.
What was the highest level of education?
GED.
Where'd you graduate high school from?
I did. I got a GED.
No, but I know, but like, where'd you get
While I
that?
was incarcerated.
Right now, are you under the influence of any drugs or alcohol?
No.
Okay. Do you have any traumatic brain injuries or anything like that? Anything that prohibits you from recalling any memories or anything like that?
Not that I know of.
All right. So we've met before, right? We met the other day. I know you've had a long time down here. You've kind of been a roller coaster. I'm going to apologize for what happened out there, that's not how I do business, okay? That had nothing to do with me. Those are guys that like to play G.I. Joe, all right? If it had been up to me and I could have gotten a hold of you some way, I would have reached out to you. But you don't have a phone, right?
You guys could have just told my wife you wanted me to come in.
But aren't you not supposed to be talking to your wife?
No, that's bullshit.
It's not, you're not supposed to?
No, I can't be.
Thank you, look at that.
I can't be.
I guess they're gonna let me smoke a cigarette.
I hope they don't open that door too many more times. Owie.
So I don't know why who's saying I can't talk to my wife. That's bullshit.
Maybe it's old paperwork somebody saw.
Yeah, from last year. Over in
Aw.
Dublin after I got out of jail.
So that's all clear.
DCYF said it was cleared up. The police said it was cleared up. Everything between me and her.
Okay, and that's Kayla we're talking about. Okay. Well, you know, if that's the case, then that's my fault for maybe not checking a little bit further into it, so I apologize for that. Again, I apologize for the way things went down out there. Like I said, I'm not part of the SWAT team. I don't do that stuff. If I had a good number for you, I just, but I don't have a phone, you said, right? Okay. So I apologize for that. I do appreciate you being cooperative with me. You've never given me a hard time. I know we've only met a few times, so thank you for that. Let's talk about why we're here to talk.
It's not Hamilton. It's me.
Tell me what you want to say.
Tell me what you know.
I don't know nothing.
Well, what was our conversation about the other day?
You said you had a couple questions you wanted to ask me. Yeah, ask me the questions.
Well, what was our conversation about the other day? Remember we met, I mean, you remember that was only, what, a few days ago, right? We had a lot of worried people and scared people right now in the community. I know you're worried about the well-being of your daughter, and I kind of want to get ahead of this because I don't want you to be painted as a monster.
Well, that's what you guys are already doing.
I am.
We're not doing that. Oh, yeah, yeah.
Can you explain that?
That's what you guys are already trying to do, man.
Explain to me how I'm trying to make you, or whoever is trying to make you out to be a monster. Who's telling you that stuff? Is there somebody from that I work with that told you that? Somebody you're close with, that they told you that?
No.
All right. But you understand this whole thing is getting a little out of hand. Would you agree?
Of course. But
So that's why.
look, it's just the way you guys are going about it.
And again,
Yeah,
I don't
not you specifically, but
Right.
yeah, nobody comes out there like that for a second-degree assault charge. Nobody. Been arrested for worse charges. They don't come out and throw fucking flashbangs at my girlfriend's car and ram us into the fucking guardrail. They don't do that for a second-degree assault charge.
again, you understand what the charges are, right?
Second-degree assault, right?
Yep.
Okay.
There's also an endangering the welfare charge
Okay.
and interference with custody. Okay,
So how did I interfere with custody?
So that paperwork that we served you the other day, you remember that?
Okay.
When they were in the alleyway, you remember outside of on Lake Ave?
Yeah.
There's paperwork that you have to comply with. You understand that, right? We had that conversation, did we not? Right? So that's what that's all about.
So
Like,
second-degree assault charge, what is this referring to?
well, that's what we want to talk to you about.
Well, explain to me what I'm being charged with it. What the hell am I being charged with it for?
Well, your daughter had some injuries
What?
that you know about when you lived on Guilford Street.
No, I do not. What are you referring to?
Well, you were there, I wasn't, right?
What are you referring to?
I'm referring to her having some good marks.
What are you referring to?
Marks that were left on her by you.
Absolutely not. I have nothing else to say.
Like we talked about how we were worried about your daughter the other day, right?
Okay.
You remember that conversation?
I remember that conversation, but right off the rip, with the way you're approaching the conversation, you guys are completely out of line. So,
Me?
Yeah.
What? In the time you've known me, which
what
is
you just said to me, you guys are completely out of line.
okay, but so explain to me, how are we out of line?
I have nothing to explain.
Okay, but wouldn't you rather explain it so we can make sense of it than just have other people's side of the story? Like, you want to defend yourself and like this picture people are painting of you. Now's your chance, man. Defend
Whose side of the story? Who's telling you these things?
people that were close to you.
Obviously not.
Well, maybe at the time, maybe not anymore.
Yeah.
I mean, you saw that reward on the news, right?
No, I did not.
Do you know that the reward is about $40,000 to find where your daughter is right now?
Okay.
When you start throwing money around like that, people come out of the woodwork that you would never expect to do.
Okay.
So, like I said, when I talked to you a few days ago,
Can I have another cigarette?
sure, I kind of told you this thing was going to get a lot bigger.
That's not right.
And we wanted to get ahead of it.
But you're sitting there telling me that right off the rip that there was something wrong with my daughter because of me. No, that's bullshit.
Okay. So if your daughter had marks on her at some point when you lived over there,
As
how
far
would you explain those?
How was she got those marks?
well, I would love to know when that marks were there because DCYF came to my house multiple times.
Okay. And we know that they came there.
Right. And closed the case.
Okay. Do we know that DCYF is the flagship agency in the country?
No, but if there was significant marks like you're referring to, I believe they would have flagged something at that point and they would have said something. They wouldn't have came there and seen that the kids were well taken care of. All the kids loved being at the house with me.
So let me tell you about what second degree assault is. Because there's a lot that encompasses that charge. Basically, if there's a mark on a kid that's under a certain age, it constitutes second degree assault. Although it is a felony, which sounds extremely intimidating, it doesn't mean that somebody got their head bashed in or they got cut up or whatever. So although it sounds pretty intimidating, the charge, I understand that. What we're talking about doesn't mean that it's the craziest crime that's ever been committed. Do you understand what I mean?
Okay.
So somebody could have a bruise or a really bad welt on them, and that would constitute second degree assault for a kid under a specific age. So that's why that charge is there. So nobody is saying that you took like a baseball bat or like stabbed your kid. Like, I'm just going to put that out there. That is not what anybody's saying about you.
Mhm.
So I know you're concerned with when I say second degree assault, but it sounds a lot worse than I think you're thinking it is.
Yeah, but for you to sit there and say that it was inflicted because of me.
We're just going on what we hear. You're not telling us how, so we're going with what we have.
But I don't even know what you're referring to. What are you referring to?
Your daughter had a mark on her face that multiple people have told us was inflicted by you.
Multiple people that weren't even living with us at the time.
Well, there was enough people that had spoken about it.
Yeah.
People share knowledge of what they know.
So somebody, you telling him and then he tells you and then he tells you, so something that just
No,
gets
it's-
passed down the line.
Yeah, I'm not talking about like a game of telephone here. I'm saying that people say a story and then the details kind of fill themselves in, like corroborate. Do you know what the word corroborate means?
Of course I do.
Okay. You're a smart guy. I'm not trying to insult your intelligence, but when people kind of fill in the blanks, that's what I mean by like we're corroborating that story. But this is your time to tell me, kind of explain that. You know, if you're saying this was a mistake or this was an
I don't even know
accident?
what you're referring to. Like, that's what I'm trying to get at. Is I don't even know what you're referring to.
I'm saying she had a mark on her face. I mean,
Okay, I don't even know what you're referring to.
you don't recall your daughter ever having a mark on her face?
The reason DCYF came out to visit you guys, you don't recall that? Why did DCYF come out and start visiting you guys? What was the allegation?
If I remember correctly, it was because of I believe at the time, I could be wrong. I believe it had something to do with my uncle saying I was using drugs, and I wasn't.
Now, who's your uncle, so we are clear?
Kevin
Okay. And Kevin's last name?
Montgomery.
Now, he lived there with you?
He lived there with me right around the time when I was first going back to get custody for my daughter.
Okay.
And then he left in April, May, March, something around that time.
And just so I have it right, because I don't want to guess or like get confused, what house are we talking about?
Guilford Street.
All right, and what was the number there again?
I'm not 100%.
Okay. Do you remember what color the house was at least?
Beige, maybe.
Okay. And whose house was that originally?
My grandmother's.
All right. And grandma is who?
Kevin's mother.
Kevin's mother.
My dad's mother.
Okay. So was it the Montgomery group living over on Guilford Street?
Yeah, and they all moved out. My grandmother moved out in like January with my little brother, and they all moved down to Florida. And then Kevin went a couple months later.
And so grandma, uncle Kevin, you said little brother, and who's he?
My father's son, Michael.
So Michael, that's what I meant. Like, what's his first name?
Yeah, and his girlfriend.
And his girlfriend. And is he still with that same girl now?
I have no idea.
Oh, so you don't talk to Michael anymore?
No.
Okay. What was that girl's name at the time? Because maybe she can help us to say that, like, this is.
Kayla, I believe.
So Michael's girlfriend's name was Kayla at the
Yeah.
time? And you dated a Kayla at the time?
Yeah.
So it kind of got confusing in the house. Somebody's yelling for Kayla.
Yeah.
Okay. So what was Kayla? Kayla you were with at the time was?
My wife.
Okay, Montgomery. And then Kayla he was with is?
I have no
idea who she was. Okay, so there was grandma and Kevin, they moved out in when?
Grandma moved out in like.
I'm just trying to think of people we can talk to.
I'm
like,
trying to
like,
figure it out.
corroborate that
I'm
stuff,
trying
you know
to
what I mean?
figure it out to go back. Like I think we moved over. Thank you. I think we moved over there.
Good grief.
I think we moved
The
over
accent
there
is
in,
strong with this one, though, Gabby. Have to give you that.
I don't know, October, September, somewhere around then.
And what year is that?
2018.
Okay.
And at the time, I was going for custody for my daughter for at least a year already at that point. And Crystal was showing no interest of going to get our daughter back. So finally, in like, I don't know, December, January, February, something along them lines, the courts called me and told me I could come pick her up and bring her home. Brought her home. And then, I don't know, it was, I think the month before, my grandmother left with my brother and his girlfriend. And then the month after, I want to say, Kevin left.
So then who was left living at the house?
Me, Kayla, and the kids.
In that time period, I don't know which kids were born yet and who was.
It was Declan and Seamus.
Okay,
And then Harmony moved in with us.
okay. So what time did DCYF get involved with you guys? Like, were they over there often, or was it just like a certain period of time? Or
They were there every single day. The police showed up every single day, saying they
why
did
were they
because that's what it was. That's what it was due. That's what it was due to. So Kevin moved out because between me and my wife and Kevin, we were supposed to like pay the bills, keep the heat on, the gas on,
Yeah.
whatever. Well, Kevin was supposed to pay the electric bill. He didn't pay the electric bill. Me and my wife, so I picked my wife from work, showed up at home. They were shutting the electricity off. So me and Kevin got into an argument about not paying the bill.
Yeah.
And he took his shit and moved out. And then so the next day, DCY, or 2 days later, something like that, I don't know, DCYF showed up and the police showed up because they said that we were unfit to have the children at the house because there was no electricity in the house.
Okay.
But we had a generator running, we had the fridge hooked up to it, there's food in the fridge, everything was fine. The police showed up, seen that the kids was fine, there was nothing wrong with them. The DCYF showed up and they left.
And was that like summer, fall? Like when was that?
I want to say maybe spring going into summer, maybe.
Oh, okay. So like, you guys hadn't been there for too long then.
6 months or so.
Okay. And how did it end up that you guys got kicked out of there?
All right, so it was my grandmother's house.
Right.
They didn't pay the mortgage or whatever. They moved to Florida, so the mortgage payments weren't being paid. And I don't know, right around Thanksgiving sometimes, the sheriffs came and threw us out. And then me, Harmony, and Declan, and Seamus, and Kayla left.
And where the heck did you guys go from there?
So the family just walked away from their house.
Oh, so you lived in your car at that time?
For a couple of days.
Okay.
And then
Did you have like a van or something like that back then? At least, what were you driving back then?
Chrysler of some kind, I forget.
Oh, so it was just like a sedan.
Sedan, yeah.
Okay, so you live in the car so you, Kayla, and the 3 kids were living in the car for a few days, and then how'd you get up out of that situation? Like who took you in, or where'd you guys end up?
We lived in her mom's house, Kayla's mom's house.
Okay, and what's her name?
Chris.
Chris. How is she? Well, I mean, she must be okay. She's willing to take you guys in.
Yeah. All right. They're like, all right. I. You know what, man? Like, I don't even want to talk anymore. Like, this is just beating around the bush, man. It just seems a little too silly to me.
Well, I'm trying to figure out who can substantiate your claims that there's like you're not this like monster or person that either DCYF made you out to be, or your family who you didn't get along with, or whoever. So that's why I'm trying to like let you kind of speak your piece about all that shit. You know what I mean?
No, I get what you're saying. I just got nothing else to say. And like, no, yeah, and like, I just don't want to sit there and like, can I smoke another butt?
Sure. I'll be honest. I don't smoke cigarettes. I get a little lightheaded myself.
All right, I just know I smoke butts for a minute.
That's all good.
But yeah, no, but to sit there, man, and sit there and tell me you yourself too, like, this is why I feel like it's just all bullshit. This is just a game. I know it is. I'm not stupid. You fucking.
I'm just trying to give you the opportunity to explain yourself.
You're sitting there telling me not to make me out to look like some monster.
Well,
But you told my girlfriend the other day that she should get the fuck away from me. That you don't even know who I am and what my past is like and all types of crazy shit. Like, but sit there and look me in my face.
Adam, I think you're talking about Kelsey.
Yeah.
Okay. I think Kelsey might be exaggerating a little bit.
I don't know her to exaggerate like that.
It wasn't us talking to Kelsey either.
Oh,
There's
may have been someone else.
other people talking to her, just so you know.
She told me, she gave me your card and said this was the guy that said it.
Okay. Well, I'm telling you that I didn't say that. But if you want to believe it, that's fine.
I mean, she never had no reason to lie to me, so I don't know what she would lie about at that point.
She also told me she had no idea that you had a daughter, so I guess we could say the same thing about you telling her that.
Ouchie.
Right?
She knew I had a daughter. I mean, I have one with Kayla, so she knew I had a daughter.
She didn't know about Harmony.
She knew I had other kids.
She told me she had no idea that you ever like lived with her and that you like barely knew her. I don't know if she was lying to me because, or whatever, I have no idea. I don't know her. I know you better than her, so that's what I'm saying. So Christina takes you guys in, and then she's doing all right, and then would you guys move over to Union Street after that? Is that when you guys get that spot?
Nope, we go to the shelter.
And that's the one on,
Like, yeah,
okay.
Who's we? Who went to the shelter? They allowed you to go as a family to the shelter?
See, I thought they didn't like guys there for some reason.
they always let guys there. They didn't let me in there this time for no reason. The reason was bullshit, because I would have been there with Kayla again.
So back then they let you in there,
Oh, yeah.
and it was all of you guys, like, it was the
Five.
5 of you, they let you guys stay there?
No. All right, see, yeah, you guys are just.
I'm trying to understand, I don't know your timeline of life, man. You're there, I'm not. That's why I'm trying to ask you these questions to
Look, I
clarify them.
already told you the other day what transpired. So we didn't even go to her mother's house.
Okay, who didn't go to her mother's house?
Harmony was on.
Okay, so Harmony didn't go to Chris's house. So explain to me how she didn't end up going to Chris's house.
I've already explained this to you.
Okay.
Well, there's some discrepancies between what you're telling us and what other people are telling us. You're saying you brought her down to Mass, that somebody said she came up from Mass.
I never once said I brought it down to Mass.
What did you say? She came up here to get her?
I never once said. I was audio and video recording the other day. I never once said I went down to Mass.
So you're saying that she came up from Mass?
I'm not saying anything else.
Why is it that you refuse to talk about her every time we bring her up?
Because you guys are just sitting here beating a bush. It's over and over. You guys asked me what happened the other day. I told you what happened.
You
And
wouldn't,
now
you wouldn't tell us the other day. You said
You guys talked to me the other day. I explained to him what happened the other day. And now it was just a charade. Yep. No, don't worry about it. You're not under arrest. And now come up with some fucking
We
bullshit.
didn't arrest you.
No, the other day, no. But then you had a fucking SWAT team roll up on me and fucking D-Tex follow me around for the last 3 days.
Yeah, people are coming out of the woodwork. That's what we're trying to tell you. Like, we don't want you to be painted as a monster. We want you to maybe explain yourself a little bit and give us some side of your story. We have nothing. We have just what we're hearing from people. $40,000 to drag a lot of people out, whether you believe you're your friends or not.
No, I bet
It's a lot of money.
Yeah, I know it is.
So-
Absolutely it is.
That's what we're trying to get. Now's your time. Like, you keep locking up on us. You don't want to tell us anything about her.
I got nothing else to say
I think you care,
about all my kids.
right? But the one I care the most about is your daughter, Harmony. And we have people around the clock calling into us, giving us tips from all over the country because they care too, to try to find where she is. My only goal, which I told you the other day, is to make sure that she's safe. I don't want you to get tied into something if you didn't do anything wrong. My job is not to jam somebody up for something that they didn't do wrong. And if you can tell me that you didn't do anything wrong, then I want to believe you because, dude, I've met you now a few times. I helped you out when you were at the hospital when you were having a fucking meltdown. You told me about your kids. I sat there and I talked to you. Dude, I could have fucking tased you right there, and I didn't do that because I saw deep down inside that you were hurting and that I wanted to help you.
He should have tased him.
Right now, all I'm trying to do is help your daughter. I want to bring her home, and I can't do that without your help. Dude, I can't do that without your help. Hey, can you look at me? Help me, please. That's all I'm asking for. I can't sleep until I know that she's okay. And I know that you know where she is or what happened to her, but I can't do it without your help. And if you don't want to look like this fucking animal, because I don't think you are. Not that I don't think you are, I know you aren't. But I can only do so much for you, man.
I know.
I'm begging you to help me. Because as much as you're hurting inside, I'm also hurting inside. And I don't know how you can sleep at night because I'm sure it's eating the shit out of you. Am I wrong?
No, No, see, me and Pies. I know I'm not fucking seeing my wife. I'm not seeing my kids. You guys are
Right.
just playing games. Like
But I
this.
do have a
Keep it on
girlfriend on
that
the
track.
side.
We're not trying to play games.
Like,
telling my wife and kids that I'm not allowed to see my wife and kids. Like,
but dude, that was a mistake from some court paperwork that hadn't been updated. So like I said, I apologize for
but
that.
it was updated. DCYF told them,
No. This was some like DV paperwork I'm talking about.
but I'm talking about DCYF already told us multiple times that there was no contact order.
Maybe
Okay.
through DCYF, but
It could have been through DCYF.
It's
So let's,
fucking criminal.
dude, let's fucking forget about it.
All right,
You've seen your kid, you've seen your wife and kids over the last how many days, right?
I haven't seen them in the last. I haven't seen my kids in the last 2 days, 3 days.
Okay. You're always going to be their father, Declan, Seamus, and then Sierra, right? Kiera. And then there's Harmony.
I got nothing else to say.
Yeah. Huh. Weird.
That's it, guys. I got nothing
Hey,
else to say.
can you make me a promise? Like man to man? Can you tell me that she's alive?
You're gonna play the same word games that you played with me the other
No.
day.
It's not word games.
I got nothing
Because
else
we
to
care,
say.
man. We want to know.
This isn't gonna go anywhere. Like this isn't gonna stop. So
No,
you
I
know.
know it's not.
So
So
either get on the bus now or get run over.
I got nothing else to say.
Why is it you have so much trouble talking about Harmony?
Guys, I got nothing else to say. I want a lawyer with me.
Well, leave this copy of this ex parte or it's a petition from DCYF. You can read it later sometime. I'll put it in your property. It's basically the same thing you got the other day. It's just a little more detailed that we handed you. It does say that you're ordered to help us locate Harmony Beards unless you're not going to do that.
I'm just telling you guys I want a lawyer.
It is 9:25.
Okay. Well, Stormy, you might not agree with me on this, but that was the smartest thing he did because anytime the police read you your rights, ask for an attorney so you don't say anything that will be used against you later. Because don't forget, they can lie to you and they will lie to you. And that's not a knock on them. It's just protect yourself. And he didn't give him anything. Every time they brought her up, he just, oh, I'm done talking. I'm done talking. I was about to pull Hamilton and throw things. One, because apparently my computer deserves it today. But two, I dealt with people about, well, you didn't ask me right. I don't care. Don't come at me like that. Shut up. I mean, answer the question. They're asking you where your kid is, and they didn't ask you something right. He made my head hurt even worse than his defense attorney did. Alrighty, I don't know. Oh, well, yes, he deserved that too. I was just like, he was making me very, very angry because he deserved it. Oops. Don't throw your phone, Hamilton. Don't throw it. Sorry. You know. Oh, that's funny. All right. I I don't have anything else to watch. Um, Anybody know of anything else to watch? I would play the Shonda jail calls, but that's on a different stream, and I don't want to go get their stuff. So I don't even know where it is. Oh, I wanted to throw all my computer stuff. One, because it deserves it. Two, he was making me mad. Uh, I haven't. So I went and kind of was looking at Tucker's stuff uh, yesterday, and I saw that on the 9th of February, his ankle bracelet quit, ankle monitor, whatever, quit working. And they said it's because he did not properly charge it, and they wanted him, I think, violated for that. But there was nothing else that I could find that followed that up. So I have no idea. Also, I kept saying final pretrial date was March 11th, but that's not, it's just a pretrial date. So I don't know what's going to happen that day. I don't expect that to be anywhere streaming. And the guy that his YouTube channel is Justice as a Process, he's saying he's not convinced that that the new judge in Monroe, Florida, is going to let them televise the retrial, which will really suck because I want to see what happens. I want to see the end of the case. So that's all I know now. I was trying to kind of read some of his motions. I was going to print some of them out, but one was, I don't know, 50 some pages, and I didn't figure my dad would appreciate me using his printer in that capacity. Paul is coming up Monday. So I looked again yesterday. They still say it's at 8:30. I don't believe it's going to be at 8:30 a.m. My time, Eastern time. I guess your time too. I think they'll probably move it. I think when they update the judge's docket, which I will check again tomorrow, that it will have I think it'll be like Shonda's was, around 1:30ish, is my guess. But maybe not. If it's at 8:30, I will be here to cover it because I got to see that one to the end as well. And he needs, that guy's gross. I felt sorry for him, but that is over. And he's gross. What? What could be in Boston other than people with really thick New England accents? Like Mark Wahlberg. Boone is still on track for May, as far as I've seen. I haven't checked her this week. So, as far as I know, they're still on track for what is it, May 7th for final pretrial, May 13th start date. So she should still be a go. I'm kind of wondering if she'll pull a thing like this and not show up at court. Museum of Fine Art. We are the Museum of Fine Art, right, on this channel. You're going to miss Paul's sentencing? Yeah. I am over it. And I haven't even really looked at the stuff that people have sent in the comments because I don't want to. I saw that just a headline that he's trying to get his confession, he doesn't want it admitted into court. Okay, good luck. I don't maybe they'll be able to suppress it. I don't know. You never know with lawyers. Sometimes they can pull some stuff. So, other than that, I haven't looked. To be honest, when I get done for the day on here after being on here for 5 plus hours, I am off my computer the rest of the day. And so sometimes that means me getting off of here, resetting the stream up for the next day if I don't do it the next morning, and then just going and just not eat. My husband be like, "Why are you so quiet?" It's like, "'Cause I don't wanna talk any I've been talking." I just wanna sit here for just a minute. But I just need to relax for a minute and not look at horrible, horrible people. I did see a case though, a trial. They're in jury selection today that I don't know if you guys it's not on court TV or Law and Crime. Uh this alleged cult leader, Nature Boy. Does anybody know anything about that? Yes. Again, yes. Yeah. Yeah, Hamilton, it probably did not go well. Because he was Chad's the one that were they on the lawn? So, I don't know. So has anybody heard of the Nature Boy alleged cult leader? Well, I'm gonna check it out then. Like I said, it's in jury selection right now. It's on a local station, I'm not sure out of where. Uh, so I kinda like to watch that's how I got freaking Shonda, is because I just like to watch stuff that's not everybody watching and everybody doing it. Um, so we might check that out next week or tomorrow or Friday. I don't even know what day is it. And see what it is. I'll look at it tomorrow when I'm at my dad's and uh, see if it's interesting or not. See if I can. 11 Alive. Does anybody know where that is? What channel? Tell you here in just 1 second. DeKalb County, that's Georgia. Right? So he's been in jail since April 22 with no bond. A former member of the cult who he unalived a former member of the cult who identified herself as his girlfriend. Said he posted revenge, starts with a P and ends with an N, because she left him. So I'm not sure exactly. That's all it says. I guess, sorry, take the unalive out. Because it doesn't, I assumed he unalived. But it does not say he unalived. I would have. He's been in jail for 2 years. I would assume that he unalived somebody. Oh, Chad Dorman's in court right now. I think. However you say his name.
So you always have to be.
If you guys want to look at that. He should plead. Oops. Well, it's going. Do you want me just to start it? Do you want me to back it up? What do you want me to do? I have no idea how long we're going to be before the verdict comes in. Back it up to the beginning. Oh, hang on one sec. Oh, it's already boosted. Good, good, good. I'm with you.
We are on the record in State versus Chad Norman, case number 2023 CR 407. Mr. Norman's present with counsel, Mr. Myers, and Mr. Haynes, the state represented by Mr. Colby, Ms. Laura Barron Allen, Mr. Tharp, and Ms. Terpstra.
Sorry.
I will indicate just for the record that the brief little conversation we had in chambers was not of substance. It was just Ms. Terpstra letting us know that she may have to leave before the hearing is completed based upon other matters that she
Sorry. You guys are just, I know.
has. So if she gets up and leaves, you know why she's leaving. She's going to another courtroom to handle another matter. This case is, I'll also indicate that court reporter is present as required. She remains under oath and will remain under oath. She signed that oath and remains under oath as required.
Hang
And
on.
the matter is set this morning for hearing on the defendant's motion. The motion is captioned motion to suppress and eliminate. And before we get started, if you don't mind, I'd just like to clarify the motion and some of the, make sure I captured the various.
Okay, so this is Chad Dorman. I don't know if I'm saying his name right. He unalived his 3 sons. Stormy, was it in front of his wife that he did that? Because Carmen was talking to me about it, and I just did not want to know. But then he confessed to it, and now he's trying to get, this is a motion to suppress his confession of what he did. So, another good parenting thing there. We have so many of them. It sucks. So he did. Wife and stepdaughter. Good for him. Ugh. People are gross.
Factors of this, and they're, as I've indicated, it's motion to suppress and eliminate, and those are two different standards, obviously. So, and I'll just kind of nutshell it, so to speak. The first issue appears to be that Mr. Dorman did not properly waive his Miranda warnings, or that he did invoke his right to remain silent, and the detectives involved ignored that and pursued questioning in violation of Miranda, and he did not provide a written, signed waiver of his Miranda rights. There is also a contention that any statement that he may have made, even if it was not in violation of his Miranda, was not made voluntarily due to coercive tactics by law enforcement, including some issues regarding potentially his mental condition at the time. There are also a number of, it appears, recorded interviews, and I guess we'll get into that, at the jail. The corrections officers may have recorded conversations between Mr. Dorman and jail medical staff, perhaps while he was in his cell, and other, or at the medical staff facility that's at the jail. There were also, he was also apparently videotaped during his initial conversation with counsel at municipal court, determining his eligibility. Not sure. There references that in some instances it was just video recordings. And
since we filed the motion, that part of the motion is not pursued. And no incriminating statements that were made or observed by police officers. It's conflict with Mr. Kell at that point. So we're not going to pursue that.
Okay, and I appreciate that, but if you would, let me just track it, and then I can specifically indicate what you're not presenting. Okay, and I appreciate that, but and then there's follow-up regarding that. There's also issues raised regarding potential violation of the HIPAA statute and a right to privacy. So that's my understanding. Now, let's pare this down to the specific issues that we're going to deal with today. So that one, so the record is clear, obviously, but two, so that I fully understand it. I guess the other thing I'm asking, I was curious about is the eliminate aspect of this. I mean, an eliminate obviously is much different than suppression, but go ahead, Mr. Haynes.
Well, the eliminate first goes to the HIPAA and 2317 privilege violations. If the court found that they were not subject to suppression, they might be subject to eliminate, keeping them out. As far as what I was saying about the part of our motion that deals with statements that Mr. Dorman might have made while talking with the lawyer, Mr. Kellum, at the initial appearance before Judge Nagel on June 17th. The state has, we discussed that since the motion, they don't have anything incriminating from them, intend to use those statements. They agree they're not going to use those statements. We're not pursuing anything, suppression or eliminate regarding the statements. Also, I think it's a stipulation for the court that the parties stipulate that Mr. Dorman was arraigned or had an initial appearance, if you will, before Judge Nagel in municipal court on June 17th of last year. And at that time, counsel was appointed for him in our office. He had counsel after that.
So you're still concerned, though, about it, and are going to address various times throughout his period of incarceration when COs had their They have their body cameras. I think they call them something differently. They're okay.
So we narrowed it. There are several others that we're not pursuing this motion. The two are one involving, she's good, that's the jail liaison.
Never.
Talking to our client, what we think should have been a privileged conversation, and that was video recorded by the CO or COs coming into the cell with her.
Just video, not audio.
Video and audio.
Okay.
And the same type of situation with his discussions regarding they could be fairly characterized as a medical complaint or inquiry to one of the jail nurses. I think it's Nurse Amy Griffin, who the COs were there, inserted themselves into that, recorded that. Both video and audio.
They never do.
And then the other regarding potential HIPAA violations, and were there statements obtained in the HIPAA violations or
Right, that's part of the motion is to may violate HIPAA. Or doesn't find that.
Oh,
all right. Well, on behalf of the state, it's your burden. Ready to proceed. Any opening statements you wish to make briefly?
Your Honor, we just log in the record, we've talked about a motion to separate witnesses.
Okay. If there are any witnesses in the courtroom, they need to stay outside. Obviously, do not discuss anything whatsoever about this case. This may be streamed, so don't watch any videos, don't pay any attention at all. And when you're summoned, they'll be summoned in.
he should have just said get out.
Ms. Barron Allen?
Your Honor, prior to proceeding with opening statement, there is one other issue that I would like to address with the court. I do have an exhibit list prepared for the court, and the parties have stipulated to the admission of all the exhibits that I will place of record. And again, we have also stipulated and agreed that these will not be played in open court, but for the court to review these exhibits in camera. So
And most of these are the recordings, the video and audio recordings.
I think all except one is a video and audio recording. So State's Exhibit 1, for the record, is Deputy Popham's body worn camera in unredacted form. State's Exhibit A1A is Deputy Popham's body worn camera. It is redacted. I've captioned that Part 1. State's Exhibit 1A2.
Can I interrupt you a second?
Yes,
Do you have that list?
I do. I have that for the court. So I will
You just
provide.
give it to me, and that way you don't have to read them all.
May I approach? And I also have the. phone
Absolutely. One of these days, I'm going to tell counsel, no, you can't approach, but I'm not sure.
Judge after our own heart.
So, thank you. All right, go ahead.
I do have an opening statement.
Go ahead.
Thank you, Your Honor. May it please the court, counsel. Through the testimony and evidence admitted during this hearing, the state will prove by a preponderance of the evidence that the defendant first did in fact knowingly, intelligently, and voluntarily waive his rights pursuant to Miranda, that his statements were voluntarily given, and that there was no coercive tactics used by law enforcement, and finally, that the defendant did not make an unequivocal request for counsel, but in fact, he only made equivocal and ambiguous statements referring to a lawyer during his interview with detectives at the Claremont County Sheriff's Office. Your Honor, in this case, virtually each and every second of law enforcement interaction with the defendant was captured via video and audio recording, either on body-worn camera worn by various deputies with the Claremont County Sheriff's Office, or via recording equipment in the interview room at the Claremont County Sheriff's Office. Through the testimony presented during today's hearing, as well as the video and audio evidence submitted, the court will be able to examine the totality of the circumstances as opposed to a few selectively chosen statements as listed in the defendant's written motion. When the evidence is viewed in totality, the state will have met its burden by a preponderance of the evidence to prove that the defendant did in fact make a knowing, intelligent, and voluntary waiver of his constitutional rights. We will first present the testimony of two deputies, Deputy Popham and Deputy Rudd. The court will learn from both deputies that while on scene, the defendant was rational to space and time. The defendant understood all orders made by law enforcement and reacted appropriately to each order. While not interrogated on scene, the defendant responded to any questions or comments by law enforcement appropriately and clearly understood not only the communications made with him, but what was going on around him. For example, the court will hear that while not fully Mirandized, on one occasion, Deputy Rudd told the defendant that he has the right to remain silent and that the defendant should use that right. The defendant responded, "Yes, sir," and fell silent for a period of time. You will hear that on multiple occasions, the defendant made statements such as, "I'm not going to hurt anyone," or "I won't hurt any officers." Those statements indicate that at the time, the defendant knew exactly what was happening, who he was interacting with, and that things possibly could go downhill for him should he attempt to injure any officers. You will both see and hear on all videos that there was no interrogation of the defendant while on scene. Deputy Rudd and Deputy Ross will further testify that the detective was transported directly from the scene to the Claremont County Sheriff's Office to be interviewed. And again, even that transportation was recorded on video. Once the defendant was at the Claremont County Sheriff's Office, he was placed into an interview room, again, that the entire time was both video and audio recorded. You'll hear that while detectives prepared to interview the defendant, a patrol deputy remained in the room with the defendant at all times. And again, no interrogation occurs at that time. The deputy asks no questions. You will hear from Detective Ross, who was the lead detective in the interview. And you will hear that the Detective Ross did in fact read the defendant his Miranda warnings, that he read from a card containing those rights. A copy of that card has been submitted for the court's review. As Detective Ross reads the defendant his Miranda warnings, the defendant provides physical indications of understanding, such as nodding. And as Detective Ross finishes the warnings, the defendant immediately indicates that he did in fact understand his rights. After indicating his understanding of his rights, you will see that it is only then that the defendant speaks with detectives. In his motion, the defendant seems to argue essentially that because there was no signed Miranda form and because the defendant did not specifically say the words, quote, "I waive my Miranda rights," that his decision to speak with officers was not knowing or voluntary. However, when reviewing the evidence, it is important to remember that the United States Supreme Court has held that when an express written or oral statement of waiver of the right to remain silent or of the right to counsel, those are usually strong proof of the validity of the waiver. An express waiver is not specifically required for a confession to be knowingly and intelligently and voluntarily made. The Ohio Supreme Court has continued to follow that ruling, holding in multiple cases that, quote, where a suspect speaks freely to police after acknowledging that he understands his rights, a court may infer that the suspect implicitly waived his rights. Your Honor, the evidence presented will show that through both his behavior on scene with Deputy Rudd, as well as his clear indications that he understood his rights after being advised pursuant to Miranda, the defendant did acknowledge that he understood his rights and only subsequent to that acknowledgement spoke with the police, effectively and implicitly waiving his rights. Similarly, the defendant, through his motion, argues that his statements to Detective Ross were not voluntary due to coercive tactics used by the police. However, the evidence that will be presented will prove quite the contrary. You will see that the actual interview of the defendant at the Claremont County Sheriff's Office by Detective Ross and other detectives lasted only approximately 2.5 hours total, some of which the defendant is simply alone in the interview room. You'll hear that the defendant was in his early 30s at the time of the interview, that he held a full-time job at the time of the interview, that he's had prior contact with law enforcement, including prior arrests, that law enforcement did not physically assault or deprive the defendant in any way. And in fact, what you'll hear is that detectives relocated the defendant's cuffs from behind him to in front of him, that he was provided water, asked if he wanted soda, was offered food, was given multiple opportunities to use the restroom, and was provided with dip or tobacco. You will see that the detectives of the Claremont County Sheriff's Office went through great lengths to make the defendant as comfortable as possible during this 2.5 hour time period. There will be absolutely no evidence presented that the defendant's will was overborne and his capacity for self-determination critically impaired because of coercive police conduct. Detective Ross will testify, and the recorded interview will bear out that during the interview, the defendant even indicated multiple times that he was neither nervous nor scared. The defendant's motion also indicates that during the course of the interview, the defendant requested counsel. However, with the testimony of Detective Ross, as well as, again, the video and audio recording of the interview make clear, is that the defendant's statements concerning an attorney can truly be described as nothing other than ambiguous and equivocal. During the interview, the defendant states, I will wait for a lawyer. I don't really know. Like, give me a couple days and let me talk to a lawyer so that way I can get nice, good answers. Detective Ross will explain that the defendant's statement, I'll wait for a lawyer, was immediately followed by his statement, I don't know. And even that unequivocal comment was immediately followed up with the statement, just give me a couple days. Just give me a couple days and let me talk to a lawyer so I can get nice, good answers. You'll hear that despite the fact that the defendant's statements were utterly ambiguous, Detective Ross attempted to follow up with the defendant to clarify whether or not he was actually requesting an attorney. What you will learn is that instead of clarifying and unequivocally requesting an attorney, the defendant actually muddies the water even further. The defendant follows up his statement about, I'll wait for a lawyer, I don't really know, give me a few days, with a request to speak with his dad. He also requests to speak with a woman by the name of Ruby Franklin, who he says is in the CIA. The defendant then acknowledges to Detective Ross,
Sorry, I heard that name.
neither one of those individuals, neither his father nor Miss Franklin, are attorneys. Because the defendant said he didn't know what he wanted to do, asked for a couple days, and requested to speak with two individuals who he knew were not attorneys, Detective Ross did not believe he was making an unequivocal request to end the interview to speak with counsel at that time. It is important to view the defendant's statements in light of other statements examined by courts throughout Ohio. Statements such as, maybe I should talk to a lawyer, I think I need a lawyer, maybe I want a lawyer, I think I would like an attorney, I think I might need to talk to a lawyer, I'd like to have my lawyer here, and do I have to hire an attorney to have him present? All of those statements are among those which have been considered too ambiguous or equivocal to require police to terminate questioning. And the state believes that when the court reviews the evidence and the testimony presented, that the defendant's statements are even more ambiguous than those. The defendant also challenges statements made to Renee Butcher, a mental health liaison who assists at the Claremont County Jail, as well as statements made to nurse Amy Griffin. However, the evidence will make clear that Ms. Butcher is only involved in asking routine booking questions of the defendant. And Nurse Griffin was summoned by the defendant to provide a medical assessment at his request. Accordingly, neither of these conversations rise to the level of a custodial interrogation. The defendant argues alternatively that his right to privacy was violated by the recording and or of the booking questions and or the medical assessment. However, the law is clear that inmates have a reduced expectation of privacy while incarcerated. And finally, the defendant also argues that the recording interactions between Ms. Butcher and the defendant, as well as Nurse Griffin, violate HIPAA. However, the defendant fails to note that HIPAA contains a carved out exception for inmates. Your Honor, the only evidence that will be presented as part of this hearing will show, the evidence that was presented during this hearing will show that the detectives with the Claremont County Sheriff's Office and staff at the Claremont County Jail did everything properly and upheld the defendant's constitutional rights from beginning to end. Accordingly, the state believes that when all testimony and evidence is submitted, the court should deny the defendant's motion in its entirety. Thank you.
Mr. Myers or Mr. Haynes, any opening?
Yes, briefly, Judge.
Mr. Myers.
Fundamentally, we stand by our written motion. We believe the evidence is going to be presented in these recordings speaks not only for itself, but loud and clear in a manner that contradicts everything the state has summarized. First, foremost, and always, they can't have their cake and eat it too. If they want this court to look and see these audio video recordings, and if they want to assert and contend as they have that he was clearly of fundamentally his right mind, then so too they must defer, as the detective should have deferred to and respected, an obvious, clear, unequivocal, I want a lawyer. And as we've outlined in the written motion, as you'll see for yourself when you have a chance to review that interrogation recording, it was the detective who impermissibly continued that conversation, that interrogation, by quizzing, well, which lawyer? Do you have a lawyer? Give me a name of a lawyer. That's nowhere in this controlling law. Everybody knows, we trust, except perhaps for the detectives involved, that when a custodial interrogation is underway and the suspect clearly says, I want a lawyer, that isn't the start of a test. That isn't the start of an officer's an invitation to a detective to quiz about name, rank, and serial number of a lawyer. That's the time they stop. They stop, get up, and go. That's what they should have done. That happened within about 5 minutes of the interrogation. We've got those times outlined for the court's convenience by reference to that interrogation. 45 minutes goes by. He asks again, where's the lawyer? And at that point, he is again ignored. So overall, Judge, with respect to the exercise of his right to counsel, we defer, as indeed we must, to the court's assessment of Mr. Dorman's demeanor during this time. But fundamentally, if he had the wherewithal, as the state asserts, to know his situation, to know where he was, to assure officers he posed them no risk, then likewise, he had the wherewithal to clearly say, I want a lawyer, period. With respect to the Renee Butcher encounter, that's not booking. That's coming on 40 hours after he's been detained. He's already been over to his initial appearance. He's already had lawyers signed on behalf of the Claremont County Public Defender, and he's being questioned about his medical issues and his state of mind in a manner that has nothing to do with booking. It is a matter that should have been private. It should not have been recorded. It should have been conducted in accordance with the normal routine procedures that we understand Ms. Butcher employs when she's doing her assessments of inmates, not at the doorway of their cell, in her office, not with one or two corrections officers with their body cameras operating. So overall, again, we'll defer as need we must at the end to these recordings speaking, we trust loud and clearly that his right to a lawyer was violated, and his right to private interaction with mental health providers was provided, and all those statements should be suppressed.
Just one question. There's not any argument that all the videos, audio recordings that you have been provided have in any way been altered or doctored or anything along those?
None whatsoever, Judge. We defer. I mean, we have stipulated to their admissibility. There are probably a couple of portions in the 2.5-hour interrogation that might be unintelligible to a degree, but honestly, far less than I think we often frequently encounter, is that most of it is really quite clear. Certainly the parts regarding, we contend, the parts of those interrogation interactions regarding the request for a lawyer are crystal clear.
All right.
And we stipulate to their admissibility.
Okay. All right. Thank you. And Ms. Baronell.
State calls Deputy Chad Poplin.
Looks like we might have another funky cameraman on our hands. How old is this fella here? He looks young.
This doesn't need any adjustments, just talk loud enough so the judge can hear what you have to say, okay?
Yes, sir.
Good morning, Deputy.
Good morning.
Can you please state your name and spell your last name for the record?
Chad Popham, Popham.
And how are you employed, sir?
I'm employed at the Claremont County Sheriff's Office.
What is your current assignment?
I'm a canine handler with the Sheriff's Office, ma'am.
And what type of dog do you have?
I have a dual purpose dog. It's a German Shepherd.
You said you have a dual purpose dog?
Yes, ma'am.
What does that mean?
He does apprehension, tracking, drug interdiction.
And so do you have your canine with you every shift you work?
Yes, ma'am.
And how long have you been employed with the sheriff's office?
Just over, a little bit over 10 years.
And as a canine officer, what are your duties on a daily basis?
Just everyday patrol work. I do call outs, stuff like that, answer calls, and go to high priority calls.
And do you work a specific shift?
I work, right now I'm assigned 6A to 6P.
And were you still employed on or about June 15th of 2023?
Yes, ma'am.
And that day, were you operating a marked cruiser wearing the uniform of the day?
Yes, ma'am.
Can you describe what the uniform of the day?
Usually when I'm working the road, I wear BDUs, and like a BDU, long sleeve shirt, radio, gun belt, and body cam.
And when you say body cam, where is that located on your?
It's usually located center of my chest or just a little bit lower.
And when does your body worn camera activate?
When my lights are activated, or if I activate it myself, if my weapon's drawn or my taser is activated.
And on June 15th of 2023 at approximately 4 p.m., were you dispatched to 1965 Laurel Lindale Road, New Richmond, Claremont County, Ohio?
Yes, ma'am.
All right. Where were you when you received that dispatch?
125 in Mount Holly.
125 in Mount Holly?
Yes, ma'am.
And what were you dispatched to that address for?
It was a 911 open line.
What kind of information were you receiving while you responded?
Received that it sounded like a female was crying back saying that her babies were shot. We had called that there was a male shooting children.
And so based on that information, did you respond with lights and sirens activated?
Yes, ma'am.
So your body worn camera would have activated at that time?
Yes.
How long did it take for you to get to 1965 Laurel Lindale from your location?
Approximately 10 minutes.
And again, your body worn camera would have been active that whole time?
Correct.
All right. Based upon the information you were receiving from dispatch prior to your arrival, how are you preparing yourself for what you need to do when you get on scene?
You're trying to figure out, trying to go through your mind of what's going on, how you're going to park your car. You don't want to pull up in front of the residence. You're trying to stay clear on the radio, try to get radio traffic out to other deputies coming in.
So you are communicating with other deputies as you respond?
Yes, ma'am.
And when you got to 1965 Laurel Lindale Road, what did you do initially? Where did you park?
I parked up from the residence with another deputy.
Why did you do that?
Just didn't know what's going on. Someone with a gun, you don't want to park in front of their drive just in case if they're in the drive shooting or anything like that, just so you're out safely and able to respond.
So more of a tactical approach.
Yes, ma'am.
Okay. And so when you arrived and parked, what did you find?
I was there with another deputy. We were responding up to the residence. There was a male sitting on the porch of the residence, and there was a female appeared to be giving CPR to 3 children in the front yard.
Okay. Male on the porch, did you see anything around the male or what he was doing when you arrived?
The male was sitting on the porch.
Wasn't me
It
for
looked like he had a firearm, what appeared to be a firearm on the left side of him, sitting on the porch next to him.
The individual who was sitting on the porch next to the rifle, do you see him in the courtroom today?
Yes, ma'am.
Can you please point to him and describe where he's seated and what he's wearing?
There'd be a gentleman right here in the first seat, has a blue shirt, blue suit.
The record will reflect identification of Mr. Dorman.
Thank you. And who was the other deputy that you were with when you first responded?
Deputy Sparks.
So once you observed who you identified as the defendant sitting on the porch near a rifle, did either you or Deputy Sparks give commands to the
Yes,
defendant?
ma'am. While we were approaching the residence, we were advising the male to stand up and lay on the ground.
All right. Did he comply?
He didn't comply to that. He raised his hands, like showing like he didn't have a firearm or anything like that in his hands, but he wouldn't stand up, walk away from the residence, or lay down on the ground.
And as you were giving commands, what were you and Deputy Sparks doing?
We were approaching the male.
And were you able to make contact with the male at that time?
Yes, ma'am.
And so when you made contact, what happened?
Deputy Sparks grabbed the male by his arm, put him on the ground. I kept him at gunpoint at that time. Then once he was on the ground, I holstered my weapon and handcuffed Mr. Dorman.
And I'm just going to note for purposes of the record, at approximately 2 minutes and 15 seconds into State's Exhibit 1A1, which is your body camera video. Your body camera video was still active at that time, correct?
Yes, ma'am.
All right. And at that point, did the defendant begin to speak to you?
Yes.
Were you asking him questions or?
No, ma'am.
Okay. Do you recall what he said?
He advised that he didn't want to hurt nobody, that he didn't take any drugs. He's never took any kind of drugs. And he was concerned about his dog staying inside, not biting any of the deputies on scene.
And all of those various statements that he didn't want to hurt anyone, that he wasn't under the influence of drugs, and other statements about his dog, was that in response to any question that you had asked?
No, ma'am.
And once the defendant was cuffed, did you ask him any questions?
I did. I think I asked him what was going on. He implied that he wanted to roll over, and he was reassuring that he wasn't going to hurt anybody.
And when he asked you if you could roll over and indicated he wasn't going to hurt anyone, did you respond to him or have any further conversation?
I asked him if he had anything in his pockets at this time. Mr. Dorman stated that he had a cell phone in his pockets. I found a cell phone. I think I tossed it over towards the porch. And then he was still reassuring that he wasn't going to hurt nobody. And just be careful of his dog. His dog shouldn't come outside the house.
And once he reassured you that to be careful of his dog and that his dog wouldn't bite you or anything, did you ask him any further questions?
I think I asked him again what was all going on. And I think he said he was uncomfortable to see if he could roll over and stand up.
Okay, so he again kind of reiterated to you that he wanted to get up.
Yes, ma'am.
At that point, did he say anything further about not running away or not hurting officers or anything?
I believe the whole time while we were speaking, he was reassuring that he wasn't going to hurt nobody. He wasn't running away. Like I said, he was assuring that his dog wasn't going to bite no one. Just don't reach for his dog.
Okay. And when he requested to stand up because he was uncomfortable, what did you do then?
I actually stood Mr. Dorman up. There was a camper to the right that was away from the firearm and the children behind us. We responded over there.
And as you responded over towards the camper with the defendant, did you ask him any other questions?
I asked him just for safety if there was anyone else inside the residence at this time.
And did he respond?
He said there's no one else in the residence, and he stated that his daughter ran over towards the fire department.
And after that conversation, did you reach the camper?
Yes, ma'am.
All right. And what happened when you reached the camper?
Deputy Rudd responded. He arrived on scene, and I handed him off to Deputy Rudd.
And what was the purpose of handing him to Deputy Rudd?
Deputy Rudd responds. So like I said, I handed him off, and then I turned around and tried to give aid to the children in the front yard.
Okay. And at some point after that, or any point after that, did you have further contact with the defendant?
Yes, ma'am.
And can you describe what that contact was?
So Deputy Rudd detained Mr. Dorman in the back of his car. Deputy Rudd advised that Mr. Dorman was banging his head on the window and the partition in the vehicle, so I responded back to the vehicle.
Okay. And again, for purposes of the record, we'd now be at States Exhibit 1A2. So when you responded to Deputy Rudd's vehicle, what did you do?
I asked Deputy Rudd if we had the wrap system or he had a like a safety helmet that we put on subjects if they're banging their head so they can't harm themselves in the vehicle. I asked him if he had one and advised that he did. So we went back to the vehicle. I opened the door and made contact with Mr. Dorman.
Okay. And when you made contact with the defendant at that time, did you speak with him?
Yes, sir.
What'd you say?
I asked him what's going on. Why is he banging his head? He said it was extremely hot in the back inside of the vehicle. And I asked him if I needed to put the helmet on him. He just said no. He ain't going to hurt himself. It's just hot inside the vehicle.
So when he indicated that he was just banging his head because it was hot and that he wasn't going to hurt anyone, what did you do for him?
I rolled down the windows. Mr. Dorman complained that his cuffs were too tight. So I ended up checking they weren't too tight, and I made sure that they were locked in place.
So as you were discussing essentially the temperature in the cruiser with the defendant, he indicated to you that his cuffs were too tight, and you confirmed that they were locked in place and
Yes.
weren't going to be too tight.
I just made sure they were re-locked in place.
Okay.
Make sure everything was fine.
And after you did that, did you then also have the windows of the cruiser rolled down for
Yes,
the
ma'am.
defendant? Who rolled down the window?
Deputy Rudd.
And when he rolled down the window, do you recall how far he rolled down the window?
Maybe halfway.
And can you describe what was going on at that time when you were at the cruiser dealing with the defendant, kind of talking to him?
There are several deputies nearby. Our radios are going off. EMS is on scene. Fire trucks are on scene.
So fair to say there were multiple cruisers in the area at that time?
Yes, ma'am.
Did all of those cruisers have their engines running?
I would assume so, yes.
Okay. And you indicated that your radios were going off. Is
Yes, ma'am.
part of the uniform of the day wearing a radio?
Yes, ma'am.
And where is that radio located?
On your shoulder of your non-dominant hand.
Okay. And does every deputy who's in uniform wear one of those radios while on duty?
Yes, ma'am.
Okay. And you indicated that radio communications were continuing at this time when you had contact with the defendant. Is that right?
Yes, ma'am.
Okay. And you indicated previously that you're a canine officer, correct?
Yes, ma'am.
Did you have your canine with you that day?
Yes.
Okay. And was your canine barking at that time?
At that time, yeah, 'cause, it was barking. Yes, ma'am.
Okay. And were there any other noises or anything going on at that time that you can recall?
No, ma'am.
Now, at some point while you were at the cruiser, after having dealt with the defendant, did detectives come by?
Yes, ma'am.
Okay. And do you know a detective by the name of Detective Schubert?
Yes, ma'am.
And did Detective Schubert specifically come by the cruiser?
Yes, ma'am.
And did Detective Schubert ask you something at that point?
He asked if that was Mr. Dorman in the back of the car.
Okay. And are those the words he used?
I think he says that motherfucker in the back of the car.
And when Detective Schubert asked you, is that motherfucker, where were you?
I was standing, I think, near the rear door, right where Mr. Dorman would be sitting in the vehicle.
Okay.
So
And
the driver's side of the vehicle.
driver's side, rear passenger
Yeah.
door? Okay. And was the door closed?
Yes, ma'am.
But you indicated the window was rolled down maybe halfway.
Yes.
Okay. And all the kind of extra noise that you just testified to, was that still going on?
Yes, ma'am.
And where was Detective Schubert in comparison to you when he asked that question?
He was walking by the vehicle 10, 15 feet, maybe 20 feet.
And when the detective said that, did he stop walking?
No, ma'am.
Okay. Now, did Detective Schubert say anything else to you?
He said, shut the door before I kill that motherfucker.
Okay. And so, again, the door to the cruiser was shut at that time?
Yes, ma'am.
Where was Detective Schubert when he said that?
He was continuing walking. He never stopped. He just continued walking by.
And so was he even further away from you when he made that second statement?
Yes, ma'am.
Okay. And when Detective Schubert said that, did the defendant give any indication that he had heard that statement?
No, ma'am.
May I have one moment, Your Honor? Thank you, Deputy. Nothing further at this time. Hold on. They're going to have some questions probably.
Good morning. How you doing?
Was your canine deployed with you as you approached the house?
No, sir.
It stayed in your vehicle
Yes, sir.
throughout the whole time you were on scene?
Yes, sir.
As you approached with Deputy Sparks this scene, I think you've mentioned that you saw, did you first see Mr. Dorman sitting on that concrete stoop?
Yes, sir.
And it's just a short 8 or 10 inch high kind of concrete pad leading right into one of the entry doors of the house.
Yes, sir.
And as you approached, you and Deputy Sparks were hollering commands fairly consistently.
Yes, sir.
You each had weapons drawn.
Yes, sir.
And as you begin to approach and bring him into your eyesight, taking care for safety and procedure, coming up at an angle, right?
Yes, sir.
When you first saw him, were you roughly the distance of this longer width of this courtroom or even further?
Probably a little bit farther, sir.
And approach both you and Deputy Sparks, guns drawn, commands being hollered, you're obviously being cautious, you're worried.
Yes, sir.
Sadly, the wife is crying, screaming. Remember those sounds?
Yes, sir.
You and Deputy Sparks are the first law enforcement responders at the scene.
Correct.
Others are others arriving around the time you're getting close to that concrete stoop?
No, sir.
And as you approach a distance longer than the long width of this courtroom, Mr. Dorman took no step, took no action that was threatening in any way.
Correct. Like I said, he didn't. He just raised his hands.
The gun you mentioned was like a hunting rifle,
Yes, sir.
and it was within his reach,
Yes, sir.
but not in his hand.
Correct.
He never made a move to reach for the gun.
Correct.
His wife, that was to his left. His wife was to his right, maybe no further than we are together in this courtroom.
Correct.
That's, what do you think, 10, 12 feet?
Approximately.
And all the while, he sat there. He didn't yell back at you, did he?
No, sir.
He seemed kind of stunned, didn't he?
He was He was just like just raising his hands. I mean, he wasn't saying nothing. I don't know if he was stunned. I don't know how he was acting. Like, he wasn't being aggressive or anything in that means, but.
And even as you got to the point where your cohort deputy Sparks could reach and touch, grasp, put him onto the ground, belly down, right?
Correct.
Then he's cuffed, and you said you cuffed him.
Yes, sir.
And take him a distance maybe from where I stand to the judge's bench, which is where that little house trailer, that little recreation vehicle.
Yes, sir.
And then you pass him off to Deputy Rudd is now at the scene.
Correct.
And Deputy Rudd has to walk him some distance down to the end of the driveway, turn left,
Yes.
and walk a pretty good distance up where his vehicle is parked, right?
Correct.
And then later, how much later was it that you got alerted to the headbanging problem?
Honestly, I couldn't tell you how long it was between there and the
Things
time.
were chaotic. Time passes strangely, if I can put it that way, in that kind of chaos. Is that fair?
That's fair.
And it wasn't right away. It wasn't, within minutes that you were alerted to the headbanging. It wasn't.
No, sir.
And when you got down to where Deputy Rudd had this doorman in the back of his cruiser, it was a hot day, hot summer day,
Yes, sir.
and the windows were up in the cruiser.
Yes, sir.
There was no air conditioner running in his cruiser.
Air conditioning runs. I just don't think there's any rear vents in that vehicle. So
Do you even know if the vehicle was on?
when I was there, the vehicle was on. Yes, sir.
And when Detective Schubert walked by, how long do you think it was between your initial interaction with Mr. Dorman about the cuffs and the heat in the back of the cruiser?
Within a couple of minutes, like I said, I was, after I was done dealing with him, I was in the process of like shutting the door when Detective Schubert passed.
And as he's walking past, do you remember whether the door had already closed?
I was shutting it, or it was already, like, it was shut by the time he was passed.
And that's of course depicted in the body cam. That's going to go into evidence here.
Yes, sir.
And did you have a chance to review that body cam to refresh your record?
I have not watched that body cam almost since after the day it happened.
And the body cam, of course, speaks for itself, but is it your recollection that Detective Schubert he's walking from the driveway down towards other houses and other law enforcement?
So how we were parked, like you mentioned earlier, if you leave the driveway, you hang a left on the roadway, and he was headed up from the roadway past our vehicles. Like he was walking towards the rear of our vehicles, not back towards the residence.
Right, he's walking away from the residence.
Yes, sir.
And Deputy Rudd's vehicle was an SUV,
Yes, sir.
and it was to Schubert's left.
Yes, sir.
And as Detective Schubert walked by that vehicle, it might begin to approach you.
Yeah, that's fine.
How far away do you think he was when he made those statements?
Look, if you passed the car, I would say maybe about where the stand for the judges, sir.
Could he have, as he walked by, could he have touched the side of the cruiser? Was he that close?
I don't believe so, because I was standing in between him and the cruiser.
And you heard what he said.
Yes, sir.
Does it seem uncommon to you a little bit? He was agitated?
I'd say so, or at least upset.
Do you have a sense of how much time passed then between those comments made by Detective Schubert and when you left that vicinity of the Deputy Rudd's cruiser?
I couldn't tell you, sir, because after I was done dealing with him, a lot of us that were the first ones responded just stayed in that area. I'm not saying I stayed right next to Deputy Rudd's patrol vehicle, but I'm pretty sure I was parked directly behind Deputy Rudd's. I was in that area till.
And do you have a sense of how much time passed between made by Detective Schubert and when Mr. Dorman left the scene in the custody of one of your colleagues?
No, sir.
It was some period of time, fair to say. I mean, it wasn't like.
It wasn't immediately.
Right.
Yeah, it wasn't immediately after Detective Schubert made the comment, but I couldn't tell you if it was 10 minutes or 20 minutes. Thank you.
Did you redirect?
No, Your Honor, thank you.
All right, thank you, Deputy. You can step down.
Thank you, Judge.
Next witness.
Deputy Rudd, Your Honor.
Okay.
Yes.
Judge, prior to his testimony, may I inquire whether I have not asked him whether he would care to be videotaped or not.
I'm sorry.
I have not asked Deputy Rudd whether he prefers to be videotaped or not. May I ask him prior to his testimony?
Yes.
Thank you.
Go right ahead.
Yes, sir.
Good morning, sir.
Morning.
Would you please say your name and spell your name for the record?
Deputy Jeffrey Rudd, Jeffrey Rudd.
And where do you work, sir?
Claremont County Sheriff's Office.
And how long have you worked there?
Total of 22 years.
And prior to that, did you have any law enforcement experience, sir?
I did part-time at the village of Felicity PD while I was working at the jail.
How did you go about becoming a deputy for Claremont County, sir?
I spent 5 years in the jail. During that time, I went to the basic police academy, then got a POTA certified.
Okay. Would you please describe briefly for the court your ranks or positions that you have held for Claremont County Sheriff's Department?
I've held the rank of deputy my entire career.
Okay, great. Currently, what is your assignment?
Traffic safety unit.
All right, thank you. June 15th of 2023, were you working for Claremont County?
Yes, sir.
Okay. And what were your duties on that day, sir?
Regular patrol.
Just regular patrol? Okay. And what was your shift, if you recall?
It's 8 in the morning to 6 in the evening.
Okay. What was your dress? Was it uniform of the day?
Uniform of the day.
And what would you typically wear as a uniform of the day?
My uniform typically of the day is a pair of black BDU pants with a black BDU shirt.
Okay. Clearly marked police, etc.
Yes, sir.
Gun belt, radio. et
Gun
cetera.
belt, radio, has sheriff's patches on the sides.
Okay. Thank you. Now, sir, you're on patrol. What type of vehicle were you driving?
A Ford Explorer that's marked with yellow stripes, has the big sheriff star on the doors,
Okay. So,
lights on top.
So an Explorer type cruiser that we're all familiar with?
Yes, sir.
Okay, great. Thank you. Did you have a partner on the day in question?
No, sir.
Okay. At the time of this incident, June 15th, were you equipped with a body cam device, a camera?
Yes, sir.
Okay. And where would that be positioned on your body, sir?
Where it's at right now, about the center of my chest.
Okay. Is that the same body cam?
Yes, sir.
Okay. And sir, was it working on that day, if you recall?
Yes, sir, it was.
Okay. And of course, the incident we're here to discuss, was your body cam on when you were at the scene?
When I was at the scene?
Yes.
Yes.
Okay. And sir, you had the opportunity to review the footage of the scene?
Yes,
The
sir.
day in question. Okay. Is it a fair and accurate reflection of what occurred on that day?
Yes, sir.
Okay, great. Let's see. So referring back, June 15th, about 4 p.m., did you become involved in the investigation of an unfortunate shooting of 3 children in the area of 1965 Laurel and Dale Road?
Yes, sir, I did.
Okay. And that, of course, is the incident we were speaking about. How'd you become involved in that investigation, sir?
I was finishing up a traffic stop on Linda Mount Holly Road, which is roughly probably 5 or 10 miles away from where the incident occurred. While I was finishing up the traffic stop, I overheard on my radio of the incident that came out. I finished my traffic stop and immediately went en route to the scene.
Okay. And once you began going to the scene, were you updated on possibly what was going on at the scene?
We was.
Okay. And how were you updated in that way?
Our communications center let us know over the radio that was possibly a grandfather shooting. Then we got reports of a of the fire department that's pretty much right across the street was being shot at. Then we got told that there was a male out in the front yard shooting. And then that's when 2 of the deputies arrived on scene not too long after that.
Okay, were you notified that other deputies had arrived prior to your arrival?
Yes, sir.
Okay. Now, sir, although we're not playing them, I'm going to refer during your testimony to some times from our previously stipulated states exhibits 2A and 2B. That would be your body cam, is that correct?
Yes, sir.
Okay, so your body cam in this case actually is recorded into 2 separate pieces of footage. Is that fair to say?
Yes, sir.
Okay, but again, you stated accurate reflects your time on scene.
Yes.
All right, thank you. Once you arrived, where did you park, sir?
I parked on Laurel Lindale Road behind 2 police cruisers that were already on scene.
Okay, and how did you proceed once you arrived?
Once I arrived, I got out of my car. I proceeded to walk up to the gravel driveway. As I was walking up the gravel driveway, to my left, Deputy Sparks was performing CPR on one of the children in the front yard. When I walked past him, I looked up, I seen Deputy Popham had the defendant already handcuffed and was standing up against a shed, I believe.
Okay, and about 30 seconds into the footage of States 2A, is that when you reached the defendant and put him into custody?
Yes, sir.
Okay, and what'd you do once you reached the defendant?
Once I reached the defendant, I grabbed him by his left arm. I walked him back down the driveway, out on the Laurel Lindale Road, and walked him back to my cruiser.
Okay, and when we say the defendant, do you see that person here in the courtroom here today?
Yes, sir.
Okay, would you please point to him and describe what he's wearing?
Gray suit jacket.
Record will reflect identification of Mr. Dorman.
Okay, you said you took him by the left arm and walked him back out on the Laurel Lindale and down to your cruiser, is that correct?
Yes, sir.
Okay, and from about 1:07 to 1:13 time frame of States 2A, did you have a discussion at that point with the defendant?
As I was walking him back to the car, the defendant asked about his wallet in his back pocket.
Okay, was this in response to any question by you, sir?
No, sir.
Okay, so he just asked that of his own volition?
Yes, sir.
Right, thank you. Did you answer him?
I did.
And what'd you say, sir?
I told him to shut up. And also during that, I told him he had the right to remain silent, to fucking use it.
Okay.
I'm sorry, what was that last comment? You said you,
I told him he had the
Told him
right to remain silent, to fucking use it.
Okay. And did he respond to you, sir?
He did.
And what did he say?
Yes, sir.
Okay. And what did you take that yes, sir to mean?
That he understood I didn't want him to talk.
Okay. Did you say anything further to you at that time, sir?
No, sir.
Okay. And about 1:16 into States 2A is when he said, yes, sir. Is that correct?
Yes.
That'd be 1:16 in. Okay, thank you. How'd you proceed at that point once he says yes, sir?
Once I got him back to my car, I patted him down due to policy and procedure. I took out a wallet, a set of keys, and a can of dip. I set those items on the rear bumper of my cruiser. I then placed him in the rear of my cruiser,
Okay. And which door did you place him in, sir?
the driver's side passenger.
Okay. So this is a 4-door Ford Explorer. So it'd be the rear door on the passenger side?
Driver's side.
Driver's side, excuse me, driver's side.
The passenger side, there was a deep ditch I didn't want to walk him down into.
Okay, great. Thank you. At that time, did you have any discussion with him or ask him any questions, sir?
No, sir.
And you described that you walked him from initially where he was placed in cuffs back to your cruiser. Did he resist you in any way, sir, during that time?
No, sir.
Okay. Did he pull away?
None at all.
Was he able to follow your commands?
Yes, sir.
And you described the discussion that you had with him briefly, correct?
Yes, sir.
Okay. During that walk and quite frankly, during the time on scene, what was his demeanor, if you can describe it for the court?
He was very calm, just like a normal day.
Okay.
He didn't seem agitated, wasn't confused, just calm as could be.
Did it appear to you that he understood what was going on?
He did.
Once the defendant's placed in the cruiser, you place his wallet, et cetera, into evidence. Is that correct?
Yes, sir. I placed it in a brown paper bag.
Okay. Now, during the entire time that you were at the scene there with the defendant in your cruiser, are you in his vicinity, sir?
Yes, sir.
Did you ever go anywhere else?
I would walk back and forth between other officers. They were asking me for stuff, but I was never that far away from the car.
Okay, well, you were within about 15, 20 feet of that cruiser the entire time you were there. Is that correct?
Yes, sir.
Thank you. Now, about 7 minutes, 12 seconds in the state's Exhibit 2A, you're able to hear some radio chatter. Hey, Chad. What was that in relation to, sir?
They were asking Deputy Popham for something over my police radio that I
Okay,
had on my shoulder.
Okay, so that wouldn't be referring to the defendant, is that correct?
No, sir.
Who also happens to have the first name Chad, is that correct?
Correct.
Thank you. And now, moving on to previously stipulated State's Exhibit 2B. This would be your second set of footage, about 11:25 in. The defendant stated to you, you're able to hear, hey, can I go outside? Is that correct?
Yes, sir.
Do you remember that?
I do.
Okay. Was that in response to any questioning by you, sir?
No, sir.
No, okay. And how were you able to hear him? Was his window down just a little bit?
At that time, it was not, but I had the back hatch to the Explorer open. Because that way I could see him a little bit better.
Okay, so you can hear through that, sir?
Vaguely,
Meaning-
yes.
I'm sorry, meaning in that passenger compartment, you could hear.
You can hear him.
Thank you. Did you respond to him?
I asked him what.
Okay. Other than that, did you have any discussion, sir?
No, sir.
Thank you. Now, about
Hey, Christy, welcome.
17:45,
Glad you
State's
got to
Exhibit
make it
2B,
live.
You call out, hey,
Beaver.
Chad, and the defendant responds something, but it appears he says something to you. Do you recall that, sir?
I do vaguely.
Okay. Were you calling out to Deputy Popham?
Yes.
Okay. And would you explain that to the court?
While I was in the back of my cruiser watching the defendant, I noticed that he started to bang his head on the front part of my cage that separates the driver compartment to the rear compartment.
Mhm.
And that's when I yelled for Deputy Popham to come to assist me in making sure that he didn't harm himself.
Okay. And did Deputy Popham, in fact, respond?
He did.
Great, thank you. What happened once Deputy Popham responded, sir?
When Deputy Popham got there, I went to the back of my cruiser. We have a padded helmet that we can put on a suspect to keep him from harming himself. So I went back and got that. At that time, Deputy Popham opened the door. When the door got open, the defendant said it was hot as crap back here and that his cuffs hurt.
Okay. Just prior to Deputy Popham actually making it to that door, did you actually go to get that helmet, sir?
I did.
Okay. And at that time, about 18:07, so it's 18 minutes, 7 seconds in the State's Exhibit 2B, did the defendant yell out, "Take my ass to jail"?
He did.
Okay. So was that in response to anyone asking him a question, or was that just a voluntary statement of
It was
his?
just a voluntary statement if I asked him anything.
Okay. Did you respond to him at all?
I did not.
Did you ask him any questions based on that?
I did not.
Okay. And at that point, then about 18 minutes, 23 seconds in the footage of State's Exhibit 2B, is that when Deputy Popham was able to arrive?
Yes.
Oh, great, thank you. And would you please explain to the court the interaction between you and Deputy Popham and the defendant at that point once Popham arrives and opens that door?
Once he opened the door, the defendant said that it was hot as crap back here, that his cuffs hurt. Deputy Popham then went to adjust his cuffs, get them a little bit looser, and to double lock them. That way, when he sits back, they don't automatically clamp down on his arm.
Okay.
I was asked to turn the AC on in the cruiser.
Mhm.
However, my particular car does not have rear AC.
Okay.
So it does get quite warm back there. So I did go up to the front. We turned the front AC on, full blast, and then we rolled the windows about halfway down.
Okay, great. Other than the defendant asking if his cuffs would be loosened, did he say anything else, sir?
No, sir.
Okay, do you recall him saying, "I will not hurt anyone, I will not hurt a cop," or anything?
He did say that quite often.
Okay. Did he say, "I'm not going to hurt anyone, I'm not going to hurt myself"?
He did.
Okay. Were you able to hear that because the door was open, he was
The
speaking?
door was open at that time, yes.
Okay, so you heard that clearly, sir?
Yes, sir.
Thank you. What did you take those statements to mean from the defendant, if anything?
That he knew right from wrong, that he didn't want to hurt nobody else, that he wanted to comply with what we was saying to him.
Okay. Now, Deputy Popham was the one that was actually physically interacting with the defendant, is that correct?
Yes, sir.
Okay, did you go around the cruiser to help adjust his seatbelt?
I opened up the passenger door to hand Deputy Popham the other part of the seatbelt.
Okay, and why'd you go over there?
The seatbelt it's a long seatbelt. It's not your typical car seatbelt.
Mhm.
So it's really loose. So when you undo it, it kind of has a tendency to go across the, on the other side of the cruiser. I didn't want Deputy Popham to have to reach across, so I went around to the passenger side and handed the,
So now both doors are open. Is that fair to say?
yes, sir.
Okay, were you able to hear any conversation between Deputy Popham and the defendant at that time?
No,
Did Deputy Popham ask him anything other than in relation to his cuffs?
no, sir.
Okay, did you ask him anything?
No, sir.
Did the defendant say anything else
No, sir.
that you recall?
No, not that I recall, no.
But during that time period, was he able to follow commands?
He was.
Okay. Did he seem disoriented, out of it?
No, sir.
Did he seem to know what he was doing? I mean, he said he was hot. He was aware he was hot.
Yeah, he said he was hot, that he didn't want to hurt nobody. So
He was aware that his cuffs were a little tight. Is that fair to
he
say?
was aware his cuffs were tight also, yes.
Thank you, sir.
Well, they're not made to be
Okay,
comfortable.
Sir, are you familiar with or do you know a person by the name of Detective Sean Schubert?
I am.
Okay. Did you happen to see Detective Sean Schubert on the scene that day?
I did.
Okay. Was he in the area while Deputy Popham was adjusting the defendant's seatbelt, cuffs, etc.?
He was walking down Laurel Lindale to his IMV car.
To his IMV car. Okay. Well, let's discuss that, sir. So, if you were looking at your vehicle on the passenger side and the defendant is here, let's say, which way would he have been walking? Towards the house or towards his vehicle?
Towards his vehicle,
Okay,
away from the scene.
Away from the scene. So that would be toward your hatchback. Is that fair to say?
Yes,
In the direction of your hatchback?
yes.
Where was he, if you recall? You say he's in that direction, but where was he in relation to you, sir?
He was, so it's a 2-lane road.
Mhm.
He was on the opposite, on the opposite side of the traffic.
Uh-huh.
And he was probably 15, 20 feet as he was walking past us.
He was past you?
Yeah, he was past us.
Okay. Do you recall him saying anything?
I did.
Okay. And whom was he speaking to? Do you know? Could you tell?
I really couldn't tell.
Okay. And what did he say, sir?
He just asked if that was him.
Okay. Do you recall particularly specifically what he said, sir?
He specifically said, "Is that the motherfucker?"
Okay. Did he say anything else?
He did. He said, "Shut the door before I kill the fucker."
Okay. Gotcha. And that would have been about 19 minutes and 30 seconds in the State's Exhibit 2B. Is that fair to say?
Yes, sir.
Okay, great. Now, Detective Schubert, as he was saying that, was he walking towards you or was he walking away?
He was walking away.
Okay, did he turn around and stop to say that, or did he kind of say it over his shoulder?
He said it over his shoulder as he continued to walk.
Okay. Was he yelling? Was he screaming, or was it just more
It was just
conversation?
normal conversation tone.
Okay, just
How me and you was talking right now.
okay. Now, straight down. Did Detective Schubert ever stop and come back and confront the defendant in any way?
No, sir.
Okay. To your knowledge, did the defendant ever acknowledge that he heard what Detective Schubert said?
No, sir.
Did
I
he-
was right by the back door. He never acknowledged it all.
Okay. Were you looking at the defendant? Did you happen to notice if he saw? Or
No,
did
I
he
was
give-
not looking at him.
Did he give you any indication at all?
No, sir.
Thank you. All right. Now, just in speaking about the general area around the cruiser, what was the surrounding sound like? What was it like at the scene on that day?
It was very loud.
Okay.
You had numerous cars running. My car in particular had the AC on full blast.
Okay.
It had the radio inside the car on. You
Okay.
had dogs barking. You had birds. You had ambulances going back and forth. You had several officers walking up and down the street with their radios on. They were talking. It was very loud.
Okay. So the radio that you were wearing on that day, you have a radio in your car and you also have a personal radio. Is that fair to say?
Yes, sir.
And is it similar to the one you're carrying today?
It's the
Or-
same
I'm
one.
sorry, wearing today?
It's the same one.
Same one, okay. And at the scene, sir, are you aware, were you and all other deputies on the scene, were you on the same channel?
Some are on our private channel, which is C1.
Okay.
And then some of the officers are on regular primary channel,
Okay.
which I was on primary.
Okay. So while you're on primary or on another channel, are you in control at all of what's coming on over the radio?
No, sir.
Okay. And does that sound come out of the handset that's by your ear?
Yes, sir.
Okay. So if in fact you and another officer beside you were on the same channel and you receive information, it's actually two radios playing at the same time. Is that correct?
Yes.
Okay. So that's even louder. Is that fair to say?
Yes, sir.
Thank you. Now, sir, how long have you used a cruiser of the type that you were driving that day?
Probably the last 10 years.
Okay, so you're pretty familiar with the one you were driving on the day in question, is that fair to say?
Yes, sir.
Okay, now you described that the tailgate was open. Is there a partition between that back passenger area and the trunk area, for lack of a better word?
There's a thick piece of plexiglass.
Okay, are you able to hear through that, sir?
You can, but you have to yell quite loud. You really can't hear it if you're just talking normal.
Okay, and you said that there's a partition, I believe, between the driver's area and that rear passenger area. Is that correct?
Yes, sir. It's
Okay.
another thick piece of plexiglass.
Okay, it's not like bulletproof glass, right?
No,
But it's pretty thick.
it's pretty thick.
It's pretty thick. Were you able to hear the defendant though when he yelled loudly?
You can hear him if they yell loud enough.
Okay, great. As you've described before, when he yelled, "Take my ass to jail." Is that fair to say?
Yes, sir.
Okay. Now, following the interaction with Deputy Popham that you described, et cetera, did you again remain near the cruiser?
I did.
Okay. And did the defendant on occasion exclaim or yell or say things you were able to hear?
He was yelling stuff that
Okay. About 30 minutes, 10 seconds in the State's Exhibit 2B, do you recall the defendant exclaiming something and then just yelling, "Take me to jail"?
I do.
Okay. Was that in response to any question? Was that in response to or was that just voluntary, sir?
It was just voluntary. Nobody asked him nothing.
Okay. And about 32 minutes, 22 seconds in the State's Exhibit 2B, do you recall the defendant exclaiming something that sounds a bit like, "She started the whole fight with me"? Do you recall that?
I do.
Okay. And then he continues to yell some things, but were you able to understand what he was saying?
Not really. Ever like mumbles.
Okay. About 35 minutes even in the State's Exhibit 2B, the defendant calls out, "Hey, bud."
Hey, that defense attorney sitting over there to the left is watching the body cam footage. I just now noticed it. Just FYI. If this guy stays out of the way.
Bud. Do you know who he was yelling to, sir?
I have no idea. I don't know if he was yelling to me.
Okay. Did you respond to him?
I did.
Okay. What'd you say?
I asked him what.
Okay. Did you have any other discussion at that point?
He never answered me.
Okay. Thank you. So do you have any idea what that was in reference to?
I have no idea.
Thank you. About 35 minutes and 23 seconds in the State's Exhibit 2B to 40 minutes, 40 seconds in the State's Exhibit 2B. So about 5-6 minutes there. It appears your sound goes off on your body camera footage. Can you explain that for the court?
So Lieutenant White came up to me and we started discussing on how we was going to get my cruiser out. So when we started discussing tactical and strategies on that, I went in and I muted my body cam.
Okay. Was that for any purpose other than to just keep that tactical discussion off of camera?
Just to keep that private.
I don't think so, Gabrielle. I think
I do believe I misstated something, sir. That was 23 minutes.
yeah.
35 minutes, 23 seconds in the State's Exhibit.
That's why they keep giving times, because they stipulated to it, so the judge is going to watch it in his chambers, and that's why they keep giving the times. So I'll play it sometime, but I don't believe they're going to play it during this hearing. I think that's what they were talking about at the beginning when she said they stipulated to, and he said, "Do you have a list? You don't have to read it all." And so if you listen, they're saying at 2 minutes and 10 seconds or whatever. I think that's so the judge knows where they're talking about. But he's not watching it now, but that defense attorney was watching it a minute ago. I just didn't catch it right away.
Exhibit 2B to about 46 minutes, 21 seconds. Pardon me. But during that time period is the discussion you just described for the court?
Yes, I was just trying to figure out if family members were still up near the firehouse, which I would have to go up, make a U-turn to come back. I didn't want to put my cruiser anywhere near the family just for safety reasons.
So for the safety of yourself, the defendant, everyone?
Yes, sir.
Great. And about 46:21, the sound comes back on. Did you do that, sir?
I did.
Thank you. About 40 minutes, 40 seconds in the State's Exhibit 2B, it appears that you enter your cruiser and start the engine and begin to pull off. Where were you going, sir?
I was heading back to the Claremont County Sheriff's Office.
Okay, and was that a part of the discussion you discussed that you just described about where you were going to go, how you were going to get the defendant
Yes,
away,
sir.
et cetera? Okay. Did you stop along the way?
I did.
Okay, and do you recall why?
As I was transporting the defendant, I could see him in my rear view mirror. I noticed that the seatbelt had came off, and then I noticed what appeared to me that he was trying to wrap the seatbelt around his neck.
Okay, but either way, something was going on with the seatbelt. You wanted to stop.
Yes, sir.
Okay, and that would be about 49 minutes and 5 seconds in the State's Exhibit 2B. Is that fair to say?
Yes, sir.
Okay, great. Were you alone at that time?
I was.
Okay. Was anyone following you?
Detective Ross was following behind me.
Okay. And how did you proceed once you see the defendant sort of?
We came to the intersection of Lake Cock Cutoff and State Route 222.
Okay.
I notified my communications center that I was stopping because the defendant had gotten out of the seatbelt. I got out of my cruiser. When I got out, Detective Ross pulled up behind me. He also got out. I got a pair of gloves out of my back of my hatch. I walked back up, opened the driver's side passenger door, and told the defendant to sit back while I adjusted his seatbelt.
Did he say anything to you at that time, sir?
He just said his cuffs were hurting so bad he couldn't sit back.
Okay. How'd you respond?
I told him that he had to sit back. So he then sat back. I repositioned the seatbelt and made it tighter to where he wouldn't be able to slip out of it.
Okay. Did you adjust his cuffs at all?
I did not.
They had already been double locked so that they wouldn't be tight. Is that correct?
Yes, sir.
Thank you. Did you have any other discussion with the defendant at that time?
I did not.
Okay. He was able to follow your command to sit back.
He did.
Thank you. Did Detective Ross have any conversation with him at that time?
No, sir.
Ask him any questions? Did he say anything else?
No, sir.
Thank you. Okay. After you closed the door, sir, how'd you proceed?
Got back in the driver's seat, continued on down to the Claremont County Sheriff's Office. When I pulled into the sheriff's office, I waited a few minutes for another deputy to come out. Once the other deputy came out, we got the defendant out of the back of the cruiser, walked him into the sheriff's office, into the investigative office, and set him down into an interview room.
Okay. And that would have occurred about 1 hour, 8 minutes, and 20 seconds in the State's Exhibit 2B. Is that fair to say you arrive and then the rest happens?
Yes, sir.
Okay. And at that time, was the defendant able to follow your directions?
He was.
You walked him into the sheriff's office?
Yes, sir.
Okay. And did you take him directly to IMV?
I took him straight into IMV where he was set down in an interview room.
Okay. And at that point, sir, did he fight with you? Was he able to follow commands?
He followed all commands. He didn't resist at all.
Thank you, sir. And would that conclude basically your involvement in this investigation, sir?
Yes, sir.
Okay. One moment, please, Your Honor. Thank you, sir. Your Honor, I have no further questions for this witness. Thank you.
Cross-examination.
Thank you, Judge. Morning, David Rudd.
Morning.
Just a couple real quick. Did you have a chance to review these body-worn camera recordings to refresh your recollection for today's testimony?
I did.
And did you do that with the times specific that were specified to you during your direct examination?
Yes, sir.
And I believe you testified at one point in time, you went to the rear of the vehicle and opened the rear hatch. It's an SUV, right? It's not a four-door cruiser.
Correct.
And you went to the rear and had the hatch open, right?
Yes, sir.
And like the Ford Explorer, I think you said it was,
Yes, sir.
hinged at the top. So when it opens, it's, you got that whole wide opening between you and the rear storage compartment of the Ford Explorer.
Yes, sir.
And as you've already described, there is some plexiglass that would be the back seat of that car up to the roof, correct?
Yes, sir.
But also during your direct exam, you said at one point you could hear Mr. Dorman making comments.
As he was yelling, yes.
Well, all and only when he was yelling?
Yeah, when he was talking normally, it was more mumbles. You really couldn't understand much what he said.
Well, you could.
True.
But you knew he was talking.
You could hear him talking.
And have you ever sat in the back of your own cruiser with the
I have.
doors closed, air conditioner running, to see
I have.
what you can hear?
Not to see how much I could hear, but I have sat in the back of those.
It'd be fair to say that many of the questions that you were just asked on direct, talking about the ambient sounds, the other sounds, it's all perhaps a question, what could or could not have been heard from that rear compartment of your SUV.
Sure.
And by the time Deputy Schubert walked by, the window had already been rolled down on the driver's side rear seat.
It was halfway down, yes.
And that's depicted in the video. The judge was able to see that.
Yes.
And it was open when Detective Schubert walked by
What was open?
the window.
Yes.
And Detective Schubert was angry.
Yes.
And he wasn't talking low and polite. He was walking by, firm stride, angry.
I guess.
Well, you repeated already what he said.
Right.
And you don't know, in your own mind, you don't know whether Mr. Boomer heard that or not, do you?
I couldn't say that or not.
I'm sorry.
I couldn't say that or not.
Nothing further, thank you.
Any redirect?
Nothing at this time.
All right, thank you, Deputy, you're excused.
State will call Detective Mike Ross.
I'd feel sorry for him, but I can't. I do feel sorry for this cameraman, though.
Yes, sir.
Good morning, Detective.
Morning.
Can you please state your name and spell your last name for the record?
Yes, Detective Michael Ross, ROSS,
And how are you employed, sir?
with the Claremont County Sheriff's Office.
And how long have you been employed by the Claremont County Sheriff's Office?
About 26 years now.
And what is your current assignment?
I'm assigned as a detective to the investigative unit.
How long have you been in the investigative unit?
Approximately 3 years.
And what are your duties as an investigator with the Claremont County Sheriff's Office?
I investigate crimes against people and property, including things like homicide, robberies, burglaries, rapes, and other minor crimes.
Can you describe for the court the investigative unit? Like how many deputies are assigned to that unit?
Sure. We have 9 detectives. We're a plainclothes unit. We are assigned cases that go above and beyond things that the general patrol could not handle. But because we're only a 9-man unit, when something major occurs, everybody would respond to the scene and assist in some type of way.
And when the entire unit responds to a scene, how do you know what your job is on scene?
Tasks are given to us from a supervisor.
And is there any training required to be both a deputy and specifically an investigator with the Claremont County Sheriff's Office?
Sure, yeah. To be a police officer, obviously you got to be certified through APATA. But as a detective, my training continues every year through EOPATA training and things like that. I've also been to homicide school. I've been to the Reed technique class. I've been to a class called Detecting Deception, and other.
I wondered where you were.
Lots of other trainings and things like that that probably wouldn't be relevant to this.
Okay. And you indicated you've been to the Reed technique class.
Yes.
What is the Reed technique?
The Reed technique is an interview technique or an interview structured interview process where there's some fact analysis, then there's an interview, and then potentially an interrogation. The Reed class was beneficial to me because it also teaches a lot about verbal, nonverbal, and paralingual cues that people might give you while you're interviewing them.
Okay. So you've indicated you've gone to the Reed technique school, interrogation tactics, homicide school, detecting deception, at all of those trainings, are interrogations addressed or one way or the other?
Yes, interview where it's non-confrontational, and then sometimes that leads into an interrogation where you directly confront people.
And during your time as an investigator, how many interviews have you conducted or been a part of?
As a detective, I've been involved in hundreds of interviews. If you include my time on road patrol, it's probably in the thousands.
And pursuant to your experience and training, can you please describe some of the various interview tactics that you have used, both on road patrol and as an investigator?
Sure. Sometimes it's just an interview where I'm collecting, I'm getting information and it ends there. But sometimes that leads into an interrogation where I directly confront people and I'm confrontational. Sometimes I use tactics where I develop rapport with somebody and connect with the suspect so they feel trust and will tell me things that they otherwise wouldn't. Unfortunately, a tactic that works well for me is victim blaming. Sometimes when you blame the victim, that will get them to tell you things that they wouldn't say. I'm trying to think of some other tactics maybe that I might have used, but that's.
Have you heard the phrase "good cop, bad cop"?
Yes, that
No.
is also, if you have multiple detectives available to help in the interview, one of the detectives sometimes will, like I said, connect and develop rapport and be the good cop, so to speak, and then the other detective at the right time will confront the suspect and be the bad cop, so to speak.
And were you still employed as an investigator with the Claremont County Sheriff's Department on or about June 15th of 2023?
Yes.
And at approximately 4 p.m. on that day, did a call come in involving the shooting deaths of 3 children at 1965 Laurel and Dale Road in Richmond?
Yes, I think it was 4:16
At 4:16 p.m.?
p.m., yes.
And where were you when that call came in?
I was at my desk in investigations at the sheriff's office. We have a radio that plays the dispatch communications, and I heard the call go out.
And so what information were you initially made aware of?
Initially, it came out that
Still not
a
being listened to.
grandfather was shooting his family, and then I think they updated that it was a father shooting his family, and then another update was that maybe firefighters or a fire station was getting shot at, but things were coming in very quickly and changing.
And you indicated that as an investigator, normally you are not first on scene. You're not getting that initial dispatch. So when you heard this dispatch, what did you do? What were you thinking?
Well, I'm also a member of the SRT team, and I immediately thought that this could quickly turn into an SRT call out.
What is SRT?
The Special Response Team. It's a multi-jurisdictional team of operators and equipment and things like that.
So what's sometimes described as a SWAT team, for
Yeah,
example?
sorry. In other words, it's a SWAT team. We handle managed situations that the typical road patrol wouldn't be able to handle because they don't have the training and equipment.
And based on what you were hearing from the initial dispatches, what made you think that it might be an SRT or SWAT situation?
Just from my experiences over the years, that an active shooter could quickly turn into a barricaded shooter and could quickly be beyond the capabilities of the responding road units.
So because of your concerns with it potentially turning into an SRT situation and being on duty as an investigator, what did you do?
I responded directly to the scene.
And you responded directly to 1965 Laurel and Dale?
1965 Laurel and Dale, yes.
And what did you find upon your arrival?
When I arrived there, the scene had already been secured with caution tape. There was a perimeter set up. The suspect was already in the back of Deputy Rudd's vehicle. So I did not go inside that perimeter. I stayed at the driveway and the roadway outside the perimeter and waited for Sergeant Crouch to assess what was going on and give me the task that he would give me.
So was this one of those situations where the entire investigative unit was called out and responded to the scene initially?
Yes,
And so when you were waiting outside the perimeter, were you waiting with other investigators?
as they were arriving and other police departments and other deputies, yes, outside the scene though.
And you indicated you waited for further orders from Sergeant Crouch. Would that be the detective sergeant with your investigative unit?
Yes, he's my direct supervisor.
And once you were on scene and Sergeant Crouch arrived, were you tasked with a specific job to do on scene?
I was a couple tasks. My first task was to interview Laura Dorman and Alexis Skeen, who were inside an ambulance.
And did you do that?
I did. And then after that, I went back and let Sergeant Crouch know that I was done. And he asked me to respond to the sheriff's office and interview the suspect.
And at that time, were you aware of who the suspect was?
Yes, Chad Dorman.
And were you aware of his relation to the individuals involved?
Yes, Chad Dorman is the father.
So, Gabby, I'm not sure. I was actually going to ask you if I lost my cursor. I was going to ask you if they had said anything, if they were going to have them go home or stay until they. It just depends on the judge. So, I don't know. I don't have an answer for that. Some judges make them go home. Some judges, if they're close, want them to stay. I just am like, can't believe it's gone this long. But again, I guess I shouldn't be surprised. So, yeah, I was just going to ask you. They haven't said anything. You're staring at a flag. Dang it. And you guys, even if Kayla's the holdup here, why? Because she's not going to be charged. They both, I think, knew. They both, I think, may have been involved. I'm not sure, but I can't. I wouldn't be held up on her if I was sitting in there, but I'm not sitting in there. So, and they didn't ask me to because I don't live there. But I kind of wish I want them to come back today. Tomorrow does not work for me. Just
To
like
the deceased children.
And are you going to stipulate identification?
Yes, stipulated to identification, Mr. Dorman, in this court.
Record will reflect identification of Mr. Dorman.
Thank you. And when tasked with interviewing the defendant, did you immediately respond to the sheriff's office?
I did. I followed Deputy Rudd though.
And so when, as an investigator, are you in a marked cruiser, what we typically think of with the sheriff's emblem, lights on top, things like that?
No, I'm in a black Ford Taurus. It's not marked.
Okay. And so you would not actually transport suspects yourself from scenes?
No, I don't have the capability to transport because there's not a secured area in the back. It's just a regular vehicle.
Okay. And you were aware that the defendant was in custody in Deputy Rudd's vehicle, correct?
Yes.
And you were aware that Deputy Rudd was going to be transporting the defendant to the sheriff's office?
Yes.
So you indicated that you followed Deputy Rudd's vehicle to the sheriff's office?
I did.
Now, as you followed Deputy Rudd's cruiser to the sheriff's office, were any stops made?
He did stop. He made some comments he told dispatch that he needed to stop and readjust the seatbelt because the passenger in the back seat was messing with the seatbelt or doing something with the seatbelt. So he did pull over at the intersection of Lake Hot Cutoff and 222.
And when he pulled over, what did you do?
I pulled over behind him and just was there to assist if he needed any help, but he didn't.
And while you were there to assist, did you observe Deputy Rudd's interactions with the defendant?
Yeah, he opened the door, readjusted the seatbelt on the defendant, and then he got back in his car and continued to the sheriff's office, and I continued to follow.
Did you hear Deputy Rudd ask any questions of the defendant at the time?
He didn't ask him any questions, no.
Did you ask any questions at that time?
I did not.
Now, you kind of already indicated that your unit is a plainclothes unit. What do you mean by plain clothes?
I wear what I'm wearing today, every day. I have a badge and a gun.
So basically, a business casual dress, and you do have your badge on your belt and as well as your gun.
Yes.
Are you always in a suit jacket or?
No, I typically will wear a suit jacket for grand jury or court. My everyday I would take the jacket off and I would be wearing my shirt and tie and dress pants.
So as a plainclothes detective, are you equipped with a body worn camera like your uniformed deputies are?
No, I do not wear a body camera.
Now, were you able to follow Deputy Rudd's vehicle all the way to the sheriff's office?
I did.
And when you arrived at the sheriff's office, where did you go?
I parked where I typically park, where the detectives park. Deputy Rudd stopped at the back door entrance where they typically will bring people in for an interview. So I parked in a different area, and I went ahead inside to the sheriff's office to prepare myself for the interview and to prepare the interview room for the interview.
Okay. And when you say you were going to prepare the interview room for the interview, what do you mean?
Well, I needed to activate the DVR recorder and timestamp it. And then again, just start mentally preparing myself, things that I wanted to ask and do, and prepare myself for the interview.
And since you went inside to prepare the interview room, let me ask you this. Is it typical to have only one deputy escort a suspect into the sheriff's office for an interview, especially on a case of this magnitude?
It would only be typical for one deputy if it was a minor crime, but because of the seriousness of this, I know that Deputy Rudd, Deputy Early assisted Deputy Rudd in walking Chad Dorman back into investigations because, like I said, the seriousness of this offense. I teach self-defense tactics for the sheriff's office, so I teach that when you have multiple officers, that would give them a tactical advantage if Mr. Dorman wanted to fight, flee, or hurt himself. For other reasons too, multiple officers would potentially de-escalate any problem before it even happens because there's multiple officers there and there's only one suspect. Or having multiple officers there could also, if there was an issue where he wanted to fight, flee, or hurt himself, they could resolve that threat or that issue using less lethal force than maybe where it might escalate to a lethal encounter if it was just one officer, one suspect. So there was a lot of reasons why that was a good idea.
Okay. And to your knowledge, did either Deputy Rudd or Deputy Early ask the defendant any questions as they escorted him into the sheriff's office and ultimately the interview room?
They did not.
And was the defendant taken any place in the sheriff's office other than into the interview room?
He was escorted directly into the interview room, which is inside investigations.
Can you describe the interview room that is inside investigations at the sheriff's office?
Yes, it's just a small 10 by 10 square room. It's got gray walls, a small desk inside it, 3 chairs. There's a fake thermostat on the wall with a camera inside it that audio and video records everything.
And so when you indicated previously that you prepared the interview room, turned on the DVR, time-stamped it, that kind of thing, is that turning on the audio and video recording that is recorded from that thermostat?
Yes.
Okay. And was the entirety of your interview recorded?
Yes.
Okay. And for the record, the interview has previously been admitted as State's Exhibit 4A and 4B. Detective, when you interview suspects on major felonies, do you ever work with another detective?
All right, for you guys worried about this guy, don't you think it might be possible? I had a friend, she's blonde like this guy is, and she would get really red. She'd get very embarrassed, or if she was uncomfortable, break out and splotchy. Do you not think maybe that's his problem? I don't want his head to pop off because you guys all think his blood pressure is super high. That would be weird and gross. And I don't want to see it. Do you think maybe it's nerves? Maybe? Yes, court ends at 4. So hopefully we'll get an update and then we can plan accordingly from there.
During the interview process.
Yeah, sometimes I do, and especially when it's a major crime, I work with other detectives during the interview.
Is there a typical detective that you will work with?
I would say that I typically would work with Detective Schubert because we do work well together, and we've had a lot of success together as interviewing together.
And did Detective Schubert ultimately take place in the interview of the defendant in this case?
Yes, he did.
Were there any other detectives involved in the interview of the defendant?
Yes, I initially started the interview with Detective Green, but then later switched him out for Detective Schubert.
And Detective Green, that's Green?
Yes.
And when you work with other detectives while interviewing, do the two of you have specific roles that you take during the interview?
Yes. So depending on who's the primary person in the interview, the primary person would be the one to ask the questions and be the main contact with the suspect. And then the other detective's role and responsibilities would be to take notes and pick up on things, that inconsistencies maybe that they're picking up on and noting and things like that. Also, especially when I interview with Detective Schubert, I'm much better at developing rapport and connecting with suspects. And he does a really good job of feeding off that. And then later, again, at the right time, confronting them about the facts and the inconsistencies and things like that. And then he'll oftentimes exit out of the room and leave us alone. And I would continue the interview.
Now, in this case, was the defendant placed into the interview room prior to you entering to begin the interview?
Yes, he was.
And when he was placed in the interview room, the recording that you had activated, did that continue to run?
It was already on and it continued to run, yes.
And was another deputy in the room with the defendant at that time?
Yes, Deputy Early remained inside the interview room with Mr. Dorman while I continued preparing for the interview.
And while Deputy Early's in with the defendant, do you have a way of monitoring what is occurring inside the interview room?
Yes, we have a TV that shows what's going on in the interview room, and we also have headphones that you can hear what's going on.
So at all times, you can potentially see and hear what's going on in the interview room, even when you are not present in the interview room?
Yes.
And did Deputy Early, to your knowledge, ask any questions of the defendant while he was in the interview room before you entered?
He didn't ask him any questions.
So when you first entered the interview room with the defendant, what did you do?
I put a bottle of water on the table and told him it was for him. I introduced myself. I said that I wanted to talk to him if that was okay, but there was some things that I needed to do first.
Did he respond?
He did. He said, "That's fine."
What did you take that to mean?
That he wanted to talk to me.
And did you then step out of the interview room?
I did. I went back out of the interview room and I continued preparing myself for the interview.
And at that point, was the defendant left alone in the interview room?
Well, he was in there with Deputy Early.
And so what were you doing at that point when you left the interview room?
I was gathering as much information as I could find about Chad Dorman. I was searching Oleg. I was searching Clear. I was searching social media. I was reading prior reports in RMS, which is our reporting system. I was pulling up his criminal history. Anything that I could find about Chad Dorman, I was researching, doing background on him.
So you indicated you were searching Oleg. What is Oleg?
Oleg is a tool available to law enforcement that offers us lots of information and data about people. It stands for Ohio Law Enforcement Gateway. It's run by the AG's office in BCI, but again, it's just a database. It's a tool that is available to us as a detective.
And you also indicated that you searched Clear. What is Clear?
Clear is another tool that's available to law enforcement and detectives. Again, it's a database, but Clear is going to be more like public records data, things like that that's available.
And then you searched RMS, which you already indicated is the sheriff's office in-house record keeping system. Is that fair to
Yeah,
say?
yes, prior reports and things like that.
And so during that time frame, what, if anything, of significance did you find?
I learned that Chad Dorman had numerous contacts with the sheriff's office dating back 16 years. He had arrests in 2008, 2009, 2010, where Miranda was read to him. He had a contact in 2012 where there was some type of dispute with family, and somebody named Ruby Franklin was identified as the fiance to his brother Todd Frost. I read that I personally had contact with him in 2015 for an open door that he had called in on Virginia Drive where he lived. And then I think the last one was a contact in 2020, which was another family dispute, fighting type situation.
Okay. And you further indicated that you had searched social media. When you were searching social media, what kind of places were you looking for information?
I went to his Facebook page and I found pictures of his 3 children, and I printed that off for the interview.
Why did you do that?
That's a tactic that I learned in homicide school. When you're investigating or when you're interviewing somebody on a homicide, especially if it's a family or loved one or somebody like that, if you have a picture of the deceased and you put it down on the table next to them, most of the time the suspect will turn it over, which he did.
So once you gathered all the information from those various databases, upon re-entering the interview room, what did you do?
Again, I introduced myself and I moved the cuffs from, he was cuffed in the back, hands behind the back. I moved his cuffs from the back to the front.
Why did you do that?
Again, that's another tactic. That's the very beginning stages of me developing rapport and gaining his trust. It puts him in a position where he's more comfortable. It allowed him to drink the water that I provided to him. But mostly it was to begin that rapport building with him.
And while relocating his cuffs or immediately following, did you ask any questions of the defendant concerning what had occurred at his residence that day?
I didn't ask him about what happened that day, but I did, again, continue that rapport building with him. I focused on my contact with him in 2015. I said he probably didn't remember me, but we had met before, and just kind of described that a little bit to him. But again, I didn't ask him any questions or anything.
And after indicating that you had met the defendant in 2015 and prior to discussing anything that had happened that day, at approximately 39 minutes and 42 seconds into State's Exhibit 4A, what did you do?
I told him that I wanted to keep talking to him, but I had to read this to him real quick. And when I said this, I pointed at my my Miranda card that was sitting on top of my folder.
And what's your Miranda card? Can you describe that?
It's provided to me from the sheriff's office. It's just a little card that has the written Miranda rights on it. On one side, it's the sheriff's emblem, and then on the other side, it's got the Miranda rights on it.
And is that something that's provided to investigators and deputies by the Claremont County Sheriff's Office?
Yes, everybody gets the same one. I've had it since I was a road patrol deputy. I've just held on to it.
And that's previously been admitted and stipulated to State's Exhibit 3, I believe. When you said that, or what was the defendant's reaction when you said that you wanted to talk to him about what happened, but you had to read this to him real quick?
Yeah, immediately he closed his eyes. He started to get upset, almost like he was going to cry. He shook his head up and down like in the yes, affirmative, and with his foot he stomped on the floor.
And what, if anything, did all of that between the affirmative head nod, the crying, and the stomp, what did that indicate to you?
Well, that told me that that he knew what happened that day, and that's exactly what I wanted to talk to him about.
And did you, in fact, then read the defendant his Miranda warnings?
I did.
And how did you do that?
I didn't hear you well.
Sorry. How did you do that?
I read him, I read it from the Miranda rights card. I read his warnings from the card that I had.
And what was the defendant's response when you asked him, or let me ask you this, when you finished reading the Miranda warning card, did you ask him anything?
Yeah, I always follow up with it. Did you understand? But before I could even say that, he said, yep. And then I said, do you understand? And he said, mm-hmm. And he shook his head, yes.
Okay, so before you finished, he said, yep. Then you followed up with, do you understand those rights? And he said, mm-hmm.
Mm-hmm. As he's shaking his head, yes. So lots of things there, verbal, nonverbal. He absolutely understood those rights that I had just read to him.
So based on his statements and nonverbal cues, you took that to mean that he understood his rights that you had read to him?
Absolutely, he understood those.
Did the defendant indicate in any manner at that point that he was confused about what you read to him and what his rights were?
No.
Did the defendant ask you any questions about what you had read to him or what his rights were?
No.
So at that point, did you begin the interview?
I did.
And what kind of questions did you begin the interview asking?
As with all my interviews, I typically like to start off with just some basic background things like that, easy questions leading up to what happened that day. But so I just started talking to him, asking him questions about if he was his wife and things like that.
And when you asked about his wife, did he answer that question?
He did eventually, not right away. He looked like he was thinking about things, or appeared to me like he was reliving what had happened that day. And I kept having to refocus him back towards me. But eventually he did say that his wife was Laura.
And did you ask him about how many times he's been married?
I did. I kind of followed up with the Laura as his wife and asked if he had been married before. But again, he seemed like he started thinking about other things and was drifting off. So he didn't answer how many times he had been married.
So to bring him back, did you ask him another question?
Yeah, I just started asking him some, basic background questions, other questions. Asked if he needed any prescription medications. He said no. I asked if he was feeling okay, how he was feeling, and he said that he was feeling good.
Did you ask him his date of birth?
I did ask him, what's your date of birth? Another basic question. And he told me 3/1 of 91, so that would have made him 32 years old.
And based on your research that you had conducted prior to the interview, was that an accurate date of birth?
Yeah, that was actually his date of birth. Yes.
And so after asking his date of birth, whether he needed any medication, how he was feeling, did you then get into what had happened that day?
Yeah, then I asked him to tell me, what happened that day. What happened?
And how did he respond?
He told me that he didn't know, and he didn't even know why he was there.
And did you anticipate that kind of response?
I did. I figured that that's where this was going to start.
Why?
Oftentimes in other investigations, the I don't know card is played a lot with suspects.
So when the defendant began to act like he had no idea why he was there or why he was talking to you, what did you do?
So then I backed up and I started asking just some simple questions that I figured he would know the answer to. Easy questions like what day it was. He said it was Thursday, which it was. I asked him if he knew what the date was, but he kind of struggled on that. But honestly, I didn't know without looking at my phone either. Oftentimes I have to look at my phone to know the date, so I didn't put a whole lot of stock into the fact he didn't know the date.
And did you continue talking to him?
Yeah, just continued asking, just some basic questions about if he needed some water, what he ate, did he sleep, and then it kind of led into, I was asking him about how he was feeling and things like that.
And when you asked about how he was feeling, what was his response?
I remember asking him if he was upset, and he said no, he wasn't upset. And then I kind of explored that a little bit because I was curious, like emotionally, where he was at. So I kind of followed up on, why are you not upset and things like that.
And as you question him further about what had happened that day and how he was feeling, at approximately 45 minutes, 45 seconds into Exhibit 4A, what, if anything, did he say about a lawyer?
Well, I feel like we were talking about, his emotions and how he was feeling, and he made some comments about, not what happened that day, but just made some comments that I thought were very important, and I was kind of exploring that. And then he did, yes, make a comment about a lawyer. He said, he cut me off. I was asking him specifically about what he had just said that I thought was very important.
So let's go back to that first then. You indicated you were talking to him and he made comments that you thought were important. What were those comments?
He had made a comment that the Bible says that you kill your firstborn, you kill your secondborn, you kill your thirdborn, but first you're supposed to kill your wife. I didn't kill my wife. So I really thought that was a very important comment that he had just made. And I wanted him to repeat to me some of the things that he had said. And I was asking him about that, and he cut me off. He stopped me from talking and said, in all one sentence, he says, I'll just wait for a lawyer. I really don't know. Like, give me a couple days. I'll talk to a lawyer and get nice, good answers. He says that all in basically one breath.
So when he said, I'll just wait for a lawyer, I don't know, give me a couple days, let me talk to a lawyer and I can get some nice, good answers for you. What did you think of that?
I didn't know. I was confused because initially he says that he'll wait, but then he covers it up with he really didn't know. So if he didn't know, I don't know what he means by it. And then he continues on almost and talks about almost like I'm going to let him go for a couple days, which obviously was not going to happen. So it really muddied the water for me as far as what he had just said about a lawyer.
So did you attempt at that point to clarify what the heck he's talking about?
I felt obligated to explore it a little bit, yes. So I did. I asked him if he had a lawyer.
And what did he indicate to you?
He said, we have family lawyers.
And did you follow up on that?
Yeah, again, I felt like pulling teeth. I'm trying to get him to talk about it. Tell me, who's your lawyer? So I asked him if there was somebody we could call. And he said, Keith Thorben and Ruby Franklin.
And did he give you any information about those two individuals?
Yes, I followed up with them. Keith Thorman is his father, and neither one of those people are attorneys.
So he was able to tell you Keith Thorben is his dad. What did he say about Ruby Franklin?
He said that she was in the CIA, and I said, well, is she a lawyer in the CIA? And he said, she's in the CIA. So neither name that he gave me were even close to lawyers.
And after that, so you were able to confirm that neither Keith Thorman nor Ruby Franklin were lawyers, and that he was aware they were not lawyers.
Correct.
And so once you confirmed that neither Keith Thorman or Ruby Franklin were lawyers, what did the defendant do?
He changes the conversation and starts talking to me about whether he knew me or didn't know me. He changes the conversation. We're talking about lawyers and who I can call, and he completely changes the subject on me to, what I had talked about earlier about knowing him from 2015.
So when he changes the context of the conversation, was that in response to a question you had asked him?
No.
So he just says something along the lines of, I don't think I've ever met you before.
Yeah, he just continues talking about something unrelated to the lawyer issue that I was trying to clarify.
So did he ever clarify for you?
No.
So when he changed the conversation subject, what did you think at that point?
I thought that he was playing games with me and trying to control the interview.
So can you describe the defendant's demeanor as you then continued the interview?
Yes, it continued the same. His demeanor continued to be the same. When I would ask questions that were unrelated to what had happened that day, he knew the answers right away and had lots of details and could remember things. When I asked him about the tough questions about did you shoot your sons, the things that really showed that he had some culpability in that whole situation, he didn't
Yes.
know, and he struggled to answer, and he would rock back and forth in his chair, and just had extreme anxiety about those tough questions.
So was there a very different manner in which he would answer you depending on the topic of the question?
Yes, if it was unrelated to what happened that day, it was very easy for him to answer, and it was very difficult if it was about what happened that day.
And as the interview continued at approximately
Of course I did.
1 hour, 35 minutes, 50 seconds into the interview, did the defendant make another?
Why would I not glitch? Yes, as long as he keeps talking, it's fair. And I'm really just, I know this guy's a piece of crap, so I'm not defending him. It's just, I don't know if you guys have ever watched Steve Gosney on anybody's channel. But he did he's a defense appellate unalive penalty public defender down in Florida. And he was him and another attorney were talking about when you tell the police you want an attorney, that they will, they might get up and walk away, but then they will keep trying to talk to you. Not talking about your case, but they might come, they're going to put you, he said the first thing is probably going to happen is they're going to put you in a room and you're going to sit there for a couple of hours, which this guy did. Again, not in this case am I defending him, because I'm not. But then they'll come back and ask you, are you cold? Do you want a blanket? Do you want some water? Do you want anything to get you talking to them again? And maybe have not even let you contact your attorney yet. So it's all, it's very strange. I don't know much about this case other than what you guys have told me today and just a little blurbs I've caught in the news, or not in the news, because I'll be honest with you, I don't watch the news. Probably what Carmen told me. Okay. But so he could have said, yes, I want an attorney, and they could have, and then kept talking. So if he said, yes, I want an attorney, and then kept talking, he's probably fair game. All right. Did the chat say anything at all? Or did they just freaking end it? Like rude? Okay. Well then, I'd say they're done for the day. That really sucks. At least they could have told us when they were coming back. All right. Now, okay, well, jerks. Because I have a really full, you guys know I'm not home on Thursdays. I will take my stuff with me. I don't think my dad and I have a lot going on tomorrow. So I should be at his house, and I'll just set my stuff up upstairs. I have an appointment at 3. So if they're not back before then, I won't be available if they come back after that until probably around 5:30. Perfect. I was so happy when we went to closing arguments today because I thought it was going to end today. So I'm going to save this. If you guys want to keep watching it, we can. If you don't, we don't have to. Yeah, they usually do say something. Oh. Probably make myself glitch even more. Did you check Law and Crime? Are they done too? No, Alexis, you're fine. I'm not sure when this one's going to go to trial. This is a motions hearing to get his confession, to suppress his confession. He's saying he made it outside of Miranda or after he said he wanted a lawyer or something. I don't know. It's kind of a mess. I hope they don't suppress it. I don't, but I don't know when he's actually going to trial. All right. So, the next trial that we might watch is in jury selection today. I cannot talk anymore. It's been too long. I'm going to look at it tomorrow when I get a chance. And it is that cult leader, what I say, Nature Boy. They did his jury selection today. I'm not exactly sure what his charges are, but it's not on Law and Crime or Court TV. You can. I haven't posted anything on there for a while, but you can go to my Twitter or whatever. It's alternate juror altogether with the number 1 at the end of it. I used to have it. It's linked on my YouTube page, and you can post stuff there. It's getting so full of bots and nobody was going there. And then I forget to go post things on there. So every notification I get is from a woman that I'm like, you're not real and I'm good. Thanks. So, but yeah, if you go to my YouTube page, I tried to link it on Rumble. I might have linked on Rumble. I'm not sure. I don't think I got it to link on Rumble, because it just wouldn't link. I kept putting it in there and it was like, nope. But it's alternate juror number with the number 1 after it all together. But it's on my YouTube page. You can click on it. I will keep this and we can finish this up Friday if you guys want to. Or we can, yeah. Let's plan on finishing. If you guys want to, we can plan on finishing this up Friday. I'll look at that other trial tomorrow, and I will do my best to jump on here if I can. I'm the same way, Stormy. I don't do social media. This is my social media. I don't have Facebook. I jumped off there in 2017. I couldn't take it anymore. And I never had a Twitter until now, and then I'm like horrible at it. Look, okay, so none of you have Twitter. Okay. Well, yeah, I don't have any other place because that's my only place. Yeah. I don't have the answer then, Stormy. Okay, so we can watch the rest of this Friday. I don't know what to tell you about the verdict. I don't have Facebook. I have Twitter, but I don't use it, like I've said 1,000 times. I will keep an eye on it, and like I said, I will try jump on. I will do a stream on it, whether I just upload it and put it up because I want to I want to complete this. So you guys let me know how you want to handle it. If I have to do it hours later, I do not have my space. So I can just, when I get home tomorrow, if they're back, I can just jump on and I can do, I can make a community post and you guys can post on that. If you want me to do that, good idea, Hamilton. And then if I can't do it tomorrow while I'm at my dad's, I'll do it tomorrow when I get home. Even if they've already been back, I'm going to do one. So, all right, you guys, you're going off the freaking rails right now. So let me, I'm going to shut this down before we completely become a really bad train wreck. Worse than what we already are. I'm going to, I have a couple things I need to do first, and then I will jump back on here and put up a community post that will work on YouTube, and then we can use that. And hopefully, I do believe it, but I can't believe they didn't come back with a verdict today. Everything was working out. So, alrighty. Yeah. AOL. You guys are nuts. All right. Well, thank you guys on YouTube, on Rumble, everybody for hanging out with me all day. This is another big, long stream. And we didn't get the finish we were looking for. We were left hanging. So we'll try again tomorrow. You guys have a good night. Be safe. Do something fun. You know, whatever. If you don't want to do anything fun. Well, Gabrielle, I'm sure they're going to come back with a verdict tomorrow, aren't you? But if not, I'll see you Friday at 10:30 a.m. Eastern time, unless something else happens before then. All right, you guys. Enjoy the rest of your evening. Like I said, do something fun, but be safe doing it. Gabby, that's for you. See ya.